The regular course. Compliance is ಮಾಡಿದೀರಾ? ಅದಕ್ಕೆ ಬಂದಿಲ್ಲ. Compliance ಮಾಡಿ ಬರುತ್ತೆ.
Threat notice was issued by the PD. Threat notice for threat of eviction.
Threat notice ಅಂದ್ರೆ ಏನ್? Threat ಅಂದ್ರೆ ಏನು? ಕೊಡಿ.
Auction is fixed for Saturday, my lord, for arrears.
ಕೊಡಿ.
230 lord matter. BBMP proclamation notice.
Proclamation ಎಲ್ಲ ಕೊಟ್ಬಿಡಿ. 230. ಅದೇ ಜಾಸ್ತಿ ಎಲ್ಲ proclamation ಕೊಟ್ಬಿಡಿ. First ಅದು ಹೇಳ್ಬೇಕಾಗಿ. All proclamation please give. Tax proclamation. ಒಂದ್ ನಿಮಿಷ. All proclamation done. ಹೇಳಿ. Yes.
So tax matter. Challenge to Health Security National Security Cess Act 2025. Similar matters are pending in Bangalore, Dharwad, and Kalaburgi. So by special order, all the matters are transferred to Bangalore bench. So files came to here.
ಮಾಡಿದ್ದಾರೆ. ಲಿಸ್ಟ್ ಆಗುತ್ತೆ. ಫೈಲ್ಸ್ ಬಂದಿದೆ. ಮಂಡೇ ಲಿಸ್ಟ್ ಮಾಡಿ. ಮಂಡೇ. ಬಟ್ ಸ್ಪೆಷಲ್ ಆರ್ಡರ್ ಅಂದ್ರೆ ಎಲ್ಲ ಆಗುತ್ತೆ. How many matters are there? How many matters?
The batch have 7 matters, my lords.
7 matters. How long will you take to argue?
The senior counsel we have engaged in this matter.
5 minutes, 10 minutes, 10 hours?
From our side, it may take some 20 to 30 minutes.
ಆಗಲ್ಲ.
There is some urgency. These matters were listed this week before the respective benches. Since the matters transferred here, it not.
Last week, how do we take it up? Hey, Monday list ಮಾಡಿ.
Please.
Fresh matter covered by your lordship on a person order.
ಕೊಡಿ.
Please, my lord.
Fresh matters ಎಲ್ಲ ಕೊಡಿ. ಅದು ಹೇಳಿದಿರ ಸ್ಟೇಟ್ಮೆಂಟ್ ಮಾಡೋಕ್ಕೆ. Date of filing to ಇದು ಬಂದಿಲ್ಲ. Fresh matter 3 days ಅಲ್ಲಿ ಬರಬೇಕು.
Covered matter mala tomorrow.
Fresh matter
ಒಂದು ಫ್ರೆಶ್ ಒಂದು ಪೆಂಡಿಂಗ್ ಕವರ್ಡ್
ರೆಗ್ಯುಲರ್ ಕೋರ್ಸ್
ಕವರ್ಡ್ tomorrow
ಕವರ್ ಮಾಡೋದು ಬೇಡ ಕೊಡಿ.
ಎಲ್ಲ ಕವರ್ಡ್.
Adjournments, list number 1, page number 2, serial number 5 and 6. Page number 3, serial number 7 to 12. Page number 4, serial number 13 and 14.
My lord, serial number 13, my lord. I am for respondent number 5, my lord. Prefer some time. The recent objection.
We informed everybody.
ಅಲ್ಲಿ petitioner ಗೆ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದ್ದೇನೆ.
ಬೇರೆ ಎಲ್ಲ
ಇನ್ಫಾರ್ಮ್
ಮಾಡ್ತೀನಿ ಬೇಡ ಮಾಡ್ಬಿಟ್ಟು ಬನ್ನಿ. Yes.
Page number 5, serial number 15 to 19. Page number 6, serial number 20 to 24. Page number 7, serial number 25 to 30.
Serial number 30. Yes. Have you informed the respondent? Please don't mention if you are not informed. Next.
Page number 8, serial number 31 to 35.
Serial number 33, my lord. Appearing
30?
for petitioner, my lord. Other side inform ಮಾಡಿ.
ಎಲ್ಲರಿಗೂ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದ್ದೀರಾ?
Entry matter may be.
At the request of counsel for the petitioner, relist on 10th March, interim order earlier granted is extended till next date of hearing. Made clear that no further adjournment will be granted. If arguments are not advanced on that date, petition will be liable to be dismissed for non-prosecution.
Page number 9, serial number 36 to 41. Page number 10, serial number 42 to 47. Page number 11, serial number 48. List number 2, page number 6, serial number 37 to 39.
My lord, list number 1, serial number 65, my lord.
Just a
230.
minute. Yes, correct. Has it been?
Your lordship, list 2, serial number 20.
Whatever has been called out only, yes.
Page number 7, serial number 40 and 41.
What's appearing for the respondent number 5, serial number 41.
Yes.
Appearing for respondent number 5. Have you informed the opponent other side?
Have you informed everybody?
Interim orders may be extended and any
At the request of
Tuesday.
why do you want time?
Senior is not well, ma'am.
He is not well. It's submitted, the arguing counsel for respond number 4 is indisposed. She see, hence a submission for an adjournment is made, released on 10th March. Interim order earlier granted is extended till next date.
Page number 8, serial number 42 to 46.
Not 46, second list.
Yes,
And for the respondents, not in all the connected matters,
in
the
all of them.
date were fixed on 23/2. Only because the first matter was, which is linked, subsequently is dated today. Sir, for my request, my lord, is may be taken on 23rd, my lord.
I appear for the petitioner, my lord. I appear.
There's already so many matters. It won't happen on 23rd.
Any other?
Readings are complete?
Pleadings, my lord, I have to only give the list of the occupants which I have made ready, that's all.
How long will it take, the matter
For
for argument?
maybe within half an hour, my lord.
46, at the request of counsel for respond number 2, released on 3rd March.
Appear for petitioner, my lords.
Lord,
Interim order.
interim order may be released.
Extended till next date.
Published.
Page number 9, serial number 47. Page number 11.
Serial number 47, my lord, in which matter, my lord, in previous occasion, your lordship directed to serve the copy N.K. Jagdishwar, my lord.
Mr. Upin is appearing.
Yes, my lord.
You are appearing for Jaglur.
Already today I have served all the petition
All
two
of them.
sets, my lord.
You have formed the layout, so ಏನು ಇಲ್ವಲ್ಲ ಅದ್ರಲ್ಲಿ. ನೀವೇ ಲೇಔಟ್ ಫಾರ್ಮ್ ಮಾಡ್ಬಿಟ್ಟು ನೀವೇ ಇಲ್ಲಿಗಲ್ ಅಂತ
ಕಾಪಿ ಕೊಟ್ಟಿಲ್ಲ
ಇವತ್ತು ಸರ್ವ್ ಮಾಡ್ತಾರೆ.
ಒಂದೂ ಕೊಟ್ಟಿಲ್ಲ.
ಅಲ್ಲ ಇವಾಗ ನಿನ್ನೆ ಮಾತ್ರ ಇವ್ರಿಗೆ ಆರ್ಡರ್ ಆಗಿರೋದು. ಪ್ರೀವಿಯಸ್ ಅಕೇಶನ್ ಆರ್ಡರ್ ಟು
ಎಲ್ಲ ಚೇಂಜ್ ಆಗಿದೆ ಹೆಸರು. Shri Mahesh R. Upin accepts notice for the respondent. Hence, registry is direct print his name as such and appear and remove the name of, delete the name of Shri N.R. Jagdishwara as that appearing for respondent. Counsel for the petitioner submit that the two sets of the petition along with all annexures would be served on the counsel for respond number 5 by end of day today.
Yes, my lord. ಈಗಲೇ ಬಾಕ್ಸ್ ಇದೆ
Counsel for respond number 5 seeks for and is granted a week's time to obtain instruction, make a submission, released on 25th February. You have formed the layout.
It was long back.
You have allotted. Now you are saying it's illegal.
Those things were done by the earlier.
Whoever has done it, it is a, unless you follow due process of law, you can't say earlier counsel did it, now I am going to cancel it. Each time somebody will be cancelling. ಮಾಡಕ್ಕಾಗಲ್ಲ.
In second list 47 also say, my lord, matter may be connected.
Second list ಏನಪ್ಪ ಇವಾಗ 47 no?
First list, I'm sorry, first list 48, my lord.
First list 48 connected.
ಅದು ಕೂಡ ಸೇಮ್. ಅದರಲ್ಲಿ ಇವರಿಗೆ ಆಗ್ಬೇಕು.
Shri Mahesh R. Upin accepts notice for respond number
5, my lord.
5, ಅದರಲ್ಲೂ 5 ಅನ್ನ.
Yes, my lord.
48 connect. Delete the name of Shri N.R. Jagdishwara as that appearing for respond number 5. Interim order earlier granted is extended till next day.
Page number 11, serial number 48 and 49.
My lord, serial number 64 in second list.
64.
64. Additional advocate general is not keeping well. Even we have informed the petitioner counsel. I pray for
64, it is submitted that the additional advocate general is indisposed. Hence, adjournment is sought for relist on 4th March. Yes.
List 1, serial number 65, my lord.
List 165.
Yes, 230 matter. That is with respect to Red and Orange Industries.
Yes.
Officers have sought 10 more days of time. Ella compile ಮಾಡಿದ್ದಾರೆ, they'll be filing it. Final chance.
Lord Counsel for respond number 6 once again seeks for 2 weeks time to comply with the order dated 21/1/25. Relist on 10th March. If compliance is not reported, respond number 6 shall be personally present before this court.
Serial number 30 of list 1.
Serial
Number
30 of list 1.
30.
Yes.
Copy is not served, my lord.
I will serve.
Then no adjournment. Dismiss it.
Your lordship, list to serial number 20.
Give copy.
My lord, I'll serve it today.
30, learned counsel for the petitioner undertakes to furnish 2 sets of the petition along with annexures on the counsel for respond number 2 by end of day today. Learned counsel for respond number 2 seeks for 3 weeks time to obtain instruction, file a statement of objection and or address his arguments. Relist on 16th March.
Lords, list
Your
two,
lordship, list
serial number
two,
53.
serial number 20.
Is 253.
I'm for the petitioner, my lords. Seniors, there's a death in the family, so he's traveling, my lords. After 2 weeks, it may be.
53.
I've informed the other side.
List 2, serial number 53.
Yes, my lords.
It's submitted that there is a bereavement in the family of the arguing counsel. Hence, adjournment is sought for relist on 11th February.
Let's list number 2, my lords.
List 2, serial number 20, your
Just a
lordship.
moment, madam.
Number 27, my lords, list 2.
List 2, serial number 27.
My lords,
Yes.
I'm filing memo for withdrawal, my lords.
Memo for withdrawal. Petitioner is before this court seeking for the following reliefs. Memo is dated so and so has been filed, signed by the counsel for the petitioner
Please, my lords.
and petitioners.
Petitioner.
Which reads as under
Liberty to
accepting
file
said
fresh
memo.
petition, my lords.
Petitioner,
Liberty.
why liberty?
My lords, thing is this, my lords, there's some incorrect facts that is stated, my lords, that needs to be corrected in the petition, my lords. Well, the same thing I've mentioned.
Carry out
in the memo.
amendment. Why a fresh petition?
My lords, it's not a small portion. my
Anyway,
lords.
we are not even issued notice, so fine. Liberty is reserved to file a fresh petition. Yes, madam, VC.
Your lordship, serial number 20, list 2. The arguing counsel's
Serial number?
mother has serial number 20, list 2.
List 2, yes.
Yes, your lordship. Lordship, the arguing counsel's mother has expired, so the matter may be.
Please convey our condolences to him.
Lordship.
Submitted that the bereavement in the family of the arguing counsel for the petitioner. Arguing counsel of the petitioner. Relist on.
Next week, Tuesday or Wednesday, if at all it is possible, your lordship.
Just on 26th. Will he be back by then, or we'll have it in the first week of March?
He will be back by then, your lordship.
Back 26th February.
Much obliged, your lordship.
List number 2, for being spoken to, serial number 1, Bharat Kumar.
I appear for the petitioner in serial number 1, my lords.
It's in the other matter, Allah.
Appearing for serial number 1.1 for petitioner. Your lordship, there is an error in the operative portion of the order.
Yes.
In
What is
serial
the
number
error?
1.1, we prayed for quashing of CC number 26956 of 16
26956.
of ACMM. But in the order, there is a common order passed of
1591, crime number 611.
yeah.
If 611 is quashed, 26596 is also quashed, Alva.
ಅದರ ಇದ್ರಲ್ಲಿ ನಮ್ಮ CC ನಂಬರ್ ಅದು ಬೇರೆ ಕೇಸ್ ಇದೆ.
Consequential, rather. Crime number is quashed.
Please.
Okay.
We have been not
Learned
been
counsel for the matter has been moved for being spoken to. Submission of learned counsel for the petitioner is that there's no reference to the quashing of CC number 26956 of 2016 in the operative portion of the order. The crime number 611 of 2014, from which CC number 26956 of 2016 arises, having been quashed, there would be no particular requirement to pass such an order. But however, since the counsel for the petitioner expresses confusion in regard to the said matter, and considering that the matter is a criminal, the case relates to a criminal issue, the following para is added after Roman 3. In view of the quashing of crime number 611 of 2014, the ensuing proceedings in CC number 26956 of 2016 pending on the file of the first ACMM at Bengaluru also stand quashed. Registry is directed to carry out the necessary correction, issue a fresh certified copy.
Serial number 2, D. Ravindra Prasad.
Lord, pertaining to my lord, lordship, my lord, allow the writ petition. Say that, my lord, based on the conversion condition, my lord, lordship allow. But my lord, what happened, my lord, in respect of survey number 68 is concerned, my lord, 4 acres, 13 guntas has been, my lord. But my lord,
Survey number 68?
68, my lord, 4 acres, 23 guntas.
23 guntas.
The conversion order, my lord, clearly indicates that, my lord, 4 acres, 13 guntas has been converted.
Where the conversion order?
Annexure D.
Annexure?
D.
Page 30.
Next page, my lord, 31. Schedule ಹಾಕಿದ್ದಾರೆ. 68.1, my lord, 2 acres, 7 guntas. Item number 3, my lord.
Annexure?
Annexure D, my lord. D, page number 31, my lord.
ಇಬ್ರು ಹೇಳೋದೆಲ್ಲ ರಾಂಗ್ ನಂಬರ್ಸ್ ಹೇಳ್ತಾ ಇದ್ದೀರಾ?
My lord, there is
page 31.
31, my lord. 68/1, my lord.
68/1.
2 acres 7 guntas.
ಎಕರೆ 7 ಗುಂಟೆ.
ಆಮೇಲೆ 68/2, 2 acres 6 guntas. Totally 4 acres 13 guntas.
This is conversion order.
Please.
Annexure D 1310 to the consequential, first was the change of land use.
Please. But change of land itself, my lord, it is also, my lord, 4 acres 13 guntas, my lord.
So let us see change of land use. Eಷ್ಟಿದೆ?
That is annexure B.
Annexure B.
68 ರಲ್ಲಿ 4 ಎಕರೆ
13 ಗುಂಟೆ.
ಟೋಟಲ್ 68 ಒಂದು ಮಾತ್ರ ಕೊಟ್ಟಿದ್ದಾರೆ ಇದು.
ಹೌದು. ಅದರಲ್ಲೂ 5 ಗುಂಟೆ ಬಿಟ್ಟಿದ್ದಾರೆ, 2 ಅಲ್ಲೂ 5 ಗುಂಟೆ.
68 4 ಎಕರೆ 13 ಗುಂಟೆ. CLU.
Please.
Now it got 4D'd.
Please.
And it became 68/1 and 68/2.
4D'd, please. After 4D'd.
68/1 is 2 acres
7
guntas. 68/2 is 2 acres 6 guntas.
6 guntas.
This is conversion.
Please.
Same bantala 4 acre 13 guntas se bantu.
Please.
Yes. I don't know what is the.
My submission is, my lord, the lordship, my lord, allow the petition and say that, my lord, 10 guntas include and give a plan, my lord. Unless until, my lord, it's change of the land use, because, my lord, we have shown in the earmark as a kharab, in a kharab. They will give application to the, my lord, the 10 guntas is concerned. Because in the year of 2014, my lord, change of land use is, and conversion order, my lord, in the year of 2018.
But though you showed para 6.
Please.
To say that 5 guntas is included.
Yes, that's what
But the
clearly it
final
says.
operative portion of the order is only 2 acres 7 guntas and 2 acres 6 guntas.
Kindly see para 6 minute.
Para 6 ನೋಡಿ ಆಯ್ತು.
Yes.
But
ಈ ಜಮೀನಿಗೆ ಖರಾಬಿನಲ್ಲಿ ಭೂ ಕಂದಾಯ 67ರಂತೆ ಸರ್ಕಾರದ ಉದ್ದೇಶ ಕಾಯ್ಸಿತ್ತು. ಪ್ರಸ್ತುತ ಭೂ ಪರಿವರ್ತನೆ ಒಳಪಟ್ಟಿರುವ 67/1 A ಖರಾಬ್ that 10 guntas is completely mentioned. 6 acre 5 guntas and 68/2 5 guntas ಮಾರುಕಟ್ಟೆ ದರ ಮತ್ತು ಭೂ ಪರಿವರ್ತನಾ ಶುಲ್ಕ both they have collected.
Yes, but the operative portion is only saying 2 acres 7 guntas and 2 acres 6 guntas.
Because it was a kharab, let this converted, therefore that is in the operative portion it is not mentioned.
Then go back and get it corrected.
Your lordship so kindly see.
If you think that there's a correction required, get it corrected. The operative, you did not show us the operative portion, you showed us the.
This is not a reason given in the order improvement.
But if you don't have a conversion,
yes,
there can't be a plan sanction.
The operative portion is.
Not only that,
they are instructing me that I should delete this 5 acre plus 5 guntas and 5 guntas from the plan.
Obviously.
The order.
Obviously it has to be deleted.
The deputy
you don't have a conversion for it.
Yes.
If that land is in between your plan itself cannot be sanctioned.
But the reason is that this 5 guntas and 5 guntas, they have collected and now that has been regularized.
Your operative portion of the order says 2 acres 7 guntas and 2 acres 6 guntas. It does not say 2 acres 7 guntas plus 5 guntas, 2 acres 6 guntas plus 5 guntas.
After
so 10 guntas are not covered.
Together.
Can't be read. Operative portion is what it is.
Which only it only refers to the schedule.
Court judgments will reason out various things. We may say a lot of things.
Yes.
But finally, the operative portion is what counts.
It's only schedule is mentioned.
Sorry. Somebody else would have said misleading. Can't be doing this. The operative portion you did not mention.
Operative portion, I have only referred to para 5. The operative, the only schedule is mentioned.
Matter is being moved for being spoken to by
respondent number 2.
For respondent number 3 and 4.
Please.
His submission is that when the above matter was disposed of on
16th, my lord.
12th February 26. He could not bring to the notice of this court the operative portion of the conversion order dated 13/10/2018 at Annexure D. His submission is that though in para 6 of the said order, it has been mentioned that 5 guntas in survey number 68/1 and 5 guntas in survey number 68/2 being acre have been regularized by collecting the market value. The operative portion indicates that it is only 2 acres 7 guntas in survey number 68/1 and 2 acres 6 guntas in survey number 68/2, which has been converted. And as such, the respondent, who is the planning authority, can only act upon the conversion order, the operative portion of the conversion order.
And also as per the,
For that reason, that the plan which had been submitted by the petitioner had been rejected.
and also, my lord, change of land use also, my lord, 4 acres.
Further submission is that even the change of land use granted much earlier on 2016 is for an extent of 4 acres 13 guntas in survey number 68. Thus, he submits that both the CLU and the conversion being only in respect of 4 acres 13 guntas, it is that extent which could be considered by the respondent planning authority while considering the application submitted by the petitioner. The submissions of the Shri L.M. Chidanand, learned counsel for the petitioner, would however once again still rely on para 6 of the conversion order date 13/10/2018 to contend that once the conversion fine has been received and once market value and conversion fine has been received, it is but required for the respondents to consider the same as converted. Heard Shri L.M. Chidanand, Shri Yogesh Naik, learned counsel for respond number 3 and 4. Shri L.M. Chidanand, learned counsel for respond number petitioner, various papers. Though para 6 of the conversion order refers to receipt of market value in respect of the 5 guntas each of A Karab in survey number 68/1 and survey number 68/2. The fact remains that the operative portion of the conversion order, which has the effect of converting the land, is restricted to 2 acres 7 guntas in survey number 68/1 and 2 acres 6 guntas in survey number 68/2, totally measuring to 4 acres 13 guntas. There is no conversion order granted in respect of the 10 guntas claimed by the petitioner, despite the conversion fine having been paid and conversion fine and market value having been paid. The CLU also reflects that the change of land use order also reflects that the change of land use is in respect of 4 acres 13 guntas. These two documents have been issued by different authorities. The planning authority, respond number 3 and 4, now cannot go beyond those two documents. If at all there is any correction required to be carried out in those documents, petitioner would have to avail of those remedies, get those orders corrected, and then submit it to the respond number 3 and 4 for consideration. In that view of the matter, the order dated 12/2/26 stands recalled. The petition stands dismissed, reserving liberty to the petitioner to approach the appropriate authorities.
Dispose
as
of
indicated
liberty
supra.
to approach the authorities for correction of the.
Liberty is as subject supra and ಹೇಳಿದ್ರು. You do that and then they can consider. If it was at least the same authority, we could have asked them to correct.
Because it is governed by
It's a
other
different
authorities.
authority.
And
They
because,
can't
and
go
because,
beyond what they receive.
because, my lord, we have shown in the earmark as a master plan in the, my lord, same, that is, we can't change, my lord, unless until change of land use.
If there's a mistake which has been committed by the earlier authorities, they'll get it corrected and give it to you. You'll have to correct the master plan. Because what Mr. Chidananda is also saying is right. If they have collected, they should have issued.
Please.
But they have not.
The deputy commissioner is a respondent. If an application is made for rectification of that, this minute, shall consider within some time frame.
If such applications are filed by the petitioner, the concerned respondent is directed to consider the same and pass necessary orders as expeditiously as possible. Please. Yes.
Respond number 2 specific.
As
Respond number 2, I want. Deputy commissioner is a party.
You have to go for CLU first. Get that done. Then come to respond number 2.
That's true.
Don't only go to respond number 2.
Yeah, both
We
have to
we
be
can't
corrected.
advise you on what process you have to follow. Your client will know about what he has to do.
Fresh matters, serial number 3. Karun Ponnappa.
Appearing for respondent in
Mr.
this matter.
Ponnappa.
Pray for short accommodation to take instructions in this matter. my lord.
Lord, Your Lordship, I kindly see that the audacity of the respondent.
Hmm.
There's a, Your Lordship, I kindly turn to annexure A, page 33.
Hmm.
Page 33, my lord. It's a judgment. Page 33.
Hmm.
The operative portion of the suit of the plaintiff is declared in part with cause. Plaintiff are declared as absolute owner of Shell B property. Directed the authority to herein to mutate the kata of Shell B property in favor of the plaintiff by receiving a requisite tax and fees, if any, within 90 days. All this has been done.
You paid the tax.
Yes, everything has been done.
This order was passed on 20, and decree was passed on 29th of August.
Yes.
24.
Yes. And I have, Your Lordship, I kindly say annexure C also. We should have noticed them, but they don't seem to be bothered.
Yes, madam. What instructions do you need?
Lords, there
Who
have
has to
been,
give you instructions?
Lords, ARO CV Raman Nagar.
So you want respondent to be present before us?
No, my lords, only till tomorrow or Monday, my lords.
Can you not
There's
follow
a
the-
parallel proceedings that they have initiated, and also that they have tried to identify the property. Even petitioners are unable to identify their own property.
But there's a decree.
In order to effect this particular order. That's the reason why we are asking for 2 days. time,
Unless you
lords.
challenge the decree,
Not been done.
you are bound by the decree.
My lords, they're unable to identify the property. That's the reason I'm asking for 2 days time, my lords, not
You
more
have
than that.
suffered the decree, madam.
Yeah, I understand, my lords. 2 days.
Is
will
the
obtain.
corporation saying that they won't follow the decree passed by a court?
My lords, they have, and they even went to identify the same property.
The
but
last
they're
respond number 1,
unable-
respond
No,
to
my
be
lords,
present.
it may be taken up tomorrow, my lords.
Tomorrow only we'll ask him to be present.
No, my lords, we'll take instructions and we'll make
Counsel for
submissions.
respondent seeks for a day's time, despite already opportunity having been granted. The grievance of the petitioner is that a decree which had been passed by the civil court on 29th August 24 in OS number 1210 of 2022 has not been complied with,
Monday, my lords.
despite a lapse of more than 1.5 years,
And they've not been filed an appeal against
and
them.
that no appeal having been filed.
Yes.
In that regard, the said decree has attained finality. The counsel for respondent now once again seeks to contend that the property has not been capable of being identified, and it is for that reason that the kata could not be effected in the name of the petitioner. The very same contention had been raised before the trial court in OS number 1210 of 2022, which had been rejected, and a categorical decree passed directing the respondent to do the needful, to effect the kata in the name of the petitioner. Though no particular adjournment is required to be granted, relist on Saturday, 21st.
Lord,
The respondent
Lord,
shall remain,
Can I persuade him?
respondent is respondent commissioner of Yavdu Nimdu.
Can I put-
Which
have it on Monday, my lord, because Saturday I have some personal.
Monday it is unlikely, we already have 150 matters.
Lords,
And now some 8,
Some
10
of them they
matters
come
have
into the
come.
court because I am.
Lords, at least a Passover, my lords.
Saturday, please. Relist on Saturday. Which corporation is it? Northeast, southwest,
This is Baipanhalli.
east.
I have made the commissioner a party, my lord.
You have made BBMP a party.
Sorry,
BBMP doesn't
BBMP
exist.
commissioner.
BBMP doesn't exist now. It's GBA.
But then it was
So which corporation is it? Northeast,
Bangalore East.
east. The concerned commissioner shall file an affidavit in that regard by that date.
Lord, in the meanwhile, can
We
I?
don't want your AROs. We don't want your AEEs.
Lord,
Completely untrustworthy.
can I persuade your lordship to?
Let him file an affidavit, then we'll adjourn it.
Yes.
Serial number 4. Nityananda Care.
My lord, I am filing statement of objection is filed.
Yeah, for,
Copy is not served.
Yes, Nityananda.
Annexure A, in judgment in, they are filing the statement of
Statement.
objection.
Statement of objections. You want to look into it or what do you want?
And even
Urgency, my lord,
notice
because
is
it is-
not served
If you're
for.
ready, you can argue.
Please, my lord.
My lord, it may
And
be
AG
passed.
has filed a statement of objection, the same is taken on record. And AG, yeah, against whose order have you?
Against respondent one.
Respondent number 2. Notice has not given to 3 to
Passed
5.
by- Whose order have you challenged?
Respondent number
Respond
one.
number 1.
One, my lord.
The respond number 1 is state. And AG accepts notice for respond number 1 and 2. ZP Davangere,
Jagdishwar.
NR Jagdishwara for 3, 4 and 5.
5.
Learned AGA has filed a statement of objections
It is
even before service of notice. The same is taken on record. Copy thereof has been served on the counsel for the petitioner. Yes.
Lord, Annexure A has been challenged, my lord. The petitioner is the member of Kuntur Gram Panchayat. And there was a unison resolution by the Panchayat regarding the handing over the new office, old dilapidated office. And it was been, and concerned authorities' permission has been taken. And there was a resolution to demolish the building and to construct a new building, Lord.
Where is the resolution?
Lord. This, page 27 is the type copy, Lord.
27.
Annexure D.
Yes. This is a typed copy. Where's the signature?
Type 27.
Where is the signature page?
So.
Who has signed? How many people have signed?
No, I'm a member.
People
Lord.
attended.
No, this is passed by the some PDO was signed, my lord.
You've given us a typed copy, but we don't know how many councillors had attended.
That that is not the allegation against the member is that he alone demolished the panchayat building without due process of law, my lord. See, my lord.
Clearly.
My contention is there was an recommendations by the PDO stating that he alone demolished the building, even though there was no particular order from the concerned authority. Based on the complaint given the video. My contention is, Miss, I was given the reply to the regional commissioner also. I stated that I have denied the fact because alone I can't demolish because I'm a member of the parliament without consent of the petition. Sorry.
Where is the consent of the council? You'll have to give that resolution.
No, my lord, I am only a member, my lord. I don't have any locus standi to demolish, my lord.
You are denying you demolished.
No, yes, my lord. I'm denying.
You're denying.
Yes, my lord. I'm denying.
Is your contention you did not demolish or you demolished with the consent?
I did not demolish the whole
did not demolish. I hear it.
Now the annexure A is, my lord, an unison order passed without hearing any. There is no proper inquiry, without adducing any material evidence. Only a statement made by the. I'll just read out page 2, my lord. Para 20. Sorry, page 21. To I'll read it from page 20, last para, my lord. ಈ ವರದಿ ಶಿಫಾರಸಿನಂತೆ ನಿಯಮಾನುಸಾರ ಕ್ರಮ ಜರುಗಿಸುವ ಸಂಬಂಧ ಎದುರವರಿಗೆ ಪ್ರಾದೇಶಿಕ ಆಯುಕ್ತರು ವಿಚಾರಣಾ ವರದಿಯ ಪ್ರತಿಯೊಂದು ದಿನಾಂಕ 25/11/2021 ಕಾರಣ ಕೇಳುವ ನೋಟಿಸ್ ಜಾರಿ ಮಾಡಲಾಯಿತು. ಈ ನೋಟಿಸ್ಗೆ ಸದರಿ ದಿನಾಂಕ 10/12/24 ಸಲ್ಲಿಸಿರುವ ಲಿಖಿತ ಹೇಳಿಕೆಯಲ್ಲಿ ಅವರು ವಿರುದ್ಧ ಆಪಾದನೆಯನ್ನು ಅಲ್ಲಗಳೆದಿರುತ್ತಾರೆ. ಅದರಿಂದ ಎದುರುದಾರ ವಿರುದ್ಧ ಆರೋಪ ಸಂಬಂಧಿಸಿ ಸರ್ಕಾರ ಅಪಾರ ಮುಖ್ಯ ಕಾರ್ಯದರ್ಶಿ ಅವರವರ ವಿಚಾರಣೆ ನ್ಯಾಯಾಲಯದಲ್ಲಿ 27/1/22 ನಡೆದ ವಿಚಾರಣಾ ಸಮಯದಲ್ಲಿ ಗೈರು ಹಾಜರಿದ್ದು ಜಿಲ್ಲಾ ಪಂಚಾಯತಿಯ ಉಪ ಕಾರ್ಯದರ್ಶಿ ಹಾಗೂ ತಾಲೂಕು ಪಂಚಾಯತಿ ನೌಕರು ಹಾಗೂ ಸಂಬಂಧಿಸಿದ ಗ್ರಾಮ ಪಂಚಾಯತಿ ಅಭಿವೃದ್ಧಿ ಅಧಿಕಾರಿಯು ಹಾಜರಿದ್ದು ಎದುರುದಾರರ ವಿರುದ್ಧ ಆಪಾದನೆಗಳಿಗೆ ಸಾಬೀತಾಗಿರುವ ವಿಚಾರಣೆ ಸಮಯದಲ್ಲಿ ಹಾಜರಿದ್ದು ಜಿಲ್ಲಾ ಪಂಚಾಯತಿಯ ಉಪ ಕಾರ್ಯದರ್ಶಿ ಹೇಳಿಕೆ ನೀಡಿರುತ್ತಾರೆ. ಮೇಲ್ಕಂಡ ಅಂಶಗಳ ಎದುರಾದರ ವಿರುದ್ಧ ಆರೋಪ ಕುರಿತಂತೆ ವಿಚಾರಣೆ ಸಮಯದಲ್ಲಿ ಜಿಲ್ಲಾ ಪಂಚಾಯತಿ ಉಪ ಕಾರ್ಯದರ್ಶಿ ನೀಡಿರುವ ಹೇಳಿಕೆಗಳು ಹಾಗೂ ಎದುರುದಾರ ವಿರುದ್ಧ ಆಪಾದನೆ ಕುರಿತು ಪ್ರಾದೇಶಿಕ ಆಯುಕ್ತರು ಬೆಂಗಳೂರವರ ವಿಚಾರಣೆ ನಡೆಸಿ ಸಲ್ಲಿಸಿರುವ ವಿಚಾರಣೆ ವರದಿಯಲ್ಲಿ ಅಂಶಗಳನ್ನು ಅಂಗೀಕರಿಸಿ ಶ್ರೀ ಧನಂಜಯ ಬಿನ್ ನಿಂಗಪ್ಪ ಸದಸ್ಯರು ಕುಂದೂರು ಗ್ರಾಮ ಪಂಚಾಯತಿ ಹೊನ್ನಾಳಿ ತಾಲೂಕು ದಾವಣಗೆರೆ ಇವರನ್ನು ಕರ್ನಾಟಕ ಗ್ರಾಮ ಸ್ವರಾಜ್ ಮತ್ತು ಪಂಚಾಯತ್ ಅಧಿನಿಯಮ 43A ಅಡಿ ಕುಂದೂರು ಗ್ರಾಮ ಪಂಚಾಯತ್ ಸದಸ್ಯರನ್ನು ತೆಗೆದುಹಾಕಲು ಸದರಿ ನಿಯಮದ ಪ್ರಕರಣ 43A ರಂದು 6 ವರ್ಷ ಕಾಲ ಚುನಾವಣೆ ನಿಲ್ಲದಂತೆ ಅನರ್ಹಗೊಳಿಸಿ ಆದೇಶದಂತೆ
ವಿಚಾರಣಾ ವರದಿ ಎಲ್ಲಿದೆ? ಎನ್ಕ್ವೈರಿ ರಿಪೋರ್ಟ್.
At page 39 is the recommendations by the 39. Annexure M. Relevant portion. In page 3 Miller.
In page?
In page 3 Miller, page 41.
40.
I'll read it from the page 40. Last paragraph. ಸದರಿ ಪ್ರಕರಣ ಕೇಳುವ ಸೂಚನಾ ಪತ್ರ ದಿನಾಂಕ 29/1/2024 ಲಿಖಿತ ಉತ್ತರ ಸಲ್ಲಿಸುತ್ತಾರೆ. ಸದರಿ ಲಿಖಿತ ಉತ್ತರದಲ್ಲಿ ಸದರಿ ಗ್ರಾಮ ಪಂಚಾಯತ್ ಸದಸ್ಯರ ನ್ಯಾರ ಕಚೇರಿ ನಿರ್ಮಾಣ ಇಚ್ಛೆ ಮೇರೆಗೆ ಅದರಂತೆ ಸಕ್ಷಮ ಪ್ರಾಧಿಕಾರ ಮನವಿ ಸಲ್ಲಿಸಿದ ಮೇರೆಗೆ ಜಿಲ್ಲಾಧಿಕಾರಿಗಳು ದಿನಾಂಕ 31/1/21 ಕುಂದೂರು ಗ್ರಾಮ ಪಂಚಾಯತಿ ನಾಡ ಕಚೇರಿ ನಿರ್ಮಾಣ ಅನುದಾನವನ್ನು ನೀಡುತ್ತಾರೆ ಮತ್ತು ತಹಶೀಲ್ದಾರ್ ಹೊನ್ನಾಳಿ ಜಗಳೂರು ಇವರಿಗೆ ಹೊಸ ನಾಡ ಕಚೇರಿ ನಿರ್ಮಾಣ ಸ್ಥಳ ಗುರುತಿಸಲು ಸರ್ಕಾರಿ ಜಮೀನು ಸಿಕ್ಕಿದಲ್ಲಿ ಹಳೆ ಶಿಥಿಲ ಕಟ್ಟಡಗಳ ಮಾಹಿತಿ ಸಕರಣ ಮತ್ತು ಛಾಯಾಚಿತ್ರಗಳನ್ನು ಸಲ್ಲಿಸುತ್ತಾರೆ. ಅದರಂತೆ ದಿನಾಂಕ ಅದು ಸ್ವಲ್ಪ ಇದಾಗಿದೆ. ಸೊ ಡೇಟ್ ಸಭೆ ನೀಡದಂತೆ ಹಾಲಿ ನಾಡ ಕಚೇರಿ ಇರುವ ಕಟ್ಟಡ ಹೊಸ ಕಟ್ಟಡ ನಾಡ ಕಚೇರಿಯನ್ನು ಕಟ್ಟಡ ನಿರ್ಮಾಣಕ್ಕೆ ನಿರ್ಮಾಣಿಸಿ ಅದರಂತೆ ಪಂಚಾಯತಿ ಅಭಿವೃದ್ಧಿ ಅಧಿಕಾರಿ ಗ್ರಾಮ ಪಂಚಾಯತಿ ಕುದೂರು ಇವರ ಪತ್ರ ರಂತೆ ಕಾರ್ಯನಿರ್ವಾಹಕ ಅಧಿಕಾರಿ ಹೊನ್ನಾಳಿ ಇವರಿಗೆ ಪತ್ರ ಬರುತ್ತಾರೆ. ನಂತರ ಈ ತಾಲೂಕು ಪಂಚಾಯತಿಯಿಂದ ತಹಶೀಲ್ದಾರ್ ಹೊನ್ನಾಳಿ ಇವರಿಗೆ ಪ್ರಸ್ತಾವನೆ ಸಲ್ಲಿಸಿದ್ದು ತಹಶೀಲ್ದಾರ್ ಹೊನ್ನಾಳಿ ಇವರು ಜಿಲ್ಲಾಧಿಕಾರಿಗಳಿಗೆ ಪ್ರಸ್ತಾವನೆ ಸಲ್ಲಿಸುತ್ತಾರೆ. ನಂತರ ಸಹಾಯಕ ಕಾರ್ಯಪಾಲಕ ಅಭಿಯಂತರು ಹೊನ್ನಾಳಿ ಇವರು ತಹಶೀಲ್ದಾರ್ ದಿನಾಂಕ 19/7/2021 ಪತ್ರ ಬರೆದು ಹಳೆಯ ಗ್ರಾಮ ಪಂಚಾಯತಿ ಕಟ್ಟಡವು ಸುಸ್ಥಿತಿಯಲ್ಲಿ ಇರುವುದಿಲ್ಲವೆಂದು ಅದನ್ನು ನೆಲಸಮ ಮಾಡುವೆಂದು ವರದಿ ನೀಡುತ್ತಾರೆ. ಅದರಂತೆ ಹೊನ್ನಾಳಿ ತಹಶೀಲ್ದಾರ್ ಹೊನ್ನಾಳಿ ಹೊಸ ಕಟ್ಟಡ ನಿರ್ಮಿಸಲು ತಿಳಿಸುತ್ತಾರೆ. ಆದರೆ ಗ್ರಾಮ ಪಂಚಾಯತಿ ಸದಸ್ಯರಾಗಿದ್ದು ಎದುರುದಾರರು ಮನಸ್ಸುಪೂರ್ವಕವಾಗಿ ಗ್ರಾಮ ಪಂಚಾಯತಿ ನಿರ್ಣಯವನ್ನು ಬೆಂಬಲಿಸುತ್ತಾರೆ. ಆದರೆ ಗ್ರಾಮ ಪಂಚಾಯತಿ ಕಟ್ಟಡ ನೆಲಸಮದ ಬಗ್ಗೆ ತಮಗೆ ಯಾವುದೇ ಮಾಹಿತಿ ಇಲ್ಲವೆಂದು ತಿಳಿಸುತ್ತಾ ಸಕ್ಷಮ ಪ್ರಾಧಿಕಾರ ಅನುಮತಿ ಇಲ್ಲದೆ JCB ಬಳಸಿ ನೆಲಸಮ ಮಾಡುವ ವಿಚಾರ ಮತ್ತು ಅವರು ಯಾರು ಮಾಡಿದರೆಂದು ವಿಚಾರ ತಿಳಿಯುವುದಿಲ್ಲ ಎಂದು ರಾಜಕೀಯ ದುರುದ್ದೇಶದಿಂದ ವೈಯಕ್ತಿಕ ದ್ವೇಷದಿಂದ ಸದರಿ ಹೆಸರು ಹಾಳು ಮಾಡಲು ಸದರಿ ಅವರ ವಿರುದ್ಧ ಆರೋಪ ಮಾಡುತ್ತಾರೆ ಎಂದು ಸದರಿ ಅವರು ನೀಡುವ ಮಾಹಿತಿಯನ್ನು ಪರಿಗಣಿಸಬೇಕೆಂದು ಪ್ರಶ್ನಿಸುತ್ತಾರೆ. ಅದರಿಂದ ಪ್ರಕರಣ ವಿಚಾರಣೆ ದಿನಾಂಕ ನಿಗದಿಪಡಿಸಿ ನೋಟಿಸ್ ನೀಡಿ 5/8/24 ಮತ್ತು 4/10/2024 ಸಂಬಂಧಿತ ವಿಚಾರಣೆ ನಡೆಯುತ್ತಾರೆ. ದಿನಾಂಕ 5/8/24 ನಡೆದ ವಿಚಾರಣೆ ಎದುರಾರರು ನೋಟಿಸ್ ಜಾರಿಯಾಗಿದ್ದು ಗೈರುಹಾಜರಿರುತ್ತಾರೆ. ಕಾರ್ಯನಿರ್ವಾಹಕ ಅಧಿಕಾರಿ ಹೊನ್ನಾಳಿ ಜಿಲ್ಲಾ ಪಂಚಾಯತಿ ಸಹಾಯ ಕಾರ್ಯದರ್ಶಿ ಮತ್ತು PDO ಅವರು ಹಾಜರಿರುತ್ತಾರೆ. ದಿನಾಂಕ 4/10/2024 ವಿಚಾರಣೆ ಎದುರಾರರು ಸಹಾಯಕ ಕಾರ್ಯದರ್ಶಿ ಜಿಲ್ಲಾ ಪಂಚಾಯತ್ ಸಹ ನಿರ್ದೇಶಕರು ಹೊನ್ನಾಳಿ ಮತ್ತು PDO ಅವರು ಹಾಜರಿರುತ್ತಾರೆ. ಎದುರಾರ ವಿರುದ್ಧ ಗ್ರಾಮ ಪಂಚಾಯತಿ ಹಳೆ ಕಟ್ಟಡವನ್ನು JCB ಬಳಸಿ ನೆಲಸ ಮಾಡುವ ಆರೋಪ. ಸದರಿ ಆರೋಪವನ್ನು ಎದುರಾರರು ತಮ್ಮ ತಪ್ಪೆಂದು ಒಪ್ಪಿಕೊಳ್ಳುತ್ತಾರೆ. ಆದರೆ ಯಾವುದೇ ವಿವರಣೆ ನೀಡುವುದಿಲ್ಲ. ಸದರಿ ಈ ಬಗ್ಗೆ ಹೇಳಿಕೆ
ಒಪ್ಕೊಂಡಿರ್ತಾರೆ.
It is the statement by because however in my reply I categorically denied my lord for the RC and also before the respondent number 1 my lord.
You were not allowed to cross-examine.
No my lord, I was not allowed to cross-examine.
Denied.
ಆಮೇಲೆ record of file
ಇದರಲ್ಲಿ ತಮ್ಮ ತಪ್ಪೆಂದು
ಅಲ್ಲ.
ಒಪ್ಪಿಕೊಂಡಿರುತ್ತಾರೆ.
ರೈಟಿಂಗ್ ಅಲ್ಲಿ ಇದೆಯಾ? ರೈಟಿಂಗ್ ಅಲ್ಲಿ ಇದೆಯಾ?
ಅಲ್ಲ, it is an admitted fact, my lord.
Admitted fact according to you. It has to be in his writing. He has, in writing he has denied it. If you had accepted in writing, you may be right. But if it's denied, then you should give him, he should be able to cross-examine those witnesses who speak against
As
him.
per the findings of the authority, my lord, it is an admitted fact. He has admitted.
Where is the admission? Show us the admission. Though he has given various background facts, he said he was not involved. He was not there at the site when the demolition happened.
Only question arises whether he has demolished it by using JCB or not.
Correct.
In
So
the-
there's nothing which has been referred to in the order. Any photographs itta, yenittu, what is the statement made? If there's an admission, obviously you don't need to do anything. That's what we have held.
Yes.
But if there's no admission, then he should be given an opportunity. We'll set it aside, remand it,
Within 30 days,
give him an opportunity to cross-examine the witnesses who have spoken against him. If the witnesses stand the test of cross-examination, you can pass the order again.
Yes.
If they don't, then it's a wrong order.
is already 8 months over the final order was passed.
ಯಾವಾಗಿಂದ ಪಾರ್ಟ್ ಚಾಲೆಂಜ್ ಮಾಡ್ತಾರೆ ನೀವು 16/6/25 you are challenging now.
Petition was filed on 18/8.
What have you been doing from 18/8? You're coming nearly after 1 year. You have not been a member for that much time out. It's belated. On that ground, you will go.
No, my lord. Allah, but however, the matter was produced pending before this.
A delay and latches
No,
is
but
there.
let the matter will be remanded, my lord.
On delay and latches, how do we allow?
It's delay of 8 months.
8 months delay is there.
Not, however,
Delay.
the order was already operating against him, my lord, from that date.
Correct. We were with you, but this delay defeats it.
I leave it to the lordship.
ಕೈಗೆ ಬಂದಿದ್ದ ಬ್ಯಾಗ್ ಬರ್ಲಿಲ್ಲ ಅಂತ ಹೇಳ್ಬೇಕಷ್ಟೇ.
Let the matter, let the annexure aim be stay, my lord, subject, because now elections are coming, you'll be disqualified for 6 years, my lord. That's the
And that's the only thing.
That is the
playing
only
in our
thing,
mind.
my lord.
Because this is.
No, let the petition be pending, my lord. Let this annexure
6 years disqualification will affect him in the next
Next, my lord.
That
That's
is, though there is a delay. Petitioner is before this court seeking for the following reliefs. The petitioner was elected as a member of the Gram Panchayat Kanduduru, Onnali Taluk, Davangere district on 30/12/2020. An allegation made that the petitioner had demolished the existing Gram Panchayat building. Proceedings were taken up under section 43 of the Karnataka Gram Panchayat and Sons Act. Notice having been issued to the petitioner, petitioner had denied his involvement. However, had explained that the demolition was required on account of the dilapidated status and condition of the said building. An inquiry having been conducted. In the inquiry, the inquiry report indicated that the petitioner has admitted his wrongdoing, and on that basis, the impugned order dated 16/6/25 came to be passed by respondent number 1. It is the Sri Nityananda K.R. Learned Counsel for the petitioner would submit that there is no admission on part of the petitioner, inasmuch as the explanation given by the petitioner was as regard the dilapidated status of the building and the recommendation made by the PDO, recommendation made by
All the authorities, my lord, concerned authorities, my lord, PWD, this.
Recommendation made by the Tahsildar, Panchayat Development Officer for demolition. The demolition was required to be taken up. Grants had also been made by the Deputy Commissioner for the construction of a new building. His submission is that the demolition was carried out by the other officers and not by the petitioner. They said, and on that ground, he submitted that there being no admission on part of the petitioner, the inquiry report indicating that there's an admission on part of the petitioner is completely wrong. On that basis, proceedings could, no orders could be passed under section 43 of the Gram Panchayat Zones Act. learned AGA, who has filed objections, would contend that in the proceedings before, in the inquiry proceedings, the petitioner had admitted the wrongdoing, and as such, the order came to be passed. On inquiry with learned AGA as to whether there is any admission in writing, his submission is that there is nothing in writing except the admission, oral admission made during the inquiry proceedings. Heard Shri Nityananda K.R., learned counsel for the petitioner, Shri learned AGA for respond number 1, peruse papers. The fact of demolition of the building is not in dispute. The question in the matter is who has demolished the building and whether the said demolition is been carried out with due, by following the due process and procedure. The further fact of the building having been dilapidated is also not in dispute. Notice having been issued to the petitioner alleging that the petitioner had caused the demolition. The petitioner had replied on 27/1/24 categorically indicating that he had not caused any demolition. It had been done by the other officers. There being a categorical denial in writing, in the inquiry, it could not have been, the inquiry officer could not have come to a conclusion that there is an admission on part of the petitioner. This admission apparently being oral in nature. If at all, a statement of the petitioner ought to have been recorded at that stage to arrive at such a conclusion. I have, in a similar matter, in so and so held that where there is an admission made, there would not be a requirement of a detailed inquiry to be held requiring cross-examination. It is only an explanation which can be called for in terms of section 43. In the present matter, when there is no admission and in fact there is a denial, as also there is an allegation made that certain other persons, stroke officers, were responsible for the demolition, it is but required for these facts to be established after a complete inquiry, the facts being in dispute. In that view of the matter, I am of the opinion that the considered opinion that the impugned order is required to be set aside and an opportunity provided to the petitioner to cross-examine the witnesses who have spoken against him, as also to lead his own evidence, if he so chooses. In that view of the matter, I pass the following order. Writ petition is partly allowed. The impugned order dated 16/6/25 bearing number so and so passed by respond number 1 is set aside. The matter is remitted to respond number 2.
No, 1 only.
Inquiry was conducted by
the respondent 1 only.
Respond number 2. The matter is remitted to respond number 2 for conducting a fresh inquiry, permitting the petitioner to cross-examine the witnesses stroke complainant who have spoken against the petitioner and permit the petitioner to lead his own evidence, if he so chooses to. The submission of learned counsel for the petitioner is that the petitioner would cross-examine the concerned witnesses stroke complainant on the very next date the matter is posted to, and further that he would not seek for any unnecessary adjournment is placed on record. Since the order is passed in the presence of both the counsels, the petitioner shall appear before respond number 2 without requirement of any further notice at 10:30 a.m. at ಎಷ್ಟೊತ್ತಿಗೆ Mr. Bopanna? 10:30 ಅವ್ರು ಬೇರೆ ಕೆಲಸ ಇರುತ್ತೆ ಆಫ್ಟರ್ನೂನ್ ಯಾವಾಗ when will it
3 o'clock
Bangalore.
3 o'clock at 3 p.m. of on 24th February 2026.
Please.
Serial number 5.
Let it be on next week of 20.
Respondent
ಯಾಕಂದ್ರೆ it is very short date. Today is already 19th.
ಏನ್ ಕ್ರಾಸಿಂಗ್ 1 ವರ್ಷ ಆಗಿದೆ.
Monday Milot on.
Delay we have to dismiss it. You don't ask for.
Please.
Yes.
ಇನ್ನು ಇನ್ಫಾರ್ಮೇಶನ್ ಬಂದಿಲ್ಲ my lordship ಈ matter.
ಏನ್ ಇನ್ಫಾರ್ಮೇಶನ್ ಅಪ್ಪ?
ಏನು ಇನ್ಫಾರ್ಮೇಶನ್
ಏನ್
ಕೊಟ್ಟಿಲ್ಲ.
pass ಇದು?
My lord, annexure A
Order
to
sheet
K
ಕೊಡಿ.
was issued, my lord, assessment order, then my lord, demand notice and the order and demand notice, my lord, without hearing me, my lord, without any inspection, my lord. I've been paying the taxes, my lord, regularly. The taxes, my lord, at page number 117, all tax receipts are paid. My lord, even this year also, my lord, I paid the tax. Almost, my lord,
You're challenging the show cause notice, demand notice?
and order, my lord. These all notices, my lord, issued me on one day, 4/8/2025.
Yes.
All the three notices were issued for the year 2021, 2021 to 23-24.
Within 5 years.
Yeah, though I'm paying the taxes regularly.
Hmm.
So they have been said that, my lord, assessment is not proper, which is, they have not conducted any inquiry, my lord, or show cause not required under law.
Where your tax paid receipts?
Tax paid receipts, my lord, can see at page number 121, 121, 122, I'm sorry, 119 onwards, my lord. Annexure A series, 117 onwards.
117.
17 onwards. 117, my lord, for the year 2020-21. 3,54,924 I pay. 21-22, my lord, again.
What
3
is the
lakh
extent of the property?
property, my lord, around.
And anyway, this is generated by the computer, so
Yes.
whatever is generated, you have to pay. 2021, 22, 23.
Up to
24,
2025, 26 also paid.
25,
Taxes have-
26 also paid.
Yes,
Yes, now what is the order?
impugned order, my lord, they say that, my lord, I'll have to pay for the year 2020-21. I have default, I have not, under self-assessment. They say I need to pay an amount of rupees 13,428.
Page
Then
number?
21,
Page number?
page number, my lord, annexure A is at page number 44, my lord. The order, my lord, at annexure C, page number 48. That is for the 1 year. Then again, my lord, annexure D, my lord, 21-22. That order, my lords, can see at page number 50. No inquiry was conducted, my lord, because whether
The reason is that it's tenanted.
it's not, it's owned by me, my lord. Produce the document, my lord. It's ambient hospital.
No, in this order,
Yeah, they say it
as
is
per
tenanted.
return filed self,
Yes.
the only thing difference that we see is that it's saying tenanted, and as per that, the calculation has been made.
It is not
And
tenanted.
non-residential building not equipped with central AC, non-resident be used as hotel or restaurant. So you are not in category 5, you are in category 7.
Yes, ma'am.
You are running a restaurant.
Hotel and restaurant, ma'am.
You'll be in 7,
Yes, ma'am.
a separate category.
Yes, ma'am.
Tenanted may be a dispute,
Yes,
but category what you had mentioned in your essay is at 5
yes, ma'am.
is not correct.
Not.
It should be category 7. Category 5 will it comes to that. So your computation is wrong anta avaru ಹೇಳ್ತಾ ಇರೋದು. You paid, but computation is wrong.
My lord, earlier occasion also paying the same tax, my lord. They have been
Correct.
accepting the tax.
Because they'll accept it because you put category 5. It automatically calculates.
No, non-residential building, my lord, I have put as non-residential building.
You are running a hotel,
Hotel, yes, my lord.
there's a separate category.
Yes.
You have to pay.
My lord, there should be an inquiry, my lord, what's required under law, my lord. At the end of the day, my lord, if at all I am liable to pay any additional tax, my lord, they should conduct an inquiry, my lord, under section
Your
144.
admission is clear. There's no inquiry. You are admitting that you are running a hotel.
They'll have
Indian
to-
inquiry ಬೇಕು.
But the,
When you denied ಬೇಕಾಗತ್ತೆ. When you admitted, where's the inquiry?
but the assessment itself is wrong, my lord. I'm not liable to pay that much of tax, my lord.
This is all mathematical now.
So therefore, my lord.
Category 7 ಇಷ್ಟು amount 20 rupees a square foot ಅಷ್ಟೇ.
So therefore, my lord, my submission, my lord, there should be an
If
inquiry,
you-
my lord,
if
system,
you want-
whatever.
If you want time to pay, we can tell them. Otherwise, no, get instructions from your client.
Whatever this tax, my lord, reflected in the system, I'm paying diligently, my lord.
Because you have put 5 as a category, when you belong to category 7.
Even if
Your
it is
client has input a wrong category.
non-residential, my lord.
It's
Even if it is-
non-residential, fine. But there's separate category, you are a non-residential,
Yes, ma'am.
ನಿಮ್ಮ ಆಫೀಸ್ ಅಂದ್ರೆ ನಾನ್ ರೆಸಿಡೆನ್ಷಿಯಲ್ ಮಾಡಬಹುದು.
ಹೌದು.
But if you are running a restaurant, it will come under category 7. If it's a theater, it comes under category 11. There's separate specialized categories for that. Call, get instructions.
Yes, ma'am.
That counsel for respondent seeks for and is granted a week's time to obtain instruction. So does counsel for the petitioner. More particularly as regards the category that had been input by the petitioner while making payment or while carrying out self-assessment under the self-assessment scheme, whether the input was in terms of category 5 or category 7. Since it is category 7, which applies to the petitioner who admittedly carries out business of hotel and restaurant, released on 26th. I1 of 26 is allowed.
Serial number 6.
Appear for the petition.
Yes.
I am the owner of the land, my lord. Road has been formed in my land, my lord, without paying compensation. That is, my request for payment of compensation is rejected.
This is getting to be a.
On the ground that, my lord, a conversion order provides for leaving the certain space for road margin. My lord, I am entitled for compensation.
We are getting too many matters of this kind.
What happens, Manoj, the deputy commissioner instructs the chief officers.
You can't do it on instructions. You have to follow the law. You can't. They'll walk into the deputy commissioner's office and like the table and take it. Beka. Rule by law. If you want the land to do it, acquire it, pay them the compensation. They may even agree.
Yes, ma'am. We will agree, ma'am. We have made a representation.
Is agreeable. Pay the compensation. See, then Naveen accepts notice for
1 and 3.
1 and 3. And AGA for respond number 2 and 4. The grievance of the petitioner is that without acquiring the land of the petitioner, the said land has been used for formation or widening.
No, road has been formed.
For formation of a new road. And no compensation has been paid to the petitioner. J. Naveen seeks for and is granted a week's time to obtain instruction, make a submission as to on what basis the land of the petitioner had been used for such purpose. The fourth respondent is also directed to look into the matter, since there are many of these cases which are coming up before this court, where land of a citizen is being used for either formation of a road or widening of an existing road without acquisition and payment of compensation. An affidavit in that regard to be filed by next date, released on 26th February.
Let him serve a copy.
Please give him 2 copies.
Serial number 7. Ravanesh Lopre.
Mandamus to consider my application of annexure for issuance of e-kata.
E-kata. Where is the earlier kata?
The kata earlier was issued on the form number 7 and 9.
Form number 11.
Yes, madam. It was a panchayat area. Subsequently, the VBMP has taken over that. The kata issued is at annexure H, my lord. Page number 47.
Consider it. The BS Karthikeyan accepts notice for respondent number 1 to 5. Petitioner is before this court seeking for the following leaves. condition of the learned counsel for the petitioner is that in respect of the property of the petitioner bearing survey number 29 and 47, site number
Sites.
29 and 47,
Site number.
formed in survey number 15/3, kata had been issued by the Gram Panchayat. Thereafter, on the property coming within the jurisdiction of the BBMP, an application having been made for grant of e-kata, followed up with a representation on 30/10/2025 at Annexure A, the same have not been considered. Whenever an application for issuance of kata, bracket e-kata, is made, it is required for the respondents to consider the same within the time prescribed under Sakala so and so, and either accept or reject the said application stroke representation. Needless to say, in either case, the order needs to be accompanied by reasons. In the present matter, neither having been done, I pass the following order. Writ petition allowed, a mandamus is issued. Respondent number 2 is directed to consider the application and the representation of the petitioner dated 30/10/25 at Annexure A in terms of the time period prescribed in the Sakala so and so.
In accordance with law. In accordance with law.
Obviously,
Please.
we have said accept or reject, pass reasoned order.
Agree.
You can't sit on this.
Yes.
Serial number 8, Pawan Shyam.
Yes.
Lords, there has been an unauthorized and illegal construction by the respondent, even after giving sufficient.
How is your construction?
Lords, it's a vacant property.
We are
yet to begin construction. Lords, they have encroached 100 to 150 feet towards our property. There's approved plan.
Where is the property?
Lords, just adjacent to their property.
Where is the construction being carried out?
We are yet to begin construction, Lords.
The respondent is carrying out construction 5. In which property?
No, my lord, they have completed their construction and they have conducting their PG, paying guest. They have only sought permission for 2 floors. There are 5 floors which are operating. Lords.
Which property is that?
At Annexure B1, my lord,
Property
State
number ಏನಪ್ಪಾ?
Property number. 689/804. Kata number 689/804.
804 4th Main Vayalikawal HSBS.
Yes, my lord.
Which is your property?
Ours is 78/7.
Where is the document for that? 78/7 is a completely different property.
No, it's just adjacent, the vacant.
How do you make out it is adjacent? Where is your property?
Lords, may kindly pass it over. I'll produce the.
Pass over. Only if you are a neighbor, we'll entertain.
Please.
Otherwise, you will have to go as a PIL.
Please, my lords.
With that, as it may be, all the PGs we have directed you to,
Yes, ma'am.
all this will come under that.
Grateful, my lords.
Serial number 9, Puttaraja CP.
Dismiss Puttraju.
My lord, it's a settlement of professional fee from the corporation, my lord. From the past 4 years, they have not settled my professional fee, even representation after representation. Your lordship may kindly see. Dated.
After disposal of the case, they did not produce the certified copies, my lordship. That is only, as per norms fees will consideration, my lordship.
Certified copy kotre, you'll make the payment?
Some of they have produced, some have not produced, my lordship.
Yaudal produce madilla.
They himself only admitted that, my lordship.
Which one do you want now?
My lordship, here in the page number 24, my lordship.
Why do you require certified copies?
After disposing the case, my lordship, they have to submit a certified copy. And also with consideration according to the fees norms, my lordship. Here is what happened, my lordship. They have produced, they have says that 1,000 rupees miscellaneous petition, my lordship. They have to produce the sum of such documents, my lordship. That is not a fees norms, my lordship. If you consideration, will consideration, my lordship, according
They can give you a printout from the website
Yes, my lordship.
or certified copy ne beka.
No. They have sent to the upsells, my lordship.
We are asking
That
you.
is enough, my lordship.
If they give you a printout from the official website, that's enough.
That's enough, my lordship.
What pidi aurge?
ಕೊಟ್ಟಿದೆ ಸ್ವಾಮಿ, ಎಲ್ಲ ಕೊಟ್ಟಿದೆ. Your Lordship
ಅಕ್ನಾಲಜ್ಮೆಂಟ್ ಎಲ್ಲಿದೆ?
ಎಲ್ಲ ಅಕ್ನಾಲಜ್ಮೆಂಟ್ ಇಲ್ಲಿ 3 ಡಿಪಾರ್ಟ್ಮೆಂಟ್ಗೂ ಕೊಟ್ಟಿದೆ.
ಅಕ್ನಾಲಜ್ಮೆಂಟ್ ತೋರಿಸಿ ಅವರು ಕೊಟ್ಟಿರೋದು.
ಕೊಟ್ಟಿದ್ದೀವಿ. Your Lordship ಅಲ್ಲಿ CD page 25 ಎಲ್ಲ ಡೀಟೇಲ್ಸ್ ಎಲ್ಲ ಕೊಟ್ಟಿದೆ. ಮತ್ತೆ page 26
ಫೈಲ್ಸ್ ರಿಟರ್ನ್ಡ್ ಅದು ನೋಟಿಸ್. ಅಕ್ನಾಲಜ್ಮೆಂಟ್ ಎಲ್ಲಿದೆ ಮಿಸ್ಟರ್ ಪುಟ್ಟರಾಜು? ಇನ್ನೊಂದು ಕೊಡಿ, ಸರ್ಟಿಫೈಡ್ ಕಾಪಿ ಅಂತಾನೆ ಬೇಡ, ಅದು ಬಹಳ ಲೇಟ್ ಆಗತ್ತೆ. ವೆಬ್ಸೈಟ್ಗೆ ಹೋಗಿ ಪ್ರಿಂಟ್ಔಟ್ ತಗೊಳ್ಳಿ, ನೀವು ಸೆಲ್ಫ್ ಅಟೆಸ್ಟ್ ಮಾಡಿ ಕೊಡಿ.
ಎಲ್ಲ 4 years ಇಂದ ಬರೀ ಇದೇ ಚಾರ್ಜ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ.
ಅಕ್ನಾಲಜ್ಮೆಂಟ್ ಇವಾಗಲೇ ತೋರಿಸಿ ಅವ್ರು ಡೈರೆಕ್ಟ್ ಮಾಡ್ತೀವಿ.
Your Lordship may kindly see page 28 28-25 ಲೆಟರ್ ಬರೆದ್ರು ನೋ ರೆಸ್ಪಾನ್ಸ್ ಟಿಲ್ ಡೇಟ್.
ನೀವು 20 ಲೆಟರ್ ಬರೆದ್ರೇನು ಏನು ಯೂಸ್ ಇಲ್ಲ. ಅವ್ರು ಹೇಳ್ತಾರೆ ಕಾಪಿ ಕೊಟ್ಟಿಲ್ಲ, ಕಾಪಿ ಕೊಡಿ
ಎಲ್ಲ
ಅಂತ.
ಕೊಟ್ಟಿದೆ ಸ್ವಾಮಿ, ಇಲ್ಲೆಲ್ಲ ಅಕ್ನಾಲಜ್ಮೆಂಟ್ಗಳಿದೆ.
ಎಲ್ಲಿದೆ ತೋರಿಸಿ. ಇಲ್ಲಿ ಒಂದೂ ಅಕ್ನಾಲಜ್ಮೆಂಟ್ ಕಾಣಿಸ್ತಾ ಇಲ್ಲ. ರಿಟರ್ನ್ ಫೈಲ್ಸ್ ಇದೆ ಅಷ್ಟೇ.
ಅಕ್ನಾಲಜ್ಮೆಂಟ್ ಸರ್ಟಿಫೈಡ್ ಕಾಪಿ ಇದು ನೋಡಿ ಸ್ವಾಮಿ, ಅದು 22 ಪೇಜ್.
Please find enclosed certified copies of so and so ಅಂತ ಎಲ್ಲಿದೆ?
ಎಲ್ಲ ಕೊಟ್ಟಿದೆ. Even no objection. Your Lordship may kindly see page 25.
Bategoda KV accepts notice for respondent 1-2. Petitioner is before this court seeking for the following reliefs. The grievance of the petitioner is that the petitioner, being a lawyer engaged by the respondents to represent the respondents in various cases, had submitted his bills which have not been paid, despite a lapse of more than
4 years.
4 years. Submission of Shri K.V. Bategoda on instructions is that the certified copies of the judgments and or orders passed in the matters as regards which bills have been raised have not been furnished, and as such the bills could not be processed. If the said certified copies are furnished, his submission is that the bills would be processed and payments would be made within 30 days of the documents being furnished. Third, Shri Puttraju CP Learned Counsel for the petitioner and Shri Bategoda KV Learned Counsel for the respondent. The only issue in the present matter is as regard the furnishing of the certified copies by a panel counsel to the BBMP who had engaged him. In today's day and age, when all the judgments and orders are uploaded onto the website of the High Court, as also on the website of the district courts, and the considered opinion that there would be no purpose served by requiring the counsel to furnish certified copy, since a printout of the said orders and judgments could be furnished with self-attestation as a true copy. In the event of respondents having any doubt about the said order, the QR code available on the said judgment could be scanned and verification made by the concerned officer. In that view of the matter, reserving liberty to the petitioner to furnish printouts of the downloaded copy of the orders stroke judgments self-certified by the petitioner, the petition stands disposed, directing the respondents to consider the bills submitted by the petitioner and pass necessary orders within 30 days of such submission of the certified of the printout self-attested printouts.
Serial number 10. Kruti C.
The PDA BBMP tax matter, my lord. This was one of the matters in which notice had not been issued. Serial number 44 in list 2 and serial number 1 in list 1 are all connected to the same matter.
So you want us to take it along with that?
Along with serial number 44, if my lord would take it.
44 and 1 of list 1.
If my lord would take it along with serial number 44 in this.
We'll take it up with list 1 because that is the last one which will be taken up. Pass over. Next.
My lord.
11.
Yes, Mr. Katimani.
Your Lordship, I'm appearing for the petition in the case, my lord. Here the petitioner is the mother who had sought for correction of a name in the birth certificate of a child, my lord.
What is the correction?
It was in the birth certificate is mentioned as Rekha A. The petitioner name is Sureka, my lord. SU had to be, and she gave a representation, my lord, that is annexure B, my lord, along with affidavit.
Where are the documents of identity?
Birth certificate is annexure A. Her identity is annexure E. And
Where's the application that you had submitted for recordal of the
annexure B, my lord, representation.
no, earlier application that you had submitted?
Earlier, no, my lord.
I don't have that copy. If the documents are there.
My lord, father, first thing, my lord, the father is not made a party to this petition, my lords. Number two, my lord.
There is not made a party, yes, you are right.
Number two, my lords, if my lordships were to see annexure H, my lords. The
H.
last, yes. The mother's name continues to be Rekha there, my lords.
This document why I have produced because there is an urgency, my lord. He is studying in 9th standard and now is going to be
10th standard for his exam.
Yes, my lord. For that reason, I've submitted this document.
Where is the father?
My lord, I can produce additional document. There is a BPL card.
Where is the father? Why is the father not a party?
My lord, father's name is correct, my lord. So on that basis,
let him also file an affidavit that he has no objection. Later, there's a dispute which happens between matrimonial proceedings. How did this change? Nobody asked me.
My lord, that's the reason I have produced.
Make the father a party and file an affidavit of the father that he has no objection.
I'll file an affidavit, man. I'll amend and
make him a party. File an impleading application.
Sure, my lord.
File an affidavit. When will you do that?
2 days time, my lord.
Shri B.S. Karthikeyan accepts notice for respondent number 1 to 3. Counsel for the petition seeks for and is granted 3 days time to file an affidavit, file an impleading application to implead the father in the present proceedings, as also to file an affidavit of the father indicating his no objection for the prayers made in the present petition. Released on 25th February.
May also, my lords, they have to actually file an affidavit with the births and registers, and a gazette has to be passed, my lords. There is another coordinate bench of this honorable court who had passed this order. I'll place it on record.
Place it on record. Give him a copy.
Gazette
Give him a copy. Gazette is after the order.
Please.
Fine. After the change, you have to gazette it.
Correct.
Fair enough. That is not a problem for them. That gazette will also help them.
Correct.
In future application, they could enclose the gazette also.
Yes, please.
What's open?
Serial number 12, M.R. Hirematta.
My lord, it's a Jaglur Lake matter.
Jaglur. Inna esti idiyamma?
12 and 15, my lord.
12 and 15. And AGA for respondent number 1 to 4 and 6. Shri Mahesh Arupin for respondent number 5. Connect with serial number 40.
48 in list 2, please.
48 in list 1, same order.
And 47 in list.
Relist on 20.
1 week.
26th.
My lord, serial number 15 is also same.
12, 15.
It may be connected with list 1, 48 serial
ಆಯ್ತು
number.
ಆಮೇಲೆ ಇನ್ಯಾವುದು
And
ಎರಡೇನಾ
list 2, 47 serial number.
ಲಿಸ್ಟ್ 47 ಆಯ್ತು.
Yes.
Serial number 13.
My lords, in this matter, my lords, our only prayer is for directions to the respondent authorities to follow the due process of law, my lords.
For what?
My lords, in this matter, they have demarcated my properties for demolition, my lords, without giving us a notice, without an opportunity for us to be heard, my lords.
Who has done it? Stormwater drain.
Stormwater drain. My lords, in fact, my neighbor, who is my GPA holder in this matter, even there was a threat of demolition of his property. He also filed a writ petition before this honorable court, and this honorable court was pleased to direct them to not take any precipitative actions.
You should notice.
So all these stormwater drains, ADLR makes us to marking, and then only our job is to
That doesn't mean that you demolish without giving them a notice.
Not notice, we don't do it, but we do inform them, and then only.
Informal notice. Informal is not over phone.
We are
Hello, how
informed
you?
that-
We are coming to demolish ಅಂತ ಹೇಳಕ್ಕಾಗಲ್ಲ.
Yes, sir. Yes,
You have to give them a notice. If he has any documents, he'll submit it.
there are JCBs coming around, my lords. The parties are in, they're living in fear, my
The
lords.
survey has to be done in their presence,
Survey must have been done, my lords. After survey only.
in their presence, not by yourself.
And it will secure records, my lords, whether it is done in their presence or not. Because the survey is done by ADLR, so they must be having the records.
We'll observe that if survey has not been carried out in their presence,
It can.
carry out the survey in their presence. I mean, carried out in their presence, issue notices. And then, if they have to remove anything, all those things have to happen.
If my lords may grant a protective order, my lords, for the time being.
Respond number 1, Shri Pawan Kumar accepts notice for respond number 2 and 3. Petitioner is before this court seeking for the following griefs. The grievance of the petitioner is that without carrying a survey in the presence of the petitioner and without issuing a notice to the petitioner, the respondents are proposing to demolish the construction of the petitioner. Shri Pawan Kumar, learned counsel for respondent 2 and 3, submit that the demarcation is done by the ADLR, and it is on that basis that action is proposed to be taken. Even if the demarcation is done by the ADLR, what would be required to be seen is whether the demarcation was made by carrying out a survey in the presence of the petitioner. If not, the said demarcation would suffer from illegality. Apart therefrom, even after a survey is carried out in the presence of the petitioner, informing the petitioner of the action proposed to be taken by respondents, including the provision of law under which the said action is proposed to be taken, giving the petitioner an opportunity to reply to the same. In the present case, the contention of the petitioner is that no joint survey has been carried out. In that view of the matter, I pass the following order. Writ petition is partly allowed. If a joint survey has not been carried out, respondents are directed to carry out a joint survey of the property in the presence of the petitioner. Needless to say, if a joint survey has already been carried out, no such survey would be required to be carried out. Admittedly, no note, if a consequent thereto, respondents are directed to issue necessary notices, notice informing the action proposed to be taken and the provision under which the action is proposed to be taken, giving adequate opportunity to the petitioner to reply to the same. Thereafter, pass necessary orders and then take action in accordance with law. The above observation, the petition stands disposed.
My lords, if my lords may also observe, my lords, that.
Needless to say, until such orders are passed, no coercive steps no coercive steps could be taken, including for demolition.
Grateful, my lords.
Santosh, you.
Petitioners are the owners of a commercial property in the limits of Nelamangala town municipality. The Nelamangala municipality's area was expanded by including about 8 to 10 surrounding panchayats in the year 2018. Prior to that, this petitioner has obtained a general license for a commercial hall, annexure E, my lord, page 60. He obtained a license to have the business called Karnataka Function Hall.
Yes.
Year 2012. And even the panchayat has given no NOC to obtain electricity supply, water supply and all is annexure D, my lord. After amalgamation into Nelamangala municipality, a petition was given by one Jagajivan Ram Association, annexure M. A temporary notice was issued in page 125 under 187 of the Karnataka Municipalities Act.
Yes.
Temporary notice, in that the operative portion of the order, page 2, my lord, 126. ಆದರೆ ನೀವುಗಳು ಈಗ ಖಾಲಿ ಇದ್ದ ಕಟ್ಟಡವನ್ನು ಪರಿವರ್ತಿಸಿ ಖಾಸಗಿ ಹಾಸ್ಟೆಲ್ಗೆ ಅಥವಾ ಶಾಲೆಗೆ ಬಾಡಿಗೆ ನೀಡಿರುತ್ತಾರೆ ಮತ್ತು ಕಟ್ಟಡದ ಒಳಾಂಗಣ ಕೆಲಸವನ್ನು ಸ್ಥಗಿತಗೊಳಿಸಲು ಈಗ ಹಳೆ ಕಟ್ಟಡದ ಮೇಲೆ ಹೊಸ ಕಟ್ಟಡ ಪ್ರಾರಂಭಿಸಿರುತ್ತಾರೆ. ಆದ ಕಾರಣ ಸ್ಥಳ ಪರಿಶೀಲಿಸಿ ಅಕ್ರಮವಾಗಿ ಕಟ್ಟುತ್ತಿರುವ ಮತ್ತು ನ್ಯಾಯಾಲಯದ ತಡೆಯಾಜ್ಞಾದೇಶವನ್ನು ಧಿಕ್ಕರಿಸಿರುವ ಕಟ್ಟಡದ ಮಾಲೀಕರ ಮೇಲೆ ಕಾನೂನು ರೀತ್ಯ ಕ್ರಮ ಜರುಗಿಸಲು ಶ್ರೀ ಮಹದೇವ್ ಸಂಸ್ಥಾಪಕ ಅಧ್ಯಕ್ಷರು ಡಾಕ್ಟರ್ ಜಗಜೀವನ್ ರಾಮ್ ಕ್ಷೇಮಾಭಿವೃದ್ಧಿ ಸಂಘ ನೆಲಮಂಗಲ ಇವರು ದಿನಾಂಕ 22-24 ಈ ಕಚೇರಿಗೆ ಅರ್ಜಿ ನೀಡಿರುತ್ತಾರೆ.
Where the photographs of the building?
My lord?
Photographs of the building?
Lord, I have not produced the photograph.
But
I have
permission for ground plus one.
ground plus one. No, my lord, the issue is the function hall of under conversion from a function hall into a school building. Commercial only, school building. A lease agreement was executed as per Annexure L, page 109. Even I am paying the commercial taxes to the municipality.
Now what are you doing? You got it for a hall and dining room.
No, hall and dining room.
Now what are you doing?
Now I have given it on lease, and he has to take after the alteration of the building, he has to obtain a fresh.
What is the alteration you are doing?
Alterations of in the buildings, of the rooms and all they are constructing.
Rooms for what?
Partition of the hall he is doing that.
You are now changing the character of the building. You have to not after the change, you have to get the permission. Before the change, you have to get the permission.
My lord, kindly peruse the dictum of the notice, my lord. Notice. Annexure A.
Yes.
Annexure A, para 3. ಪರಿಶೀಲಿಸ ನೀವುಗಳು ಅಕ್ರಮವಾಗಿ ನಿರ್ಮಿಸಿರುವಂತ ಕರ್ನಾಟಕ in which Karnataka function hall was.
ಇವಾಗ ಏನ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ ಹೇಳಿ?
No, I wanted to convert it, I leased it to one private person.
Yes.
He has to obtain a statutory sanction and permission from the authorities, and he has to convert into a commercial school building, which is also commercial in nature.
Correct. So for the before that change, you can't say that I'll do the structural changes and then get the permission. First you have to get the permission.
I'm not body. Kindly peruse, my lord, the operative portion. Operative portion, page 18. ಮೇಲ್ಕಂಡಂತೆ ವಿವರಿಸಿರುವ ಅಂಶಗಳನ್ವಯ ನೆಲಮಂಗಲ ನಗರಸಭೆ ವ್ಯಾಪ್ತಿಯ ಬಸವನಹಳ್ಳಿ ಗ್ರಾಮ ಪ್ರದೇಶದಲ್ಲಿ ಲೋಹಿತ್ ನಗರ ಸ್ವತ್ತಿನ ಖಾತೆ ಸೋನಲ್ಲಿ ನಿರ್ಮಿಸಿರುವ ನಿಯಮ ಬಾಹಿರ ಕಟ್ಟವನ್ನು their contention is my entire building.
ಎಲ್ಲಿ ಓದ್ತಾ ಇದ್ದೀರಾ ನೀವು?
Page 18 ಮೇಲೆ.
18 ಅಲ್ಲಿ ಎಲ್ಲಿ ಓದ್ತಾ ಇದ್ದೀರಾ?
18 ಸ್ಥಿರೀಕರಣ ಆದೇಶ.
ಈ
ಮೇಲ್ಕಂಡಂತೆ ವಿವರಿಸುವ ಅಂಶಗಳಲ್ಲಿ ನೆಲಮಂಗಲ ನಗರಸಭೆ ವ್ಯಾಪ್ತಿಯ ಬಸವನಹಳ್ಳಿ ಗ್ರಾಮ ಪ್ರದೇಶದ ಲೋಹಿತ್ ನಗರ ಸ್ವತ್ತಿನ ಖಾತಾ ಸೋನಲ್ಲಿ ಕರ್ನಾಟಕ ಫಂಕ್ಷನ್ ಹಾಲ್ ಎಂಬ ವಾಣಿಜ್ಯ ಕಟ್ಟಡವನ್ನು ಸಾರ್ವಜನಿಕರಿಗೆ ಹಾಗೂ ವಾಹನ ಓಡಾಟಕ್ಕೆ ತೊಂದರೆ ಸುರಕ್ಷಿತ ವಿಧಾನ ಅನುಸರಿಸಿಕೊಂಡು ನೀವೇ ಸ್ವಂತ ಖರ್ಚಲ್ಲಿ ಸದರಿ ಕಟ್ಟಡವನ್ನು ಪೂರ್ಣ ಪ್ರಮಾಣದಲ್ಲಿ ತೆರವುಗೊಳಿಸಿ ದಿನಾಂಕ 12/3/25 ಈ ಕಚೇರಿ ತಾತ್ಕಾಲಿಕ ಆದೇಶ ಹೊರಡಿಸಲಾಗಿರುತ್ತದೆ. ಆದರೆ ನೀವುಗಳು ಈ ತಹಲ್ವರೆಗೂ ಸದರಿ ಕಟ್ಟಡವನ್ನು ಪೂರ್ಣ ಪ್ರಮಾಣದಲ್ಲಿ ತೆರವುಗೊಳಿಸದೇ ಇರುವುದು ಕಂಡು ಬಂದಿರುತ್ತದೆ. ಆದ ಕಾರಣ 12/3/25 ತಾತ್ಕಾಲಿಕ ಆದೇಶ ಸ್ಥಿರೀಕರಿಸಿದೆ ಮತ್ತು ಈ ಸ್ಥಿರೀಕರಣ ಆದೇಶ 15 ದಿವಸಗಳೊಳಗೆ ಸದರಿ ನಿಯಮ ಬಾಹಿರ ಕಟ್ಟಡವನ್ನು their contention is the entire building.
What is this suit which was filed?
The suit was filed for mandatory
OS number
injunction
136 of 21.
Suits are pending, madam.
What is the order? What is the suit for?
Suit for once first suit OS number 230 is order 39 rule 1 and 2 injunction. The another suit
I'm interfering with your position.
not to interfere with the.
How is a suit maintained for all these things?
No, my local lawyer has filed it. It is pending. Suits are pending. No order has been passed.
Is there a no order is not passed? That's why you come before us. Go get the relief there only in a non-maintainable suit.
Local lawyer has approached that thing. What I challenge here, though my function hall has got a license, general license, permission, even tax.
Show us those documents.
My
Where
license
is the
from
plan sanction?
the plan sanction is that not legible, my lord, but I have given the plan sanction.
Page
Page
number?
129, the copy was Even conversion order is at page 127 from the Deputy Commissioner, Annexure N. 3-floor plan sanction also I have enclosed, but it is not visible as it is. And for that I have filed in the dispensation copy.
Yes.
Page 129, 3-floor sanction plan is
But you will
also-
not carry out any changes in that building.
That is their observation.
Neither you nor your tenant will carry out any changes till the next day. We'll restrain you from doing that. We'll restrain them from demolishing, but you will also not carry out any changes.
Any changes, we will maintain the status quo. Yes. And also we will approach the statutory authorities for appropriate, that liberty may be.
Learned AGA for respond number 1, CMC Nelmangla,
Kalyanar.
Kalyanar for respond number 2, AGA for respond number 1 and 3. The grievance of the petitioner is that without considering the plan sanction obtained from the erstwhile panchayat in terms of annexure P at page 129 of the writ petition, the respondents have sought to contend that the construction which has been put up by the petitioner of a Kalyan Mandapa is illegal and a demolition order at annexure A has been issued. Taking into consideration the plan sanction which has been produced, subject to the veracity being ascertained by the respondent, date of hearing, the petitioners and or anyone claiming through or under them are also restrained from making use of the premises for any other purpose than as a Kalyan Mandap and or carrying out any structural changes in the said premises till the next date of hearing. Counsel for the petitioner shall provide 2 sets of the petition along with annexures to the aforesaid counsels by end of day 21st February and acknowledgement filed with the registry, failing which the interim order will stand automatically vacated. Relist on 26th February. I1 of 26 is allowed.
Serial number 15 adjourned. Serial number 16. HR Uma Devi.
Madam?
For petitioner, my lord, yesterday regarding the section 311 of GB Act.
Same.
Yes, my lord.
Same suit, same. And AGA for respond number 1, Shri Pawan Kumar for respond number 2 to 4. Connect with WP number so and so, same order. Same
Not to
date.
take any coercive steps to.
Same order, same date.
Petition.
We have heard you enough and we have passed the detail. Same order.
17. Number, my God.
Idunu
And
same.
17 is also similar and
17.
19, my lord.
16, 17, 19.
Yes, ma'am.
Number kodiya.
Okay.
Number 18. Govindaraju DJ.
For petitioner, Your Lordship. The challenge under this petition is annexure J and K. The proceedings initiated by the deputy commissioners. In the like proceedings, Your Lordship has already been stayed in other connected matters.
Which one is this?
That is in, that is also made as annexure H2.
Page?
Annexure H5 to H7. There are in 3 matters Your Lordship has already stayed in respect of other petitioners. Page number 126, Your Lordship. 126.
Connect with learned AGA accepts notice for respond number 1 and 2. KM Prakash is directed to accept 1, 2 and 4. KM Prakash for respond number 3. Connect with WP number 58 of 26.
58.
Same order. Relist on date ಏನಿದೆ?
Annexure J and K.
ಹೊಸ ಡೇಟ್ ಏನಾದ್ರು ಇದೆಯಾ ಅದು?
The date has been given, Your Lordship. March ಯಾವ್ದೋ ಒಂದು ಡೇಟ್ ಇದೆ.
ಯಾವ ಡೇಟ್ ಇದೆಯಾ ನೋಡ್ಬಿಟ್ಟು ಅದೇ ಡೇಟ್ ಕೊಡಿ.
4/3 ಏನಾದ್ರು ಇದೆ.
Yes.
Stayed.
Same order.
4th March. Serial number 19, 20, adjourned 21. Rohan Osmat.
Yes, Rohan.
Buffer zone of 30 meters is fixed while sanctioning the layout plan. But it's the buffer zone is from survey number 222, which was previously a lake in the village map. The purposes of which under section 71, the deputy commissioner has diverted it and permitted usage for a police station and other purpose, which is at page 78.
78.
Please,
Where's the
98
where's the RTC of the lake?
Sorry, my lord.
RTC of the lake?
But I have not produced the RTC of the lake.
What is the total extent?
But it's pretty large extent, my lord.
So is the entire lake diverted?
But it's not the entire lake. The portion of the lake, my lord, which is situated adjacent to the property.
Yes.
But it's to that extent, my lord, I am aggrieved, my lord, where they have imposed the 30 meters buffer.
We'll have to hear them.
Please, my lord.
Learned AGF for respond number 1 and 2. Kanakpura Town Planning Authority?
Yogesh.
Ella Planning Authority. Yogesh Naik for respond number 3 and 4.
Please.
Council for the petition furnish 2 sets of the petition along with annexures on the said council. The respective councils for response are directed to secure instruction and make their submission as regards the alleged diversion adverted to by the learned counsel for the petitioner of the lake area for the purpose of establishment of
A residential layout.
a police station and
Police station and healthcare unit. my lord.
healthcare unit and the location of the property of the petitioner vis-a-vis such diversion with the distance thereof. Released on 10th March.
Please. Date.
22.
Yes, Mr. Kulkarni.
The house which has been constructed by the petitioner is being sought to be demolished without any notice or orders here by the Tahsildar.
Who is taking action? Chikbadapur,
Please, madam.
Manchenalli.
Tahsildar.
Where is your plan sanction?
Lord, the plan was sanctioned, however, the time has lapsed.
Where is the plan sanction?
Annexure D, madam.
Page
16, madam.
16.
ಮನೆ ಕಟ್ಟಡದ ಅನುಮತಿ ಪತ್ರ.
Building license of 23 till 25 itta. You are constructing as per the plan.
Lord, construction is
Mane.
going on. I have produced the photographs before your lordships at page 20. ಸುಮಾರು ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಆಗೋಗಿದೆ. ಈಗ JCB ತಗೊಂಡ್ಬಂದು trying to demolish it. They have to identify, my lord, according to the Tahsildar, government land ಅಲ್ಲಿ ನೀವು ಮಾಡ್ತಾ ಇದ್ದೀರಾ ಅಂತ. ಯಾವ ಲ್ಯಾಂಡು, whether any, they have not even issued a notice to me.
Now you are carrying out construction in 273/199.
274/200, my lord.
Nim plan sanction is 273/199. Page 16.
No, annexure D, page 16, 274/200.
Page 16 annexure D ನಿಮ್ಮ ಹತ್ರ ಯಾವ್ದು ಇದೆಯಪ್ಪ?
There's some discrepancy, my lord.
273/199.
The annexure type copy may be taken, my lord.
Type copy is wrong.
My lord, the annexure is wrongly put, I think, because I have to.
Your actual permission is only for 273/199.
Both, my lord.
Your type copy only 274/200 and you have typed it out yourself.
But obviously, though both the properties are there, a wrong annexure has been put at annexure D. I'll just
Then
correct.
produce the correct annexure.
Please,
When will you produce it?
I'll do it.
And AGA for respond number 1, 2 and 3. Manchenalli Chikbadapura, video.
Devraju.
MS Devraju is directed to accept notice for respond number 4. Counsel for the petitioner seeks for and is granted 3 days time to place on record the correct building license secured by the petitioner. Released on 25th February.
Please.
23. Rangara movie.
Petition, my lord.
Yes.
This is a case in which KHB has given the flat to the respondent number 4 herein. In spite he is an authorized occupant and the petitioner mother was working in the silviculture, government silviculture, and he has paid the money to the respondent in the last occasion also. Their case is, she has got 3 more property. It is also brought to the notice of the KHB at page number 43, my lord.
So you were to get the allotment and it's been given to respond number.
Respondent number
3 is
4.
your condition.
At annexure L, page number 43, she is also owning 3 more properties in the same location.
That we'll have to consider after notice.
Please, man. In the meanwhile, they want to give the property to them and they will go on.
It will be subject to the writ.
Please, man.
So and so accepts notice for respond number
1 and 2, my lord. Sharan Sabrad.
1 and 2.
Please.
New year, madam.
HL Pradeep Kumar, Housing Board.
I don't know, my lord. She's not on the panel. I don't know why.
Don't make those submissions. Issue notice to respond, emergent notice to respond number 3, returnable by 23rd March.
Then meanwhile,
IA 1 or 26 is allowed. Any action taken by respond number 1 and 2 shall be subject to the result of the present petition.
24.
Because they have gone registering the property.
But we can't stop it because we don't know what the this one is. Any
All
action
further
will be
proceedings,
subject to the, if you are able to establish
Please, my lord.
your
Eligibility
payments
is there. I'll
and it's borne out by their records, that will be cancelled, it will be given to you.
24. K. Ravishankar.
Yes, Ravi?
Yes, ma'am. Petitioner is dealing with an enterprises which deals with the construction materials at Subramanya. But a complaint came to be lodged, there is a sound pollution. Based upon which Milot, a complaint is also simultaneously lodged to the Women's Commission, State's Women's Commission. State Women's Commission in turn Milot directs and take action, and an action E came to be issued. Page
Why
23.
Women's Commission? Complainant was a woman, is it?
Please.
Yes.
Page 23, para 2. ದೂರುದಾರರು ಸೋ ಅಂಡ್ ಸೋ ತಾಯಿಯವರಾದ ಶ್ರೀಮತಿ ಶುಭಾ ಸೋ ಅಂಡ್ ಸೋ ಅವರು ನಿಮ್ಮ ವ್ಯಾಪಾರ ವಹಿವಾಟಿನ ಸಂದರ್ಭ ಅತಿಯಾಗಿ ಉಂಟಾಗುವ ಶಬ್ದದಿಂದ ಮಾನಸಿಕ ತೊಂದರೆ ಕೊಡುತ್ತಿರುವ ಬಗ್ಗೆ ರಾಜ್ಯ ಮಹಿಳಾ ಆಯೋಗಕ್ಕೆ thereafter it has been without enquiry. They have now stopped. I have also filed an application for renewal of a trade license, Annexure F. An
What
endorsement
business
is-
are you carrying out?
Please, Millet.
What business are you carrying out?
Millet, I am dealing with the construction material, Millet, selling.
Selling or manufacturing?
No manufacture. Kindly have a look at Millet, Annexure H, page 29. Photographs. These are all the materials which were in the business venture. This is to be sold. ಅದು ಕಬ್ಬಿಣ ಕಟ್ ಮಾಡೋ ಸೌಂಡ್ ಬಂದ್ರೆ that they have
Carrying out some works is not just trading.
Yes.
So for that pollution control board permission is required?
But I have also, they have issued an endorsement Annexure G page for my application. But page G, page 28.
Yes.
ಪರವಾನಗಿ ನೀಡಲು ಬೇಕಾಗಿರುವ ಅಗತ್ಯ ದಾಖಲೆಗಳಾದ ಸೋ ಅಂಡ್ ಸೋ ಕಿಟ್ಟಿಗೆ ತರಪಾವತಿ ಭಾವಚಿತ್ರಗಳು ಇಲ್ಲದಿರುವುದು ನಿಮಗೆ ವ್ಯಾಪಾರ ಪರವಾನಗಿ ನೀಡಲು ಸಾಧ್ಯವಿಲ್ಲ. ಆದ್ದರಿಂದ ಮೇಲೆ ತಿಳಿಸಿದ ಅಗತ್ಯ ದಾಖಲಾತಿಗಳನ್ನು ಸಲ್ಲಿಸಿ ಪರವಾನಗಿ ಪಡೆದುಕೊಳ್ಳಬೇಕಾಗಿದೆ. But I have given an application Millet on 16/2 and on the very same day I will comply with.
This is only the Panchayat Karyalaya. If you are carrying out any business, is there permission of the KSPCB required for consent for establishment and consent for operation?
It's only Millet, I am running, selling the construction material, that's it, on the trade
To make them a
license.
party, we'll ask them if there's a permit, because if there's a noise pollution, you'll have to get their permission.
But based upon the State's Women's Commission Millet direction.
Fair enough, but if admittedly you are carrying out some work there.
But now they have come and trying to stop it.
Yes. Do you?
I shall make a part.
Make them a party.
Yes.
Subramanya
Charanjit
Sharanjit Shetty accepts notice for respondent. Council being of the new mind, issue in the present matter is as regards noise pollution caused by the activities of the petitioner. In that view of the matter, I am of the considered opinion that the Karnataka State Pollution Control Board, represented by its chairman, is required to be brought on as respond number 2. Council for the petitioner to carry out necessary amendment and file amended cost title. Shri Gururaj Joshi is directed to accept notice for respond number 2. Shri Gururaj Joshi is directed to secure instructions. Council for the petitioner furnished 2 sets of petition along with annexures on the said council. He is directed to secure instruction as to whether the business of the petitioner being carried out requires any consent from the KSPCB for doing so, including consent for establishment and consent for operation. Released on 25th February.
Millet, may I request me let them not stop the business Millet. I'll undertake not, no noise will be made till then.
How will you do it without noise?
Hunting, ನಾನು ಬಿಲ್ಡಿಂಗ್ ಮೆಟೀರಿಯಲ್ ಜಲ್ಲಿ ಕಲ್ಲು ಸಣ್ಣ ಇದನ್ನು ಮಾರ್ತಾ ಇರ್ತೀನಿ, ಓನ್ಲಿ ಅವಕೇಶನ್ ಮಿಲಾಟ್.
ನೀವೆಲ್ಲ ತಂದಲ್ಲಿ ಡಂಪ್ ಮಾಡಕ್ ಸೌಂಡ್ ಆಗೇ ಆಗತ್ತೆ. So the whole thing is what you are dumping there creates lot of in a residential area.
Yesterday also they have come and visited.
Correct. You can't do that kind of thing in a residential place affecting other people. If you require, that is why the pollution control board is there. ಅವ್ರು ಎಲ್ಲೂ ಹೋಗಲ್ಲ. Only when people come to us, we'll do it ಅಂತಾರೆ. None of them inspect anything, nothing they do. Only when we receive complaint, we'll do post-mortem. They don't have a hospital, they have only a mortuary.
So it's only, but my,
to do
only
it properly.
livelihood ಇದೆ ಅದಕ್ಕೆ. Let them till millet the response.
Placing the submission of the petitioner on record that there would be no activities resulting in noise pollution.
ನಾ ಹೇಳ್ತೀನಿ ಅವ್ರಿಗೆ.
Which will be carried out. The operation of annexure, if he stayed till the next date of hearing.
Please.
It's our made clear that if any of the operations of the petitioner were to cause noise pollution,
I shall.
Respondents would be entitled to take further action against the petitioner. IA 1 of 26 is allowed.
Public.
25, Rajeshwara, please.
Yes, Rajeshwara.
I mean, permitted to do it.
Carry it out.
Respondent number 8 is carrying out construction work without obtaining license plan, my lords.
How is your,
Lords,
who are you?
I'm within the 100 meters from that place, my lords. Lords, what's happening is,
PIL.
lords, there's a Kudlu lake within the buffer zone. This work is happening.
File a PIL. If you are a neighbor, we'll consider it. Because we are finding a lot of these extortion matters coming up.
My lords, sir.
Comply with the PIL, undertake all those things, then you do. What do you want? You want conversion or you want fresh filing?
It's conversion, my lords.
Conversion ಕಷ್ಟ ಆಗತ್ತೆ ಮಾಡಿ.
All right, miss, I with liberty to file. Please.
Petitioner is before this court seeking for the following leaves. The contention of the petitioner is that respondent number 8 is carrying out illegal construction. On inquiry as to whether the petitioner is a neighbor being directly affected by it, it's submitted that the petitioner is not a neighbor but resides in the neighborhood. Even if that were to be so, a private list cannot be maintained before this bench. Reserving liberty to the petitioner to file a public interest litigation, petition stands disposed.
Great.
26, Abhimanyu Devaya.
Yes. Educational institution, Lord. Sorry, I've lost my voice a little. Educational institution.
Why have you lost your voice? Too much of argument.
It's like cold. There's some problem in the weather.
You're arguing too much with the other side.
That also could be a reason. Lord.
Yes.
This petitioner is an educational institution and is entitled to the exemption. It's running a school from 1968. And now a provision
AJ
order.
for respondent number 1, Shri Pawan Kumar for respondent 2 and 3. There's yet another case which is coming up before this court as regards levy of property tax on an educational institution which is exempt from making payment of educational institution. On that basis, notices, show cause notice, demand notice, and now a proclamation notice for sale of the petitioner's property has been issued, which is not permissible. Again, this appears to be a glitch in the software being used by the respondents, not catering to educational institutions. The Chief Commissioner of the BBMP ಮಾಡ್ತಾ ಇದ್ದೀರಾ ಇನ್ನ ನೀವು?
No BBMP.
Chief Commissioner of the GBA and the Special Commissioner IT are directed to look into this issue and to include educational institutions as an exemption as per the applicable laws in the said software. The operation of annexure C is stayed till the next date of hearing. Relist on, connect with so and so, relist on 23rd.
Serial number 27 dismissed. 28, Nachiket Joshi.
Appearing for the petition.
Yes, Nachiket.
Similar order was passed by my lord.
Yeah, the one.
The apartment.
1 to 47. So now you'll file 47 petitions.
No, my.
You're forcing 47 petitions.
Next.
They are blocking it, my lord, my instructions. They're taking steps to block it.
How much of
Yeah, how much problem has
heartburn and
caused?
grievances caused? Shri Pawan Kumar accepts notice for respondent number 1 to 4. Connect with WP number so and so, same order.
Only difference is here under the fear we have not paid the amount sought for in the proclamation.
Para 6 beda. And proclamation notice is annexure
M1.
N.
M.
M. Well, N badlu M ಮಾಡಿ.
Serial number 30 also same petition.
And that is annexure?
Annexure. It's annexure R.
Annexure R in 30. Connect with so and so, relist on 23rd. Stop doing this thing until it is solved.
Yeah, I have informed them.
They're not
Even
issuing
the
any more
auction on 17th was cancelled.
The 21st?
There are other, like, I'm following it up with them, so that other auction should also be cancelled.
So next is 21st and after that is 27th.
Third is also there, 3rd March.
27th and 3rd.
So I have
You won't be able to solve this by that
I
time.
have informed them that until this is solved.
Take out a paper publication so that everybody knows that you are not acting on these notices.
I will instruct.
So Nachiket would be happy coming before this court. His client will not be happy.
Yes, I understand it.
More than that, what we are apprehensive about is that these kind of notices can create a lot of issues.
Consequences are there.
Should not happen like that.
I already
For
informed.
15,000, 20,000, you are selling a property of lakhs and many times crores.
I have informed them.
When the problem is with your software. There's no problem with your software also, there's no issue. But when there's a problem with your software, you can't do those things. Issue a public notice. Ask the Chief Commissioner.
Yes, ma'am.
One submission, man. Here the auction dates are different as compared to the
What is the
earlier order.
date here?
Auction date is 21st, man.
21st. And that is got over, 17th.
That was 17th.
21st.
29, Mohan Kumar.
For petition matters. Ground rent matter.
Ground rent.
That's page 42, my lords.
KV Monish Kumar is directed to accept notice for respond number 1 and 2. And AGF for respond number 3. The operation of the demand notice dated 27/1/26 bearing so and so at annexure A issued by respond number 1 is stated in view of the order passed by a coordinate bench of this court. Where is the disposal?
Page 42, my lords. Respondent BBMP is hereby directed to issue modified plan.
Adalla, quashing of the ground rent order. Where is that order?
That order is not.
Ground rent quashing, which is under challenge.
Ground, page 34, my lords, annexure F.
Adalla. Nagaprasan Sahibar judgment ಅಲ್ಲಿ.
That I am
Or
not.
the Devdas sir. Devdas sir.
The Honorable Justice Devdas. I will share that number.
Dated so and so in WP number so and so. Respondents are directed to consider the application of the petitioner for issuance of plan sanction without insisting on payment of ground rent. They said sanction would however be subject to the result of the present petition and the result of writ appeal number 1050. 1050 of 26.
25, man.
25.
That matter number is 23086 of 22.
23086
of 22.
086 of 22.
That's right.
And yavat hakidivi ground rent matters 10.
10-3, man.
Based on 10-3.
Serial number 30, adjourn 31. Lakshmi.
For the petition amendments.
2 and
Lords had
3.
directed the respondents to produce the show cause notice and also to place on record the manner and methodology.
2 days accommodation due to this change in delegation of power. We were unable to take out the.
Then it is not there. Anyway,
Days accommodation.
interim order idea.
Yes, my lord.
Until then, they are restricted. The B.S. Karthikeyan has appeared for respond number 2 and 3. Delete the name of Shri Pawan Kumar as that appearing for respond number 2 and 3. Counsel for respond 2 and 3 seeks for a week's time to comply with the order dated 29/1/26, relist on 2nd March, interim order, 3rd March, interim order earlier granted is extended till next date.
Right.
For dismissal, serial number 32.
Yes, Prashant. Nimde.
My lord, this is ordered, Madam, my lordship, with respect to property tax, my lordship, they have issued a notice under section, subsection 12 of the 108.
108A.
Please, my lordship. Now they are trying.
They were supposed to produce some case
Please,
laws.
I'll produce it, my lordship.
Should keep everything ready, Mujassim.
In the meantime, may I produce these case laws?
ready.
I have one case law which I have to produce. My lordships raised a question last time on whether any assessment which is beyond 3 years can be reopened up. That aspect has been handled by this judgment, my lords.
Your contention was knowledge, date of knowledge.
Yes, my lords. When somebody doesn't come with clean hands to court, the question of limitation should not apply. My lordships may kindly turn to para 37.
Idu writ
my lords.
appeal irabekala idu.
My lords?
There was a writ appeal on this.
Yes, but it's not pending. This,
What happened in the writ
pending,
appeal?
but it's not decided upon. Adrille final decision bandilla writ appeal.
The stay of this order.
Stay on this. But that's only on the classification, not on the limitation aspect.
It appeared in this notice.
I saw the name. My lords.
The stay of this order.
Limitation aspect ಇದೆ, if I may look at para 37 and 38, my lords.
Is that limitation aspect of knowledge cannot be answered, the appeal only there is a stay.
That's all.
Lord, clearly here the provision, my lordship.
Writ appeal is still not disposed.
No, it is pending, my lord. My lord, this is a judgment, my lordship, with respect to how, my lordship, before that, my lordship, my lord, subsection 12, my lordship, it says that.
What do you want to rely on this, Mujassim?
It is with respect to same, my lordship, how they have tried.
How para nappa? Which para do you want to?
My lordship, it is a para
You
number.
cannot just give a decision, it is same one.
Sorry, my lord. It is a para number 7, my lord.
7.
Please, my lord. Where the notice was issued under a subsection A of 147 of the income tax, my lordship. And subsequently, they tried to convert it saying that it is a 147B to invoke the proceedings under 148 of 48 of the Income Tax Act, my lord. Both the proceedings under both the subsections leads to same proceedings, but the notice which have been issued made the difference and the assessment was set aside, my lordship. Supreme Court has upheld this order, my lordship.
Why do you want to rely on this case?
My lord, with respect to same, my lordship, they are saying that, see, they are admitting with respect to subsection 12, they have not, they have given notice under one subsection, and order has been passed under subsection 12, my lordship. Though,
Where is your notice?
please, my lord. Annexure A, my lord.
Annexure A is the order.
And
notice was issued under what provision?
Both same, my lordship, in this notice and order are one, they issue the notice and once no objection is filed, then it is a final order, my lord. That is what, my
This
lord.
under subsection 12 or section 108A?
Please, my lordship. My lord, kindly see, my lord, subsection 12, it says, my lordship, it is for if the occupier of the property refuses.
Not allowed them to come in.
Please, my lordship.
Yes.
Then they can proceed and pass a base judgment saying that based on the material available on record. When subsection 13, my lordship, exactly covers my, falls into my.
Now you are contending it's a random scrutiny.
A random scrutiny.
You are contending.
Yes,
Please, my lord. They are admitting this. Admittedly, they are saying that we have not proceeded under our subsection 13. And they are saying
No,
that we have not suppressed the fact, only with respect to there is a miscalculation in the property tax, my lordship, and there is shortfall of a property tax payment.
It's been issued under subsection 12.
Yes,
Please,
I
Madam.
admitted on the last occasion, it should have been 13, it has been mistyped as 12.
Then it has to go, my lordship.
On that basis, forget coming to 14. You are still stuck at 12 only.
Please, my lord.
It
That's
shouldn't have been 12 because every other instructions and every other objections which we filed is substantiating the fact that it was a random scrutiny which was picked up. And in the random scrutiny found out that they were actually classified in a wrong classification.
In the whole calculation which you have done, all of you knew about it, so you should have issued it in a proper section.
12 ಇರ್ಬಾರ್ದಾಗಿತ್ತು, 13 ಇರ್ಬೇಕಾಗಿತ್ತು.
Petitioner is before this court seeking for the following reliefs. The petitioner is aggrieved by a notice dated 14/8/2017 issued notice come order dated 14/8/2017 issued under subsection 12 of section 108A of the Karnataka Municipal Corporation Act 1976. The submission of Sri Mohammed Mujassim, learned counsel for the petitioner, is that the ingredients of subsection 12 of section 108A are not attracted inasmuch as there was no notice which had been issued to the petitioner to inspect the premises, nor was there any refusal on part of the petitioner requiring the respondents to pass an order under subsection 12 of section 108A. His further submission by relying on subsection 14 of section 108A is that an assessment or reassessment shall not be made after 3 years of filing of the tax return under the section. He therefore submits that the notice, impugned notice is required to be quashed. Sri S.H. Prashant, learned counsel for respondent number 1 and 2, submit that the notice has been issued after a random scrutiny and it is the ingredients of subsection 13 of section 108A which is required to be considered and not the ingredients of subsection 12 of section 108A. His submission is that the returns which had been filed by the petitioner have been taken up for random scrutiny. The authorized officer was of the belief that there is an incorrect assessment made and as such notice had been issued. And in that regard, he submits that there was no requirement to issue a notice to inspect the premises under subsection 12 of section 108A. Heard Sri Mohammed Mujassim, learned counsel for the petitioner, Sri H.H. Prashant for respondent number 1 and 2. The short question that would arise for consideration in the present matter is whether on a random scrutiny being carried out in terms of subsection 13 of section 108A, a notice and order could have been passed under subsection 12 of section 108A. Question mark. Section 108A is a fiscal measure relating to the proper of the KMC Act leviable in respect of property of a citizen by the corporation. It is trite law that any fiscal statute has to be considered strictly in accordance with the wordings therein, and there cannot be any interpretation given to it otherwise than what is contained in that provision. In the present case, it is not the interpretation which is in question, but the very provision, inasmuch as the counsel for respondent contending that the notice was issued pursuant to a random scrutiny under subsection 13 of section 108A, whereas the impugned notice stroke order reflects that it has been issued under subsection 12 of section 108A. The purport and impact of the aforesaid subsections would have to be considered by this court to ascertain if it is only a mistake in if it is a typographical error which could be ignored, or does it goes to the substance of the matter. Subsection 12 of section 108A is reproduced hereunder for easy reference. A perusal of subsection 12 would indicate that if an occupier of the property refuses to allow the authorized officer to enter to inspect the premises, the officer, after giving reasonable opportunity, shall record the refusal and shall proceed to assess the property to the best of his judgment. That is, a best judgment assessment has to be made. In terms of subsection 13 of section 108A is reproduced hereunder for easy reference. A perusal of subsection 13 would indicate that it is upon random scrutiny if the authorized officer has reason to believe that any return furnished which is deemed as assessed is incorrect or has been under assessed, resulting in evasion of the property tax. Having perused both the subsections, I have the considered opinion that both of them operate in different fields. Subsection 12 operates in a situation where a inspection proposed to be carried out by the authorized officer is objected to by the assessee or a person residing in the said building, requiring action to be taken under subsection 12 of section 108A. Whereas subsection 13 deals with a situation where on a random scrutiny, the return furnished is considered by the concerned officer to be incorrect or has been under assessed. Which is completely different from that contemplated in subsection 12 of section 108A. Under subsection 12 of section 108A, what is also contemplated is a best judgment assessment, whereas under subsection 13 of section 108A, it is a reassessment which is required to be carried out by the authorized officer. Thus, under subsection 12 of section 108A, there is no assessment which is on record requiring a reassessment, whereas under subsection 13 of section 108A, there is assessment already on record which requires a reassessment on account of a contention that there is an evasion of property tax. These differences being ex facie apparent, the further differences are not gone into by this court in the present matter. These differences are sufficient to hold that a notice under subsection 12 of section 108A cannot be inferred or deemed to be also under subsection 13 of section 108A. Hence, this issue going to the very root of the matter, section 108A, as indicated supra, being a fiscal statute, has to be strictly interpreted and given given effect to in a strict manner. A substitution of one subsection by another subsection cannot be permitted in respect of fiscal statutes. As such, I pass the following order. Writ petitions allowed. A certiorari is issued. The notice dated 14/8/2017 at annexure A and B are quashed. Consequently, the demand notice dated 8/1/2018 at annexure C and D and the demand show cause notice dated 16/1/2018 at annexure E and F and the endorsement dated 17/2/2018 at annexure G are quashed.
Liberty may be granted if I can issue a further notice in accordance with law, my lord.
If law permits, my lord, there is
Of
no.
course. Liberty could.
Well, that is-
Don't use that.
Orders, serial number 33. M.R. Balakrishna.
I appear for petition, my lord.
In this matter, kindly pass for I further.
They have
I have
served
given
the-
the copy to him.
You're given the copy.
They have served the soft copy, my lord. We will look into it and my lord, we will make submissions.
Your house is being demolished.
Please, my lord.
And counsel for respond number 1 and 2 submit that
During the course.
a copy of the inspection report has been furnished to petitioner and the same would be filed during the course of the day with the registry. Counsel for the petitioner seeks fund is granted 10 days time to go through the same and make a submission. Relist on 4th March. How is the violations? Lot of violations?
Violations. Setback violations are there.
Site measurement?
Site measurements, they have amalgamated two katas and they have constructed more or less. It's
More than
around
2,400 square.
60-40 around it. 60-40 more or less it will come.
Then you've done it as per the regulation of 5.1.
I have told them, my lords. I will just check. If it is not there, I will add this.
Yes.
Interim order may be extended.
Will 60-40 do it as per regulation of 5.1?
Regulation that can.
Interim order may be extended.
Interim order earlier granted is extended till next year.
Obliged.
34, Vivekananda.
Respond 1 and 2 on this. My lord, report is ready, my lord. Serve the copy as well.
This is that apartment.
Yes.
Yes.
At the tabular column, serial number 2 and 6 is the issue.
Now it has been removed. 7, 10 and 11. So that is the issue which remains.
As regards the serial number 7,
Three
they are complied.
Solar.
4, 284 car parks. Now you have 285. Inna on the extra code.
Issue at serial number 6, my lord, and 2.
Modification is after the construction is complete.
But as per my instruction, they haven't. They are allowed to they are allowed to.
Construction is complete. Sales have happened. Sale deeds have been registered.
In 2022, that partial occupancy certificate has been granted. Lecture H, page 37 minutes. But no such condition was imposed. Though RERA Act has come into force in 2017. That this is only in respect of one block now occupancy certificate is being given.
So this condition has been imposed in the modified sanction plan. Solar.
They have complied.
Yes,
I just served.
In fact, solar panels have been installed day before yesterday. After their inspection, I am furnishing.
Just received a copy.
It has been. Even that is also complied.
Yes, at the inspection, but you should do it once.
And, my lord, there is an issue at serial number 2. My lord.
One more.
Serial number 2 will come to. That's what we told you. If everything else is there, then we'll deal with serial number 2. Otherwise, we won't. If those issues are there, we don't need to come to serial number 2.
I understand.
Serial number 2 is a legal interpretation that we'll keep.
I am conscious that I can't seek negative equality before this honorable court. But my instructions are that in none of the other apartments, the installation of solar is strictly being implemented by VVMP. In fact, the next building of the petitioner, I took the aerial view. There is not even a single solar panel. If that is taken into
building solar idea.
Building.
May a person
BBMP building. Building nimmane alla.
Is there no?
BBMP building idea.
Is there in central unit?
It's a building next to our apartment complex. Not even a single solar panel is installed there. Of course, your lordships have observed on the last occasion. We are providing we have installed as many as about 9 solar panels the day before yesterday.
Third. Petitioner is before this court seeking for the following reliefs. Petitioner is the owner of the land measuring 4 acres in survey number 3/2 and 4, situated in Amrutalli village, Yelahanka Hobli, Bangalore North Taluk. After following the due process and procedure and obtaining a plan sanction, the petitioner put up a construction of apartment complex in the said property. There being certain modifications from the year 2012. From the year 2007. The construction being completed in the year 2012, upon inspection of the building, the Assistant Director of Town Planning BBMP had issued an endorsement pointing out certain defects. These defects were also cleared by the petitioner and resubmitted on 28/7/2015. When one more endorsement was issued indicating certain other defects, which was also complied with by the petitioner and a representation submitted on 23/12/2015. Thereafter, the petitioner has sold the apartments to various persons who are in occupation of the said apartments. In the year 2019, the respondents called upon the petitioner to make payment of certain amounts, which was again revised on 29/8/2020, and in pursuance of the orders passed by this court in WP number 12204 of 2020, partial occupancy certificate also came to be issued on 17/9/2020. 2. In respect of block number B, C, D, E, and F, and building 1 of the clubhouse in building 1 and clubhouse in building number 2. As regards block A in building number 1, there were certain issues which had been pointed out, which were required to be complied with by the petitioner. These issues were encapsulated in the order dated 10/2/26 of this court, and an inspection was directed to be conducted to ascertain if those defects have been complied with by the petitioners. Today, a memo with a report dated 16/2/2026 has been filed, which is taken on record. A perusal thereof would indicate that all the defects which have been pointed out have been complied with, except 2, namely that in the 7th, 10th, and 11th floor, 2 apartments have been clubbed together to form a single apartment, which is not in terms of the sanction plan. And 2, that there's no registration with the Karnataka Real Estate Regulatory Authority since the Act came into force in the year 2017, and the modified plan sanction was granted on 17/9/22. It is on account of these 2 pending issues that the learned counsel for respondent submits that the occupancy certificate has not been issued. The scope and ambit of the above writ petition has now been reduced to the aforesaid 2 issues, which would be required to be examined by this court, since all other defects stand complied with by the petitioner. Insofar as the registration under RERA is concerned, it is not in dispute that the plan was sanctioned in the year 2007, construction was completed in the year 2012. The apartments had been sold to the purchaser who had occupied the buildings, albeit without an occupancy certificate. Insofar as block number B, C, D, E, and F are concerned, an partial occupancy certificate had been issued on 17/9/2022, and the occupancy certificate only in respect of building 1 of block A was pending. This was, insofar as this building is concerned, the construction had been completed way back in the year 2012. The defects were pointed out from time to time. There is no complaint which has been raised. There is no complaint and demand raised by anybody.
No.
The submission of learned counsel for the petitioner categorically is that there is no complaint which has been raised by any of the apartment purchasers. In that view of the matter, I am of the considered opinion that the occupancy certificate which is required for people who is already occupied cannot be denied on that ground, since denial thereof would create more problems for the occupants than providing a solution on account of registration with RERA. Since even on registration with RERA being done, none of those could be complied with, since the building is ready, is completed, all the payments of the purchasers have been received by the developer, and there is virtually not any compliance which is required to be made by a developer in terms of the RERA Act. Be that as it may, the above observation will not preclude any apartment purchaser from initiating proceedings under RERA if at all they have any complaints against the development and or the construction which has been put up. The aspect of requirement of RERA registration is being considered in the present matter only with reference to the occupancy certificate to be issued and for no other reason. Insofar as the clubbing of apartments on floors 7, 10 and 11 are concerned, what the developer has done at the request of the purchaser is to club 2 apartments into 1. The same does not in any manner change the extent of construction or the nature of construction. It is only providing a larger apartment to a purchaser, which in my considered opinion cannot be said to be a violation of the plan requiring the denial of a occupancy certificate.
But they will have to apply for a modification of
requiring the denial of a occupancy certificate. This being more so for the reason that while granting an occupancy certificate, what is considered is the total construction which has been put up and the deviation from the construction total constructed area. There is no examination done unit-wise or apartment-wise to ascertain any particular defect in a particular apartment. The issuance of an occupancy certificate is for the building as a whole, considering the total extent of construction, setbacks required to be provided, the height of the building, etc., which form the basis of the building by which arise out of the requirement of compliance with the building bylaws. The clubbing of 2 apartments per se cannot be said to be a violation of the plan sanction. In that view of the matter, I'll mail it. A memo has been filed by the counsel for the petitioner enclosing photographs of the building indicating that solar panels have been installed in the said building. Considering that all the defects which have been pointed out by the response have been complied with and taking into consideration the interest of the apartment owners who are in possession or occupation of the apartments in block 1 of building, block A of building number 1, I pass the following order. Writ petition allowed. Respond number 1 and 2 are directed to issue the final occupancy certificate in respect of block A of so and so building within a period of
4 months.
4 weeks.
8 weeks, man.
8 weeks. 8 weeks from date of receipt of a copy of this order. Obliged.
Please.
In ಎಲ್ಲ inspection ಆಯ್ತೆಲ್ಲ ಆಯ್ತು ಇನ್ನೇನು 8 weeks.
Still, I'll seek for buffer of 4 more weeks.
Yes.
35.
I appeal for the petitioner's counsel.
I may be permitted to sign the inspector.
Not received copies.
We have also not received.
Filing it last minute.
ಯಾವಾಗ್ಲೂ ಅದೇ ಅವ್ರು ಲಾಸ್ಟ್ ಮೂಮೆಂಟ್ ಇಲ್ಲೇ ಬಂದು ಸೈನ್ ಮಾಡಿಕೊಡ್ತಾರೆ.
May be permitted to go through and make submissions.
ಮುಂಭಾಗ, what is the size of the property? 333.72 ಚದುರ meter.
The first page is as per the, as against the plan, my lords. The second page is as per
333 points, not 60/40.
30 by 46, my lord. There is 6 feet on one side.
30 by 46 should be 1200. It'll 333.72 square meters and it's more than 3500 square feet.
30 by 46.
No, that shows there is no application of mind on the face of the record.
ಏನಮ್ಮ ಇದು? They're saying 1,200 square feet.
And
it
we were
says-
not asked to be there when the inspection has been done yesterday or day before yesterday. I'm sure it is not so, but then at least when the matter is pending.
When did the inspection happen?
I don't know, yesterday or day before yesterday, they have done
Yesterday, my
it
lords.
without notice to us. And when there's an order of sealing the property, they have not sealed it. CCTV camera is being used on the dummy camera is put there on the outside.
Blood.
Inspection was to be carried out on we had not directed us earlier, date was
Yes.
not fixed.
There is a submission openly made and then the interim order was passed.
Yes.
That there is violation. Now they want to help themselves and they want to enrich themselves. Let me file my objections.
There's already a violation. Why are see the report, Mr. Lokre.
Please, I have not seen, my lord. Last minute they are furnished.
44%, 35%, 32%, 30%.
My lords,
Let them
that-
remove it.
My lords, that is as per, as against the sanction plan issued.
No approval under 5-1. Let me go through
But
the
the
law.
first will not apply to this if
Yes.
it is 333.72 square meters.
Yes.
5-1 will apply only to 2,400 square feet and lesser, not more.
Yes, my lords.
This is 333.72 square meters as per your measurement.
Yes, my lords.
Where is the sketch?
This last sketch, my lord, they have filed, this is wrong.
The last-
It's not so. There is total violation. It is jutting into our property.
Page number 10.
Deviance.
Where are the photographs?
Page 10, my lord, last.
Photograph we have
No
submitted,
photographs are furnished.
previous date of hearing, my lords,
Where are the photographs?
along with the installation of CCTV, my lords.
ಅವ್ರು ಅಂದ್ರೆ ಯಾರು? ಎರಡು ಜನ ಇದ್ದಾರೆ. ನೀವು
Your report does not, is not in accordance with these photographs.
Yes, my lord. There is total variation.
My lords, I'll verify, my lords.
The measurements are not in accordance.
They have liked them and given a favorable report.
My lords, I'll verify, my lords.
Don't make us escalate it. We'll escalate it. If you want to. If your officers do these kind of things, we'll escalate it.
They are openly doing it.
I'll verify, my lords. Today itself, I'll verify.
This is not the way that it doesn't match anything in the photographs. Ex-facing.
I'll verify, my lords.
You don't need anything more.
My apologies, I'll verify, my lords.
Mr. Lokre will be right in getting agitated by this.
They are taking undue advantage of the kindness of the honorable court.
Where is the ADTP's signature? What is the property size of yours, Mr. Nandish?
Blood 30 by 46. Blood.
Where do we get that?
Sorry, Blood.
What is the size of the property, Mr. Lokre?
Correct, madam?
What is size of their property?
Their property is, what he says is, it's about 30 by 40.
Correct.
A little more or less, maybe 6 feet more.
As long as below 2,400 square feet.
Yes, yes,
The
madam.
regulation of 511 would apply, 5-1 would apply. If it is more than that, it won't apply, but here
My
333 and
grievance, my grievance is as mentioned in the petition, I stand by that. Now, my lord, during pendency of this case, during when the submission was made by the learned counsel for the BBMP, that there is violation, thereafter they were directed to stop because though there was an order, my lord, kindly see the photographs, they have continued construction.
No.
They have put that property right into my property and now they name it Sajja. I have marked that in red. That's not fair, my lord. They should wait until final orders of this court. They want to take advantage and now they want to give a color saying that it is coming under 5-1 and therefore we are sufficient and there is violation, let that be removed. My only request. Last time they took permission to remove centering. Under that guys, they have fixed the centering and started the work also.
Lord, I don't know from where my learned senior is making
got
such submissions,
information
my
from
lord.
the council.
Because categorically, my lord, on 2 occasions, we have made a submission before this honorable court and we've stopped construction. And in the photographs that he is showing, my lord, I don't know from where they are saying that construction is happening.
It is just adjacent to our property, sir.
Howದು adjacent ಅದಕ್ಕೆ file
Appoint a court
ಮಾಡಿದ್ದೀರಾ?
commissioner, then we'll see.
Your lordship may appoint a court commissioner, my lord.
We'll appoint.
Please, my lord.
Now, these
My lord, in
photographs
fact-
which have been produced did not have a roof.
No, roof is there, my lord. Roof
Yes.
we have, after the roof only they have filed the
No,
first
it
floor.
was progressing. It was progressing is my grievance. And the BBMP officials are aiding them. It's my other grievance.
See, the reason why we ask you to stop construction is
My lord,
that
we have
don't-
stopped, my lord.
Don't force us to demolish it.
My lord, yeah.
Now, if you want to invest your ardent money or whatever money that you have, it doesn't stop us from demolishing it later.
Lord, my humble submission
The
is,
way
my
that
lord.
we are trying to protect your interest and their interest, both of you, so that there's no construction which happens. But if you go beyond that,
Lord, we have not constructed, my
hide
lord.
that.
ಇಲ್ಲ construction ಮಾಡಿಲ್ಲ. After, my
How
lord, we
did
have,
this roof come?
Lord, it was there earlier only, my lord.
No, man.
All the photographs which are there before us, it doesn't have a roof.
My lord, after the first floor slab was, my lord, this
There is no first floor slab in any of these photographs.
On the personal
Lord,
note,
8th of January, my lord, we have put up the first floor slab, my lord. The photograph which is given is of 4th
Get that
February.
CCTV, you have installed the CCTV, right?
We have
Get
installed.
the CCTV of.
let them file affidavit that they have installed. They
When
have
was
not
the order?
installed.
Of hearing itself, we have furnished the memo along with photos, my lords, indicating the installation of
No, and
CCTV.
photos not.
What was the date?
Seventeen to 25 memo. Same official is standing in the photo. Only one CCTV, they round it.
In
But the work
17
is going
there's a
on.
roof.
Yes,
Earlier there was no roof.
no roof and stone.
So the roof
jelly.
also happened. When did you install the CCTV?
Day before yesterday, my lords, 9/2, my lords,
Day before us.
9/2,
9/2 you installed.
9/2.
And this photograph is of
Inspection was done
9/2.
on 9/2, my lords.
There's no proof that they have installed it anyway. That's not their CCTV. It's the land owner's CCTV according to the instruction.
Why are you concerned where, who has done it, as long as you get the CCTV? Don't make everything a issue, Mr. Lopez.
I'm sorry, my lord. I'm don't want to trouble the honorable court with
We
this
are
matter.
here for the trouble only. We
All I'm
are
requesting
here
is-
only for this.
They should have waited for the court's decision and left the setback. That's all I'm saying. Why trouble so much trouble for this? They want to feverishly continue, intimidate these parties in person and want to go on with the matter, the construction.
You sealed the construction site?
We have not seen on.
There's an order directing you to seal the construction site.
Yes, please, my lords.
That order was passed on 4/2. And now you're giving us 9/2 saying that the roof has come up.
My lords, the ARO has visited the site, my lord. The CCTV.
When did
has
you
been
install this?
installed.
The order was on
First-
4/2. When did you install the CCTV?
9/2, my lords.
Why did you wait for 5 days? So that they could put the roof.
My lords, first floor casting was done
In January,
from the
my lord.
beginning itself, my lord. That is what is my instruction is.
Your instructions will be all that only. That is also clear why you waited for 5 days to install it.
From the initial times, they have been instructing us that the first floor casting was already done, my lords.
When was the first in?
How can?
January 7th, my lord.
Why
is
are
the-
we installing CCTVs? Because there's absolutely complete trust deficient. Why are we escalating it to the next level of officers? Is that all your AROs, AEEs are in collusion and they create this problem. Firstly, they are the ones who have to see to it that these kind of construction don't come out. If you want us to send somebody inside, we will do that.
My lords, it may be directed, once more the inspection will be held, my lords.
What is the point?
But there is a
After,
deviation, my lords.
after orders have been passed by this court, you allowed the first floor, the roof to be put up.
Yes, first floor.
Eleven, 12, 25 is the interim order. Even if you say you constructed on 7/1,
Please.
11, 12, 25 is the interim order.
My lord, but we were communicated, my lord, only, my lord, in the month of February, my lord,
We are worried about response, concerned, worried.
because we
whatever
have,
word
my lord,
about 4
admittedly
and
put
5.
up the first.
Because 4 and 5 were directed to instruct to visit the property immediately and to take steps to stop the construction. This order was passed on 11, 12, 25. We'll admit Mr.
Please,
Patil's
that
January.
statement clearly saying that 7/1, that they put up the roof, they cast the slab. That is 1 month after the interim order.
My lords, that was communicated, my lords. My
Very
apologies.
good. We'll escalate it. Learned counsel for petitioner vehemently contends that there is complete violation of the orders passed by this court and the respondents have had no regard for the said orders. His submission also is that the jurisdictional officers, namely the Assistant Executive Engineer, only the AEE or who?
AEE.
The AEE is colluding with respondent number
4, 5 and 6.
5 and 6 and permitting the construction to go on. The said submission is ex facie believable for the simple reason that even according to the counsel for respondent number 5 and 6, the first floor slab had been put up on 7/1/2026.
7/1.
When interim orders had been passed by this court on 11/12/2025, and this court had directed respondent number 4 and 5 to visit the property and ensure that no further construction is put up by respondent number 5 and 6. Respondent number 4 to visit and to ensure that there is no further construction put up by respondent number 5 and 6. When there is a categorical direction which had been issued by the coordinate bench of this court to do so, it is clear that respondent number 4 has failed to visit the property and ensure no construction happens, since even according to respondent number 5 and 6, the slab has been put up on 7/1/2026. The said submission of the counsel for respondent number 5 and 6 is admitted, is accepted for now. Acceptance of the said submission of counsel for respondent number 5 and 6 does not mean acceptance in toto, in as much as it still needs to be ascertained as to when the slab was put up. Be that as it may, the slab having been put up post the interim orders passed by this court, which respondent number 4 was directed to ensure implementation. Respondent number Respondent number 1 is directed to look into the matter and take such action as is required to be taken for such violation of the orders. This court would also have to, will in future consider whether contempt proceedings also have to be initiated against respondent number 4. Now you are not sealed it. That is further one more nail in the coffin.
Seal agide, there is no construction that is going on, my lords.
Deal ಮಾಡಿಲ್ಲ ಅಂತ ಅವರೇ ಈಗ ಹೇಳಿದ್ರು.
ಈಗ ಸೀಲ್ ಇಲ್ಲ ಅಂತ ಹೇಳಿ
ಅವ್ರು ಹೇಳಿದಕ್ಕೆ ಅವ್ರು
seal agide, the construction is stopped and the CCTV camera has been
Produce the
installed.
photographs in the afternoon of the sealing of the premises. Let us see what it is. If it has been sealed, how did they remove the centering material?
No, your lordships had permitted.
Don't make us get into all these things we are capable of getting into, we'll get into. Don't make us
I'll seek
getting into.
instruction.
Lord, with respect to the centering material, Lord, may I make
An
one
order is
submission?
passed by the court, it's your duty to implement it.
Yes,
Just because there's a change in bench, doesn't mean that your officers will ignore it. We'll ensure that any order passed by the previous bench will be implemented. That won't come in the way. Don't let them think otherwise. Bench change agoyitu, ad order earlier ittu, iವಾಗ implement ಮಾಡದ್ ಬೇಡ, can't be a reason.
In yesterday's report, I'm sorry, in yesterday's report also, they don't say, my lord, that it was sealed, we took permission, opened it and so on. So yeah, I'm saying it's not.
Sure, produce the photographs.
Serial number 36. BB Sidramaya.
Yes, I appear on behalf of the
My
respondent
lord.
number 2 on the.
My lord, in this case, inspection is done, my lord. We'll furnish the report on Tuesday, my. Tuesday report ಕೊಡ್ತೀವಿ sir. Inspection ಆಗಿದೆ.
Report
Tuesday.
Tuesday.
I appear for the respondent number 2. I may be permitted to place the report on record,
You
not
know,
the
but-
Tahsildar's report, but.
I want to
we've
file
conducted-
Tahsildar report. It will be filed at Tuesday.
Learned Counsel for respondent number 2 has filed the inspection report. The same is taken on record. Learned AG, see, oh, this is that road. Seeks for 2 days' time to place on record the inspection report of the Tahsildar. Inspection and action taken report of the Tahsildar. Released on 24th at 2:30 PM.
Well, that's on the last date of hearing, your lordship directed to ensure that the trenches are covered up. It is covered up by the respondent.
People can use the road now.
The road is functional now.
Submission of learned counsel for respondent number 2, that the trench which had been dug up has been closed and the general public can make use of the public road is placed on record. What is the action you have taken against the people who have dug it up?
Well, their contention is that they have a decree in their favor, Manos, and they say that that portion of land belongs to them. Six.
They still haven't come before this court. Yes.
It's a 12-meter road, Melods. Right now, it is up to 2.5 meters. It right now comes under the revenue.
Let us wait for that.
Interim order is there.
And place that decree also. Interim order earlier granted is extended till next day.
What interim?
B group matters, serial number 37. Sushant PA.
Lord, sir, pass over, kindly pass over. I request for another date, my lord. I've lost my file. I'll just take the file and see what.
You lost your
I'll just see.
24 file, how did you lose?
I'll give a copy, my lord. I'll just take a copy. I'm sorry, my lord, sir.
Counsel for respondent number 2 to 4 seeks fund is granted 10 days time to get ready and address his arguments. Relist on 3rd March.
Great.
Saying whatever by then.
38. Srinivasa KL.
Appear for the petitioners.
Appear for the respondent.
I'm challenging the annexure or my lord, this the third round litigation, not.
Yes.
Lord, earlier, my lord, I had approached this honorable court. Your lordship had directed the respondent transmitted the kata as per law on the basis of the sale deed at annexure A, my lord. I am the registered owner of the property. After getting the registered sale deed, my lord, I had approached the respondent for transfer of kata. Lord, the sale deed at annexure A, page number 14, my lord.
3522. Yes.
Lord, when I approached the respondent as per annexure N, they have not transferred the kata. Therefore, I had approached this honorable court. Your lordship had passed the order in annexure N, P, my lord.
Page.
Page number 66.
Yes.
Lord, your lordship had issued a
Your
direction.
Sale deed was, did your vendor have a kata?
Lord?
Did your vendor have a kata?
No, yes, my lord.
Where's the kata number? Where's the kata certificate?
Lord, kindly annexure J, my lord.
Page?
Page number 49.
49.
That is the Uttara Patra issued by the respondent.
Uttara Patra allappa, nim khaತೆಯಲ್ಲಿ. Where's the kata? In favor of your vendor.
This annexure J is a fabricated document, my lord.
No, my lord. Lord, I will. Now they are saying that my vendor also not having kata. Lord, I applied the copy through RTM, Lord. In that RTA, the registers.
You should like to give them copies.
I will give, my lord.
Can't
I will
pass it
furnish.
on like this.
I will furnish. It's 160A.
There is no document available.
My lord.
There is no document available.
Lord, page number 2, my lord. Page number 2. E. Nagaratna, 160A. My vendor name is reflecting in the said document.
ಎಲ್ಲಪ್ಪ ಇದೆ?
My lord,
ಇದ್ರಲ್ಲ?
RTA copy. Top of the second ಮಾಹಿತಿ ಅಧಿನಿಯಮ 2005ರಲ್ಲಿ ರಾಮಪ್ರಸಾದ್ಗಿಂತ ಮೇಲೆ ಸೀರಿಯಲ್ ನಂಬರ್ 222 ಆದ್ಮೇಲೆ
222.
ಹಾ
Number 222 is 159-2A.
ಅದ್ರ ಕೆಳಗಡೆ ಬಾಟಮ್ ಅಲ್ಲಿ 160A. ನೆಕ್ಸ್ಟ್
There is no any shara in this, my lord.
Not there.
After that calculation, everything is done.
Yes.
There is nothing to that.
Not they have admitted that my site number comes in survey number 24. Now they are saying that the property is not existed. Their own document, their own report stating that my site is existed in survey number 23. Not kindly come
But
to
if it is
annexure.
fabricated, it's available on your register.
You are their register.
Let them
Come to it, yes.
My lord, kindly come to annexure R, page number 71, my lord. When I filed a contempt petition before this court, my lord, they have issued this endorsement stating that, Lord, may I read, my lord? ನಿಮ್ಮ ಮನವಿಯನ್ನು ಪರಿಶೀಲಿಸಲಾಗಿ ಸದರಿ ಸ್ವತ್ತಿಗೆ ಶ್ರೀಮತಿ ನಾಗರತ್ನ ಎಂಬುವರ ಹೆಸರಿನಲ್ಲಿ ಮೈಸೂರು ಮಹಾನಗರ ಪಾಲಿಕೆ ಖಾತಾವಹಿಯಲ್ಲಿ ಖಾತೆ ದಾಖಲಾಗಿರುವ ಕಂಡುಬಂದಿರಲಿಲ್ಲ. ಉಲ್ಲೇಖ 4ರಲ್ಲಿ ನೀಡಿರುವ ಹಕ್ಕುಪತ್ರದಲ್ಲಿ ಸದರಿ ಸ್ವತ್ತು ನಾಚನಹಳ್ಳಿ ಗ್ರಾಮ ಠಾಣಾ ವ್ಯಾಪ್ತಿಯಲ್ಲಿ ಇರುವುದಾಗಿ ವಿವರಿಸಿದ್ದು, ಸ್ಥಳ ಪರಿಶೀಲನಾ ಸಮಯದಲ್ಲಿ ಸ್ವತ್ತು ಸರ್ವೆ ನಂಬರ್ 24 ನಾಚನಹಳ್ಳಿ ಕಸಬಾ ಹೋಬಳಿ ಮೈಸೂರು ವ್ಯಾಪ್ತಿಯಲ್ಲಿ ಕಂಡುಬಂದಿದ್ದು ಗ್ರಾಮ ಠಾಣಾ ವ್ಯಾಪ್ತಿಯಲ್ಲಿರುವುದಿಲ್ಲ ಹಾಗೂ ಹಕ್ಕುಪತ್ರ ಗ್ರಾಮ ಲೆಕ್ಕಾಧಿಕಾರಿಗಳ ಸಹಿ ಇದ್ದು ಪಂಚಾಯಿತಿ ವ್ಯಾಪ್ತಿಯಲ್ಲಿ ಕಾರ್ಯದರ್ಶಿಗಳು, ಅಧ್ಯಕ್ಷರು, ಆಡಳಿತಾಧಿಕಾರಿಗಳು ಸಹಿ ಮಾಡಬೇಕಾಗಿರುತ್ತದೆ ಮತ್ತು ಉಲ್ಲೇಖ 3ರ ಮಾನ್ಯ ನ್ಯಾಯಾಲಯದ ಆದೇಶದಿಂದ ನಗರ ಮಾಪನ ಯೋಜನಾಧಿಕಾರಿಗಳ ಕಚೇರಿ ನಜರಾಬಾದ್ ಮೈಸೂರು ಅವರು ತಯಾರಿಸಿರುವ ನಕ್ಷೆಯಲ್ಲಿ ಸದರಿ ಸರ್ವೆ ನಂಬರ್ 24ರಲ್ಲಿ 1 ಎಕರೆ 21 ಗುಂಟೆ ಫುಟ್ ಖರಾಬ್ ಜಾಗವು ಬಂಗಲೆ ಕಟ್ಟಡಗಳಿಂದ ಕೂಡಿರುವ ಪ್ರದೇಶವಾಗಿರುತ್ತದೆ ಎಂದು ತಿಳಿಸಲಾಗಿರುತ್ತದೆ. But this is the endorsement they have issued. I am not concerned about the survey number 24 or 23, my lord. My lord, my site number comes in Brampton.
Where is your sale deed? Let us see your sale deed.
My lord, kindly come to page number 14, my lord.
What, where is the schedule? Mysuru city, Jille.
Please, my lord. Schedule, my lord. ಮೈಸೂರು ಸಿಟಿ ಕಿಲ್ಲೆ ಮೊಹಲ ನಾಚನಹಳ್ಳಿ ಪಾಳ್ಯ ಹಳೆ ಊರಿಗೆ ಸೇರಿದ ಖಾತಾ ನಿವೇಶನದ ನಂಬರ್ 160
ವಿಭಾಗ ಮಾಡಿದ ನಂತರ 160A ಎಂಬರಾಗಿ ಪಶ್ಚಿಮ ಭಾಗದ ಸ್ವತ್ತಿಗೆ ಚೆಕ್ಕು ಬಂದಿದೆ. This is my site number is one, before earlier Milord, the site number 160 belongs to Timmarasu. My vendor had purchased half of the site from Timmarasu in the year 2008. That sale deed also I have produced this before your lordship at page number annexure H. Page number 43, my lord. This
is sale deed between?
Sale deed between my vendor, the original grantee, Timmarasu. Timmarasu had executed a sale deed. My vendor is Nagaratna.
This is on 17/4/2008.
2008. And after schedule, my lord, page number 47. ಮೈಸೂರು ಸಿಟಿ ಕಿಲ್ಲೆಮೂಲ ನಾಚನಳ್ಳಿಪಾಳ್ಯ ಹಳೆ ಊರಿಗೆ ಸೇರಿದ ಖಾತಾ ನಂಬರ್ 160ರ ಸ್ವತ್ತಿಗೆ ಚೆಕ್ಕು ಬಂದಿ ಸೋ ಅಂಡ್ ಸೋ ಪೂರ್ವಕ್ಕೆ ಸೋ ಅಂಡ್ ಸೋ ಈ ಮಧ್ಯೆ ಒಟ್ಟು ವಿಸ್ತೀರ್ಣ 60 ಅಡಿಗಳು ಮತ್ತು 80 ಅಡಿಗಳ ಪೈಕಿ ಪಶ್ಚಿಮ ಭಾಗಕ್ಕೆ ಸೇರಿದ ಇರುವ ಪೂರ್ವ ಪಶ್ಚಿಮ 30 ಅಡಿಗಳು ಹಾಗೂ ಉತ್ತರ ದಕ್ಷಿಣ 80 ಅಡಿಗಳ ಖಾಲಿ ನಿವೇಶನಕ್ಕೆ ಮಾತ್ರ ಈ ಕ್ರಯಕ್ಕೆ ಒಳಪಟ್ಟ ಸ್ವತ್ತಾಗಿರುತ್ತದೆ ಎಂದು ತಮ್ಮ ಆತ್ಮಸಂತೋಷದಿಂದಲೂ ಸೋ ಅಂಡ್ ಸೋ. Half of the property has been purchased by the petitioners. Now they are relying upon the annexure L, page number 57. 57.
Yes.
ಅದರಲ್ಲಿ ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿ ಮೈಸೂರು ನಗರ ಕಿಲ್ಲೆಮೊಹಲ ನಾಚನಹಳ್ಳಿ ಪಾಳ್ಯದ 160 ಉಪ ನಂಬರ್ 160A ಬಾಪ್ತು 30-80 ಅಡಿ ವಿಸ್ತೀರ್ಣ ನಿವೇಶನ ಜಾಗವು ಮೈಸೂರು ನಗರಾಭಿವೃದ್ಧಿ ಪ್ರಾಧಿಕಾರದ ಭೂ ಸ್ವಾಧೀನಕ್ಕೆ ಒಳಪಟ್ಟಿದೆ ಎಂಬ ನಿರಪೇಕ್ಷಣ ಪತ್ರ ಕೋರಿದ್ದು, ಈ ಬಗ್ಗೆ ವಿಶೇಷ ಭೂ ಸ್ವಾಧೀನ ಶಾಖೆಯ ಸರ್ವೆ ತಪಾಸಕರೊಂದಿಗೆ ಸ್ಥಳ ಪರಿಶೀಲಿಸಿದ್ದು, ಅದರಂತೆ ಸರ್ವೆ ತಪಾಸಕರು ಮೇಲ್ಕಂಡ ಸ್ವತ್ತನ್ನು ನಕ್ಷೆಯಲ್ಲಿ ಗುರುತಿಸಿ ವರದಿ ನೀಡುತ್ತಾರೆ. ಸದರಿ ಕಡತದಲ್ಲಿ ಲಭ್ಯವಿರುವ ಪ್ರಸ್ತುತ RTC ವರದಿ ಅನ್ವಯ ಸರ್ವೆ ನಂಬರ್ 24/2ರಲ್ಲಿ ಮೈಸೂರು ನಗರಾಭಿವೃದ್ಧಿ ಪ್ರಾಧಿಕಾರದಿಂದ 24 ಗುಂಟೆ ಜಮೀನು ಸ್ವಾಧೀನವಾಗಿದ್ದು, ಸದರಿ 24 ಗುಂಟೆ ಜಮೀನು ಪ್ರಾಧಿಕಾರದಿಂದ ರಸ್ತೆ ನಿರ್ಮಿಸಲು ಉಪಯೋಗಿಸಿಕೊಂಡಿರುವುದಾಗಿ ವರದಿ ನೀಡುತ್ತಾರೆ. ಸದರಿ ನಕ್ಷೆ ವರದಿ ಅನ್ವಯ ಮೇಲ್ಕಂಡ ಸ್ವತ್ತಿನ ಸಂಖ್ಯೆ 160 ಅಳತೆ 30-80 ಅಡಿ ಉಪ ನಂಬರ್ 160A ಪ್ರದೇಶವು ನಾಚನಹಳ್ಳಿ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 24ರ ಪ್ರದೇಶದಲ್ಲಿ ಬರುತ್ತಿದ್ದು, ಸದರಿ ಪ್ರದೇಶದಿಂದ ಭೂ ಸ್ವಾಧೀನವಾಗಿಲ್ಲವೆಂದು ನಿರಪೇಕ್ಷಣ ಪತ್ರ ನೀಡಿದೆ. Their contention is, my property comes in survey number 24. I am not nowhere concerned about the survey number 24. My property comes in Gramtana. My sale deed is reflects that my property is in Gramtana. I am in possession. My lord, there is an electricity connection.
How did Timmarasu get the property?
My lord, Timmarasu had got allotted from the Srirampura Group Panchayat. Earlier, Group Panchayat is there, my lord.
So where is that?
Please, my lord. At annexure B, my lord, page number 23.
ಯಾವುದ್ರಲ್ಲೂ ಯಾವ ಸರ್ವೆ ನಂಬರ್ ಏನು ಇಲ್ಲ ಅಂದ್ರೆ
ಸರ್ವೆ ನಂಬರ್ ಇಲ್ಲ, ಹಳೆ ಗ್ರಾಮ ಠಾಣಕ್ಕೆ ಸರ್ವೆ ನಂಬರ್ ಇಲ್ಲ. ಪೇಜ್ ನಂಬರ್ 23 annexure B, my lord. ನಾಚನಹಳ್ಳಿ ಗ್ರಾಮದಲ್ಲಿರುವ ತಿಮ್ಮಾಬೋವಿರವರ ಮಗ ತಿಮ್ಮರಸುರವರಿಗೆ ದಿನಾಂಕ 3/3/81ರಂದು ಪಂಚಾಯಿತಿಗೆ ನಿವೇಶನ ಕೇಳಿ ಕೊಟ್ಟಿರುವ ಅರ್ಜಿಯನ್ನು 9/8/81ರಂದು ನಡೆದ ನಮ್ಮ ಪಂಚಾಯಿತಿ ಸಭೆಯಲ್ಲಿ ನಿರ್ಣಯಿಸಿದಂತೆ ನಿಮಗೆ ಪಂಚಾಯಿತಿಗೆ ಸೇರಿದ ನಾಚನಹಳ್ಳಿ ಗ್ರಾಮದ ಇದರ ಜೊತೆಗೆ ಲಗತ್ತಿಸುವ ನಕ್ಷೆಯಲ್ಲಿ ತೋರಿಸಿರುವಂತೆ ನಮ್ಮ ಗ್ರಾಮ ಠಾಣಾ ನಿವೇಶನದಲ್ಲಿ ಮಾಡಿರುವ ಬಡಾವಣೆಯಲ್ಲಿರುವ ನಿವೇಶನ ಸಂಖ್ಯೆ 160 ವಿಸ್ತೀರ್ಣ ಪೂರ್ವ ಪಶ್ಚಿಮ 60 ಅಡಿ ಉತ್ತರ ದಕ್ಷಿಣ 80 ಪಂಚಾಯಿತಿ ಸಭೆಯಲ್ಲಿ ತೀರ್ಮಾನಿಸಿದಂತೆ ಇದರ ಕಿಮ್ಮತ್ತು ಮೊಬಲಗು 500 ರಸೀತಿ ಸಂಖ್ಯೆ 53ರ ಪ್ರಕಾರ ಪಡೆದು ನಿಮ್ಮ ಸುಪರ್ದಿಗೆ ವಹಿಸಿಕೊಟ್ಟಿರುತ್ತೇವೆ.
Finally, ಇಲ್ಲಿ ಗ್ರಾಮ ಠಾಣಾ ಅನ್ನತ್ತೆ.
Lord, even this annexure B, my lord, your lordships may see at bottom, ಗ್ರಾಮದ ಲೆಕ್ಕ ಅಧಿಕಾರಿ, my lord. He is a village accountant. And my lord, if any so the allotment has been done, the resolution will be passed by the panchayat, my lord. There is no any such resolution has been passed so till today. And my lord, only the petitioner vendors they are relying upon this document.
It's not that your endorsement is not that there is all these are fabricated. Your endorsement is saying it's coming under survey number 24 and survey number 24 has been acquired.
or the formation of a road, therefore the property does not exist, is your
Lord, this
endorsement.
survey number 24, what they are stating, the property was identified by them telling that this is my property. That complete property which they are identified, my lord, it comes in survey number 24. I have placed the RTCs on record before your lordship.
Filed your objections.
Please, my
They
lord, I
already
filed my
filed
objections,
objection,
my
my
lord.
You produce the records of the, of this resolution, if there is any resolution on this part, what
I
is
have,
there? Have you produced anything?
My lord,
1981.
Filed my statement of objection, my lord. We have stated that there is no any such resolution, my lord, number one. And my lord, the annexure B, we are disputing, and annexure J also we have been disputing, it's been fabricated. We have gone through our records. There is no any which they have relied upon annexure J, my lord.
No, RTI, they have produced it. It's there in your records.
They themselves collected
RTA,
tax,
what
my
they have
lord.
produced, my lord, the entire, your lordship may take page 2, my lord, in this. To all the other entries, my lord, there is a shara. Only when particular to this annex, what is the,
Fact remains that there is an entry in your records.
my lord, this I'll verify, my lord.
There are no
once.
record, entry in your records, that's different. There's a sale deed which has been registered.
Sale did be registered, my lord, but this I'll verify with,
This is not now, these are all old sale deeds.
please, my lord.
There's a sale deed registered by Timarasu in favor of Nagaratna in his favor, for the same measurement.
No, my lord.
And the entry
And
is
then
there
it has
in
been
your
fabricated,
records.
I mean, so then it has been bifurcated, what is they are stating it.
Correct,
But my
but
lord,
these are all registered sale deeds.
in my objections also I have stated, my lord, there is no any resolution passed by the panchayat, my lord. Para 4 of my,
That doesn't arise for you to say now. Because you got an entry in your, in the register which is available with you. 2, you are saying it is in 24 and 24 is acquired. All these conditions you did not raise.
lord, in respect to survey number 24, my lord, now in annexure B, my lord, they have stated it. Your lordship may take their own annexure E, my lord, page 36, my lord. Typed copy is 36.
Yes.
In there it says that Mysuru ತಾಲೂಕು ಕಸಬಾ ಹೋಬಳಿ ನಾಚನಹಳ್ಳಿ ಗ್ರಾಮ ಪಂಚಾಯತಿ ವ್ಯಾಪ್ತಿಯಲ್ಲಿ ಬರುವ ನಾಚನಹಳ್ಳಿ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 24ರಲ್ಲಿ ವಿಂಗಡಿಸಿರುವ ಖಾತಾ ನಂಬರ್ 160. Just now my learned counsel said I'm not concerned about survey number 24.
Okay. This is Rudikarna Patra issued by the Panchayat.
Panchayat. But my lord, there is no any address to whom it has been issued. Even the allotment letter also.
Anyway, they have produced it, so they are.
They issued by the Nationally Gram Panchayat secretary.
And according to that, it is survey number 24.
But now they say that just now my learned friend said that we are not concerned about survey number 24.
My lord, for a moment, my lord, kindly annexure K, my lord. They have collected the tax from my vendor from 2007 to 2008 and 9 to 2017. They have collected the tax. They have issued
Yes,
the.
Mr. Counsel.
Yes, ma'am.
You cannot be changing, approbating and reprobating. You said you had nothing to do with survey number 24.
Yes, my lord.
But you have produced a document indicating
Lord,
24 and 160.
Lord, this is the document issued by the consent
Neeve produce ಮಾಡಿರೋದು.
Gram Panchayat. Yes, my lord.
Neeve produce
The
ಮಾಡಿರೋದು
Gram
to
Panchayat
establish the identity of the property.
In this document, my lord, they have reflected survey number 24. The earlier.
ಅದಕ್ಕೆ ನಿಮ್ಗೆ ಆವಾಗಲಿಂದ ಒಂದೇ ಕ್ವೆಶ್ಚನ್ ಕೇಳಿದ್ದು ಸರ್ವೆ ನಂಬರ್ ಕೇಳಿದ್ವಿ ಗ್ರಾಂತನ ಅಂತ ಹೇಳ್ತಾ ಬರ್ತಾ ಇದೆ ಸರ್ವೆ ನಂಬರ್ ಇಲ್ಲ ಅಂದ್ರೆ now there is a clear document which indicates that it is survey number 24.
Kindly come to annexure L1, my lord, page number 58.
Page number
58.
58.
ಸರ್ವೆ ನಂಬರ್ 24ರಲ್ಲಿ 24 ಗುಂಟೆ ರಸ್ತೆ ಭೂ ಸ್ವಾಧೀನವಾಗಿರುತ್ತದೆ. ಸದರಿ ಬಣದಿಂದ ಗುರುತಿರುವ ಪ್ರದೇಶವು 23ರಲ್ಲಿ ಬರುವುದಿಲ್ಲವಾಗಿದ್ದು ಸರ್ವೆ ನಂಬರ್ 24ರ ಪೈಕಿ ಬರುತ್ತದೆ. ಸದರಿ ಪ್ರದೇಶ 24ರ ಪೈಕಿ ಅಳತೆ 30 ಅಳತೆ ನಿವೇಶನವನ್ನು ಜಾಗವನ್ನು ದಿನಾಂಕ 17/4/28ರಂದು ತಿಮ್ಮಬೋವಿರವರ ಮಗನ ತಿಮ್ಮರಸುರವರಿಂದ ಶ್ರೀಮತಿ ನಾಗರತ್ನ ಅವರಿಗೆ ಕ್ರಯವಾಗಿರುವ ಪ್ರದೇಶವಾಗಿರುತ್ತದೆ. ಸದರಿ ಕ್ರಯದಾರರಿಗೆ ಮೈಸೂರು ಮಹಾನಗರ ಪಾಲಿಕೆ ಮೈಸೂರು ಸಿಟಿ ಕೃಷ್ಣರಾಜ ಕ್ಷೇತ್ರ ವಲಯ ಕಚೇರಿ ಟು ನಾಚನಹಳ್ಳಿ ಪಾಳ್ಯದ ಅಳವೂರು ಗ್ರಾಮದ ನಿವೇಶನ ಸಂಖ್ಯೆ 160ರ ಪೈಕಿ 30-80 ವಿಭಾಗ ಮಾಡಿಕೊಂಡಿದ್ದು ಉಪ ನಂಬರ್ 160 ನೀಡಿ ನಾಗರತ್ನ ಅವರಿಗೆ ನೋಂದಾಯಿಸಿದೆ ಎಂದು ಉತ್ತರ ಪತ್ರದಲ್ಲಿ ನಮೂದಿಸಿರುತ್ತದೆ.
ಇದು ಸರ್ವೆ ನಂಬರ್ 24 ಬಂತು.
Not if they are going to admit that my site number comes under survey number 24. My site is existed. Now they are declined to register my car.
That is what we told him. Now but all of this points to 24. Another question is whether it's been acquired or not. Even according to it points to 24.
24.
And only it exists in 24.
Now the question remains is whether it's acquired or not.
Yes.
What is the acquisition notification?
Lord,
What does it say?
No, I've placed RTC on record, my lord. In 24, my lord, it has been divided to 4 parts. 1, 2, 3, 4, my lord. Regards to your lordship may take.
If it's
page-
acquired, you should have an acquisition notification.
That is acquired by the MUDA, my lord.
Whoever, there must be a notification.
Please, my lord, that I'll verify, but
Place
the
it on
RTC is-
record whether the survey number 24 has been acquired and whether 160 has been shown in the notification.
in survey number 24, but 2 has been acquired by MUDA, 24 Guntas land has, it has been formed a road, my lord, it has been functioning now. Remaining survey number 24 bar 1 stands in the private person, my lord. Survey number 22 bar 3 also stands in private person, 24 also stands in private person. Now if their identification is not my lands comes in at 24. That is why the impugned order was issued. They showed the property saying that this is my land. It's a complete vacant land. And this current, and this survey number 24 also comes to the Puttakarabu of the palace bungalows.
All your arguments are contradictory to each other.
Lord, their
You
contention
have to
is,
take one stand. You can't be taking different stands. You are an authority.
please, my lord.
You say this site is not there. Then you say that it's fabricated.
Lord, I'm saying
Then you
the-
say it is in 24. Now you say it is palace land. Then you say it is acquired by MUDA. Which one is the true fact?
Lord, where does the property lies, my lord, the specification exactly they have to tell, because now there's no, my learned counsel said, I'm not concerned about 24. The annexure says he is 24. And my lord, when it comes to regards to 24, my
The
lord,
council forget all those. You are going behind the whole thing. Your endorsement says 24. Your endorsement recognizes their site number.
please, my lord.
Your endorsement recognizes the sale. Your endorsement recognizes all these things. Now you are trying to go behind it.
What they have filed this RT
Can't go beyond your endorsement.
once again, I'll verify, my lord, because now they have produced this saying that there's a entry.
That is nothing. Your endorsement is clear. Your survey is clear.
That I'll verify, my lord, once again.
You can now go back beyond the endorsement saying that it's a fabricated document.
Lord, our
When your endorsement is clear that it is 24. Only question that you will have to show us is if it is acquired. Where is the acquisition notification? If it is not
24
acquired,
but
then
2
you
is
will have to
acquired,
give
my
them the kata.
I'll once again verify, my lord, short date may be given.
24 but 2 is acquired, my lord. That is the RTC was showing name
For
of the Mysore.
respondent initially seeks to submit that the sale deed relied upon by the petitioner is fabricated. However, a perusal of the endorsement
Not
issued
the
by
sale deed, my
respondent,
lord. Annexure J, the Uttarapat.
Annexure J is fabricated. However, the endorsement issued by the, to deny the title of the petitioner. However, the endorsement which has been issued by the respondent itself indicates that they have admitted the site to exist in survey number 120, or survey number 24 and the site to bear number 160. If the endorsement only reflects that the land has been acquired, if that is so, it is for the respondent to place on record the acquisition notification indicating that this particular property has been acquired.
Please, my lord.
Relist on 26, it is made clear that if the acquisition notification not produced by then, adverse inference would have to be drawn and matter proceeded.
One submission.
Yes.
Serial number 28 and 30, the SAS numbers in both the petitions are different from the earlier petition, my lord. I may be permitted to give the
Just
court
write
officer
on
the
top of
SAS.
it and-
Yes.
Lordship, serial number 39, filing objection, my lordship, 39.
39?
Filing objection, my lordship.
Who appears for the
39
petition?
ಅಲ್ಲಿ levying of tax on the mobile towers, telecommunication towers. It is covered by the
You want to see the objection or are you ready?
objection is with regard to the property tax
Are you ready? You are opposing adjournment.
and one more matter is not listed.
ಮತ್ತೆ
ಅಲ್ಲ ನಂಬರ್ ಕೊಡಕ್ probably mistake ಆಗಿದೆ.
Land Council for respondent has filed a statement of objection. The same is taken on record. Connect with WP number
19159.
19159 of 2025. Relist on 3rd March.
Serial number 6 in the first list, you
In second list.
Serial number
Cell number?
6.
50 in second list.
Yes.
Today there's an inconvenience, my lords. He is not available. I've informed the petitioner council as well as the rest.
All the respondents you are informed.
Yes.
Sale number 50 at the request of council for respondent number 3. Relist on 3rd
Serial number 6.
Milords, I appear for the petitioners in the.
Serial number 6, your
Milords,
lordship.
I appear for the petitioners in serial number 50, Milords. Milords, the respondent number 4 was directed to place on affidavit whether they have there was a deed of declaration, Milords. Milords, it pertains to the island of trees that are obstructing ingress and ingress to my school. Milords, the urgency, Milords, if it can be taken on Monday, Milords.
This we have heard quite.
Please, Milords.
Monday, my lord, 1 week's time, because your lordship directed to file some affidavit and documents, my lord. We are searching the file, my lord. We have whether nammalli siktalla, whether it is in BBMP alli, then 1 week's next week. We will also searching the engineer section
Counsel
also.
for respondent number 4 also seeks for a week's time.
Yes.
To comply with the order dated 10/2/2026.
Yes.
Pre-list on 3rd.
Serial number 6, your lordship. 6 in the first list.
The lordship list.
Apply for the petitioner. So Devraju is here and inform the other private respondent also.
Madidira?
Madidira.
Serial number 45, my lord.
The request of counsel for the petitioner relist on 10th March.
Interim order.
Serial number 45, my lord. Serial number 45, my lord.
Now list.
List 2, my lord. May required, my lord, some formal objection when next Wednesday or Thursday.
Counsel
I'm
for
for the
respondent
third
number
respondent.
3 seeks for and is granted 10 days time to file a statement of objection.
Your lordship list 1, serial number 15.
We have 120, 130 matters every day.
He said, well,
Yav file martira.
by Wednesday, Thursday, my lord.
Seeks for a week's time to file a statement of objections. Relist on 25th. You take your chance.
Your lordship list 1, serial number 15. We are for respondents.
List number 1, serial number
15. We are for
50.
15, your lordship.
15.
Your lordships, an NOC has been given. Council praise time, we will be filing a memo of
Here
retirement.
for whom?
Respondents, your lordships.
You have informed everybody?
Yes, your lordships. We will
You're
be
not
informing.
Don't move if you're not informed.
Okay, lordships.
ಬೇಕಾದ್ರು
Number 140 ಹೋಯ್ತು ನೋಡಿ. Number 1 list ಎಲ್ಲ
KG for 16 Pavan Kumar for 100.
ಏನಂತೆ ಸರ್?
Other question is 14 ಅದೇ 17 19 18 ಗೂ ಅದೇನೆ.
ಈ ಮಧ್ಯಾಹ್ನ 230 ಲಿಸ್ಟ್ ಬೇರೆ ಇರಬೇಕು ಅನ್ಸುತ್ತೆ. ಲಿಸ್ಟ್ ಇಲ್ಲ ಬಟ್
ಹೌದು.
16 17 19
ಆಮೇಲೆ ಒಂದ್ಗೆ ಇದೇ ಲಿಸ್ಟ್ ಕಂಟಿನ್ಯೂ ಆಗುತ್ತೆ. ಕಂಟಿನ್ಯೂ ಫಸ್ಟ್ ಲಿಸ್ಟ್ ಏನು ರೀಚ್ ಆಗೋದೇ ಡೌಟ್. ಅದರಲ್ಲಿ ಸುಮಾರು 60 ಮೇಲೆ ಬಂದಿದೆ.
14 26
14 ಬೇರೆ 14 ಬೇರೆ
ಅದು ಬೇರೆ
14 ಬೇರೆ 14 ಏನೂ ಇಲ್ಲ
14
ಏನೂ ಇಲ್ಲ ಅದು ಜಾಸ್ತಿ ಜಾರಿ ಇದೆ.
ಓಕೆ 16 17 19 ಮಾತ್ರ ಮೂರು ಕನೆಕ್ಟ್ ಮಾಡಬೇಕು. ಡೇಟ್ 14 18 ಗೆ ಸೇಮ್ ಆಗುತ್ತೆ ಕ್ವೆಶ್ಚನ್ 4 ಗೆ ಡೇಟ್ 21 ಲೋಡ್ 3 and 4 22 R4 ಗೆ
MSc ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಇರುತ್ತೆ ಎಲ್ಲ ಹೆಸರು.
ಸರ್ ಫಸ್ಟ್ ಲಿಸ್ಟ್ ಅಂತ
23 ಅಲ್ಲಿ 1 and 2 ಶರಣ್
ಸ್ಲಿಪ್ ಪಿನ್ ನೋಡಿದೀನಿ. ಶರಣ್
24
ಶರಂಜಿತ್ ಶೆಟ್ಟಿ ಶರಂಜಿತ್ ಒಂದೇ ವರ್ಡ್ ಶೆಟ್ಟಿ ಅಲ್ಲ ಇರೋದೇ ಒಬ್ರು
ಲಿಸ್ಟ್ 1 ಲಿಸ್ಟ್
26 ಅಲ್ಲಿ ಪವನ್ ಕುಮಾರ್ 28 29 28 ಮತ್ತೆ 30 ಪ್ರಿಂಟ್ ಸೇಮ್ ಇದೆ ಎರಡು ಬೇರೆ
ಸೇಮ್ ಆರ್ಡರ್ ಆದ್ರೆ ಎರಡಕ್ಕೂ ಸೇಮ್ ಒಂದೇ ಕೊಟ್ಟಿರೋದು. 20 ಇದ್ರಲ್ಲಿದೆ ಅದು 28 ಅಲ್ಲಿ ಇದೆ
ಕನೆಕ್ಟ್ ಅದೇ
ಪ್ರಿಂಟ್ ಅಲ್ಲಿ ಏನಿದೆ ಅದೇನೆ ಸೇಮ್ ಆರ್ಡರ್. ಸೇಮ್
ಅದನ್ನೇ ಕನೆಕ್ಟ್ ಮಾಡಬೇಕು.
ಹೌದು ಆರ್ಡರ್ ಅದೇ ಆಗುತ್ತೆ.
ಮಾಡಲ್ಲ 3 ನಿಮಿಷ ಕನೆಕ್ಟ್ ಆಗಿದೆ. ಅದು ಇದಕ್ಕೆ
ಹೌದು
ಆಮೇಲೆ 29 ಅಲ್ಲಿ ಮೋನೇಶ್ ಕುಮಾರ್
KB Monesh Kumar, KB.
31 Kartikeya Dhara. Thank you, ma'am. ನಿಮ್ಮ ಪಾಸ್ವರ್ಡ್ ಕೊಡ್ಬೇಕು ಟೈಪ್ ಮಾಡಿ ಕೊಡ್ಬೇಕು ಪಾಸ್ವರ್ಡ್.
ಬೇಡ ಅನ್ಸುತ್ತೆ ಬಿಡಿ ಹೊಸ. ಗೊತ್ತಾಯ್ತು, ನೀವು ಎಲ್ಲರಿಗೂ ಇನ್ಫಾರ್ಮ್ ಮಾಡಬೇಕು. ನೀವು NOC ಕೊಡಿ, ಇನ್ನ NOC ಅಕ್ಸೆಪ್ಟ್ ಆಗ್ಲಿಲ್ಲ ಅಲ್ವಾ ಇಲ್ಲಿ ಮ್ಯಾಮ್. ಕೊಡ್ತಾರೆ ಬಂದ್ಮೇಲೆ, ಅದರ್ ಸೈಡ್ ಇನ್ಫಾರ್ಮ್ ಮಾಡಬೇಕು. ಒಂದ್ ಡೇಟ್ ಅಡ್ಜರ್ನ್ ಆಗುತ್ತೆ ಹೋಗಿ ಅಷ್ಟೇ. ನೀವ್ ಹೇಳೋ ಸಬ್ಮಿಷನ್ ಎಲ್ಲ ಬರೋದಿಲ್ಲ, ಸುಮ್ನೆ ಅಡ್ಜರ್ನ್ ಆಗುತ್ತೆ ಅಷ್ಟೇ. ಮೇ ಬಿ 12th 10th ಮಾರ್ಚ್ ಇಲ್ಲ 17th ಮಾರ್ಚ್ ಎರಡರಲ್ಲಿ ಒಂದು. ಹೇಳಿ ಸರ್. 54 ಇದೆ ಮಧ್ಯಾಹ್ನ ತಗೋತಾರೆ. ನಾಗರಾಜ್ ಇದು 230 ಆಮೇಲೆ 230 ತಗೊಳ್ಳಿ. ಅದಕ್ಕ 20 ಹಾಕಿ ಸರ್. ಹಾಕಿರಿ ಸಂಜೆವರೆಗೂ ಬಿಡಕ್ ಮುಂಚೆ ನಮ್ಗೆ ಹೇಳಿ ಪೋಸ್ಟ್ ಮಾಡಕ್ ಮುಂಚೆ. ನೀವು ಹಾಕೋದೊಂದು ಹಾಕಿ ಯಾವುದು? ಟೂನಲ್ಲಿ ಅಲ್ಲ ನಾನು ಅದೇ ಅಂತ ಅಲ್ಲ ಇದು ನೀವು ದಿನ ಮಾಡಿರ್ತೀರ. ನನಗೂ ಅದೇ ಅಂತ ಅನ್ನಿಸ್ತಿದೆ, ನನಗೂ ಗೊತ್ತಿಲ್ಲ. ಇಲ್ಲಿ ಲಿಸ್ಟ್ ಕೊಡ್ತೇನೆ ಗೊತ್ತಿಲ್ಲ ನನ್ನ ಏನ್ ಮಾಡಲಿ ಇವಾಗ ಗೊತ್ತಿಲ್ಲ. ಎಲ್ಲ ಗೊತ್ತಿಲ್ಲ. ಆ ಕನೆಕ್ಟೆಡ್ ಜಾಗ ಬಿಟ್ಟಾಗಿ ಗೊತ್ತಿಲ್ಲ. ಕನೆಕ್ಟೆಡ್ ನಂಬರ್ ಗೊತ್ತಿಲ್ಲ, ನಿಜವಾಗ್ಲೂ ಗೊತ್ತಿಲ್ಲ. ಗೊತ್ತಿದ್ರೆ ಏನು ಹೇಳಕ್ಕಿಲ್ಲ. ಆಯ್ತು ಹಂಗೆ ಮಾಡಿ, ಅಷ್ಟೇ ಹಂಗೆ ಮಾಡಿ. ಗೊತ್ತಿರೋದನ್ನ ಟಕ್ಕಂತ ಹೇಳ್ತೀವಿ, ಗೊತ್ತಿಲ್ಲ ಅನ್ನೋದು ನಾನು ಏನು
ಇದು ಮಾತ್ರ ಬ್ಲಾಂಕ್ ಬಿಟ್ಟೆ ಕಳಿಸಿ.
ಅದು ಏನು ಸಿಗ್ತದೆ
ಸರ್? ಇಲ್ಲ ಇನ್ನೂ ತಗೊಂಡಿಲ್ಲ. ಸೆಕೆಂಡ್ ಲಿಸ್ಟೇ ಫಸ್ಟ್, ಆಮೇಲೆ ಫಸ್ಟ್.
ನಾನು ಫೈಲ್ ದಟ್ ಮೆಮೊ ದಟ್
ಫಸ್ಟ್ ಧಾರವಾಡ, ಕಲಬುರ್ಗಿ ಪಾಸ್, ಆಮೇಲೆ 230 ಮ್ಯಾಟರ್ಸ್ ಪಾಸ್ ಓವರ್ಸ್, ಆಮೇಲೆ ಲಿಸ್ಟ್ ಕಂಟಿನ್ಯೂ, ಆಮೇಲೆ ಲಿಸ್ಟ್
ಹಾಕಿದೆ.
ಇದರಲ್ಲಿ ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಹಾಕ್ಬೇಕಾಗಿತ್ತು. ಇಲ್ಲ ಕ್ಯಾಲ್ಕುಲೇಷನ್ ದಟ್ ವಿ ಆರ್ ನಾಟ್ ಏಬಲ್ ಟು ಡು ವಾಟ್ ವಿ ಡಿಸ್ಕಷನ್. ದಟ್ ಇಸ್ ನಾಟ್ ಅವರ್ ಪರ್ವ್ಯೂ. Parameters you wanted to set.
ಯಾರು? ನನಗೆ ಗೊತ್ತಿಲ್ಲ, ನಾನು ಹೇಳಿದ್ದೀನಿ. ನೀವು ಉಳಿಸ್ಕೊಂಡ್ರೆ ನಾನೇನು ಮಾಡಲಿ? ನಾನಂತೂ ಹೇಳ್ಕೊಂಡ್ರೆ ಹೇಳ್ಕೊಂಡು ನೀವೇ ಮಾಡಿದ್ರೆ ನಂಗೆ ಗೊತ್ತಿಲ್ಲ.
Type written.
ನಾನು ಗೊತ್ತಿಲ್ಲ.
Matter of adjournment.
Dharwad bench matters. Kishan GS.
The direction of this honorable board and sir, the copies. The judgment of which I have sought review is that, my lord, your lordship has directed the authorities to consider my representation, my lord. I had sought that my representation should be considered in the light of the fresh circular issued by the central government. Since that word is missing, my lord, they have said that option is that obligation is not on us. That is the only thing, my lord.
The circular is issued, it's in accordance with law, that would have to be considered.
It has to be considered, but your lordship may kindly see, they have issued an endorsement.
Yes, who is appearing for the respondent?
One Mr. Doreraj.
Nobody is here.
In fact, I have called and also informed them, my lord.
And wakalat is also not filed. None appears for the respondent. If none were to appear for the respondent on the next date of hearing, matter would be taken up.
Public work is involved in this matter, my lord. Regarding construction of road, my lord. My only request is, my lord, this representation has to be considered in the light of the fresh circular issued by the government. That's all, my lord. In fact, that is made applicable even to the ongoing projects also.
Mr. Counsel, you must have the basic courtesy to understand that the other side has to be here. There's no wakalat filed on their behalf. So do you want us to deal with all your matters without you being present? We'll do that. Our matter or that basic courtesy to the other counsel you should have. None appears for the respondent. One more opportunity is granted for the respondents to appear. If none were to appear for the respondent next date of hearing, matter would be taken up for consideration on the basis of the submission of the counsel for the petition. We list on 5th March.
Kalburgi bench matter. Naresh P. Kulkarni.
CGP.
My lords, in this case, a memo
Yes,
has been filed, my lords. The memo dated 1/12/2025. It
One?
is placed before the Honorable Court. 1/12/2025.
112.
Please, 1/12/25. It was filed in the Kalburgi bench.
112. Yes, madam.
My lords, direction was to development of the software regarding allotment of the site, my lords. In a letter is given by the Undersecretary to the Government Advocate in page number 3, my lords.
Yes.
May I read, my lords? ಪ್ರಕರಣದಲ್ಲಿ ತಂತ್ರಾಂಶಗಳನ್ನು 3 ತಿಂಗಳ ಒಳಗೆ ಅಭಿವೃದ್ಧಿಪಡಿಸುವಂತೆ ಆಯುಕ್ತರು, ನಗರಾಭಿವೃದ್ಧಿ ಪ್ರಾಧಿಕಾರ ಹಾಗೂ ನಗರ ಗ್ರಾಮಾಂತರ ಯೋಜನೆ ಆಯುಕ್ತಾಲಯ ಮತ್ತು ಜಂಟಿ ನಿರ್ದೇಶಕರು KMDS. The Karnataka Municipal Data Society has been given the power for the purpose of development of the software.
3 ತಿಂಗಳು ಆಗ್ತಾ ಬಂತು.
They have sought for 6 months. The last para, what they have stated that 6 months time they have sought for product.
6 ತಿಂಗಳು.
6 ತಿಂಗಳು ಅಂತ ಹೇಳಿದ್ರು.
For the requirements of development.
Development of software.
So what is the status as on today?
Thereafter, we have not been communicated regarding.
What is the status as to what has happened? Cannot be saying 6 months and it gets adjourned, and after 6 months you again say 6 months. Give us the status.
I'll get the information regarding the status.
A memo dated 1/12/25 has been filed by learned SCGP. A page of the said memo indicates that in terms of letter dated 28/11/25, 6 months is required to develop and implement the project software. Nearly 3 months having elapsed from that date, the current status report has not been placed on record. Hence, relist on 5th March to enable learned SCGP to place on record the current status.
230 matters. It's number 2, serial number 60.
60.
Sampath A.
Mr. Monish.
He served a copy on me today. No?
He has served a copy on you?
Yes, now.
File ಮಾಡಿದ್ದಾರೆ written submissions.
No, he served it. He was carrying in his hand.
Okay. Where is Omkar is also not here. Pradeep is also not here. Received. Written submission on part of the petitioner as also respond number 1 and 2 have been filed, reserved for judgment.
But can I make one submission, Manoj? Yes. But it's in WP 8296 of 2005. There is no challenge to section 77. Manoj.
Yes.
Could that be de-linked, Manoj? Could that be de-linked, Manoj?
We'll deal with both of them together. You argued both of them. Now you can't say dealing.
Because there is
after
no
arguing
challenge.
everything.
No, I'm sorry, Manoj.
Challenge
Because
is not
that was
you
not brought to the
both
note.
of you have argued both the matters.
There was no challenge to that. That's why I wanted to mention.
It's only for filing of the written submissions.
Yes.
Serial number 61. Speaker PK.
Waiting for the petitioners.
Connected matters.
Methodology of calculation. '61.
Mr. Mahantesh appears in the matters. He mentioned that he's filed a memo and there's a calculation within that. Copy ಕೊಡ್ತಾರೆ ಅಂದ್ರೆ type ಮಾಡ್ಬಿಟ್ಟು ಹಾಕ್ಸಿದ್ದಾರೆ.
Illi Mahantesh illa. Nobody is here.
As per the
ಪಾಸ್ವರ್ಡ್
ಯಾರು ಇಲ್ಲ ಬೋಪಣ್ಣವ್ರನ್ನ ಹಿಡಿಯೋದು.
ಇಲ್ಲ ಪಾಸ್ವರ್ಡ್ ಮಾಡಿ ಬರ್ತಾರೆ.
ಗವರ್ಮೆಂಟ್ ಅಂದ್ರೆ ನೀವು.
Your lordship may kindly pass over the matter.
Pass over. Manish, we have reserved for.
Pass on my. It's ready, Manoj. I passed it on to the other side.
File ಆಗಿದೆ ಅಂದ್ರು.
ಇಲ್ಲ ಅದು ಇಲ್ಲ.
61 ಹಾಸನ್ ಇಲ್ಲ PP.
ಸರ್ ಇದು ಸಿನಾಪ್ಸಿಸ್ ಅಂಡ್ the judgments.
ಇವಾಗ ಫೈಲ್ ಮಾಡ್ತಾರೆ.
ಸರ್ ಯಾವ ಮ್ಯಾಟ್ರಿಕ್ ಮಾಡ್ತಿದ್ದೀರಾ?
Counsel for the 61. Counsel for the petition already filed this synopsis of arguments. Counsel for respond number 1 and 2 has today filed this synopsis of arguments. Copy having been served on the counsel for the petitioner. Oral arguments having already been heard, reserved for judgment. 61 pass over.
ತಮ್ಗೆ ಇನ್ನೊಂದು ಹೇಳೋದಂದ್ರೆ ನಂದು ಸೆಲ್ಫ್ ಗವರ್ಮೆಂಟ್
ಮೈಕ್ ಅಲ್ಲಿದೆ.
Similar lease deed I have produced before my lords for kind consideration, which is approved by the deputy commissioner. I have produced before this court. My lords may kindly take note of that, and
We'll take note of that, but the state has to tell us what is the methodology of calculation. There must be a norm for it. Each CMC cannot do it by itself.
Yes, my lord.
Like
Now
what we
it
saw
is
in
only
one
public
other
premises.
matter where they ನಿಮ್ದೇನಾ ಅದು ಇನ್ನೊಂದು
ಇಲ್ಲ ನಮ್ದಿನ್ನೇನಿಲ್ಲ ಇನ್ ವಾರದಲ್ಲಿ ಮುಗ್ದೇ ಇದ್ರೆ ಮತ್ತಿನ್ನಿದೆ ತಮ್ಮ ಮುಂದೆ ಮುಗಿಸ್ಕೊಳ್ಳೋಣ ಈ ಕೇಸ್ನ ಅಂತ ಆತರ ಎಲ್ಲ ಅಷ್ಟಕ್ಕೆ
ಫರ್ದರ್ ಹಿಯರಿಂಗ್ ಅಲ್ಲೇ
ಅದಕ್ಕೆ ಆತರ ಎಲ್ಲ ಅಷ್ಟರಲ್ಲಿ ಏಳ್ ಮ್ಯಾಟರ್ ಅಲ್ಟಿಮೇಟ್ಲಿ ಇಟ್ಸ್ ಅವರ್ ಪ್ರಾಪರ್ಟಿ ವಿ ಹ್ಯಾವ್ ಲೆಟ್ ಇಟ್ ಔಟ್ ಟು ದೆಮ್.
Shankar, what we are saying is each CMC, each TMC is doing on its own.
ಇಲ್ಲ ತಾವು ಬಂದಾದ್ಮೇಲೆ ಸ್ವಲ್ಪ ಬದಲಾವಣೆ ತಾವೆಲ್ಲ 20 days ಅಲ್ಲಿ ಹಾಕದೇ ಇದ್ರೆ ಇಟ್ ಇಸ್ ಡೀಮ್ ಟು ಬಿ ಕ್ಲೋಸ್ ಅಂತ ಮಾಡಿ ದಿನ ಎಲ್ಲರೂ ಆಫೀಸಿಗೆ ಬರಕ್ ಶುರು ಅದು CCC ಬೇರೆ ಇದ್ರಲ್ಲಿ ಬೇರೆ ಬರ್ತಾ ಇದೆ ಈಗ ಥಿಂಗ್ಸ್ ಹ್ಯಾವ್ ಚೇಂಜ್.
ಮೊನ್ನೆ we have been seeing, so ಮೊನ್ನೆ was one glaring example where they issued a notification for auction saying only existing tenants shall participate because there are no norms by the state. State is saying only circular has to be followed. Circular ಅಲ್ಲಿ ಇದು ಹೇಳಿಲ್ಲ, restriction ಏನಿಲ್ಲ, it's left to interpretation is
ಬರುತ್ತೆ. ಆಯ್ತು ಸರ್ ಬರ್ಲಿ.
ರಂಗೋಲಿ ಕೆಳಗೆ ನುಗ್ಗದ್ ಬಹಳ ಈಸಿ. ಅದಕ್ಕೆ ಅವ್ರು ಹೇಳ್ಬಿಟ್ರೆ ಹೆಂಗೆ ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಅಂತ. It will be available for everybody.
So that in future also.
In future it is, you know what we are expecting, we are only assuming that everybody is acting bona fide. We are not attributing any mala fides. If that calculation is given by Mr. Mahantesh,
system creator,
everybody follows the same calculation. So there's no Article 14 violation for anybody. Yes, Mahantesh.
Last time we have filed the method of calculation.
File ಮಾಡಿದ್ದೆ.
When earlier the copies were not visible. Thereafter I filed it with the typed copies, my lord. Last date of hearing.
ನಮ್ದು ಇವರೇ ತಗೊಂಡ್ಬಿಟ್ರು.
ಅದು ಇಲ್ಲ.
ಇವರೇ ತಂದೆ ಕೊಟ್ಟು.
It's the same circular of 2009.
Yes. Other than that, we have no documents or even to say that the methodology to calculate the rents or fixation, my lord.
So ಇದ್ರಲ್ಲಿ ಹೆಂಗ್ ಕ್ಯಾಲ್ಕುಲೇಟ್ ಮಾಡೋದು ರೆಂಟ್? Which is the provision?
There is some illustration, my lord.
Page?
Page 2. ಸಂದರ್ಭ ಅಂತಿದೆ.
So ಸಂದರ್ಭ 1.
ಸಂದರ್ಭ 1. ಅಂಡ್ ಇತರ ಸ್ಥಳೀಯ ಸಂಸ್ಥೆಗಳ ಖಾಲಿ ಜಾಗದಲ್ಲಿ ನೂತನ ವಾಣಿಜ್ಯ ಸಂಕೀರ್ಣ ನಿರ್ಮಾಣ ಮಾಡುವ ವಿಲೇವಾರಿ ಮಾಡುವ ಸಂದರ್ಭಗಳಲ್ಲಿ ಸ್ಥಳೀಯ ಸಂಸ್ಥೆಗಳು ವಿವಿಧ ಯೋಜನೆಗಳಲ್ಲಿ ನಿರ್ಮಿಸಿದ ವಾಣಿಜ್ಯ ಮಳಿಗೆಗಳ ಕರ್ನಾಟಕ ಸಾರ್ವಜನಿಕ ಸಂಗ್ರಹಗಳ ಪಾರದರ್ಶಕ ಅಧಿನಿಯಮ ಸೋನ್ಸೋ ಹೊರತುಪಡಿಸಿದ ಸೋನ್ಸೋ ಲೀಸನ್ನು 12 ವರ್ಷಗಳ ಅವಧಿಗೆ ಮತ್ತು ನೀಡತಕ್ಕದ್ದು. ಮಳಿಗೆಗಳು ನಿಧಿಸಾತ್ಮ ನೀಡುವಾಗ ಸ್ಥಳೀಯ ಸಂಸ್ಥೆಯ ಮಾಸಿಕ ಸೋನ್ಸೋ ಬಾಡಿಗೆ ಮತ್ತು ನಿಗದಿಪಡಿಸುವುದು. 6th ಹೆಲ್ಪ್ ಮೈ ಲಾರ್ಡ್ಶಿಪ್. ಮಳಿಗೆಗೆ ಕನಿಷ್ಠ ಮಾಸಿಕ ಬಾಡಿಗೆ ಅಥವಾ ವಾಣಿಜ್ಯ ನೆಲಬಾಡಿಗೆಯನ್ನು ಎಕ್ಸ್ ಪ್ರಯೋಗದ ಚದರಡಿಗೆ ಸೋನ್ಸೋ ಆಧಾರದ ಮೇಲೆ ಕೆಳಕಂಡಂತೆ ಲೆಕ್ಕಾಚಾರ ಮಾಡತಕ್ಕದ್ದು. ದಿಸ್ ಎ ಕ್ಯಾಲ್ಕುಲೇಷನ್.
ಏನಿದು ಸಿ ಅಂದ್ರೆ ಏನು, ಡಿ ಅಂದ್ರೆ ಏನು? ಸ್ಥಳೀಯ ಸಂಸ್ಥೆಯ ಬಡ್ಡಿ ರಹಿತ ಕನಿಷ್ಠ ವಾಣಿಜ್ಯ ಮಳಿಗೆ ನಿರ್ಮಾಣ ವೆಚ್ಚದ ಶೇಕಡ 25ರಿಂದ 100ರಷ್ಟು ಆಧಾರದ ಮೇಲೆ.
8 ಅದರಲ್ಲಿ
5 ಅಲ್ಲಿ ಇದೆ.
ಓನ್ಲಿ ರೆಫರೆನ್ಸ್ ದೇ ಹ್ಯಾವ್ ಗಿವನ್ ದಿಸ್ ಸಿ ಅಂಡ್ ಡಿ ರೆಫರೆನ್ಸ್.
ಅದ್ರ ಹಿಂದ್ಗಡೆ
ಮೇಲಿದೆ 5 ಅಲ್ಲಿ ಇದೆ. ಸ್ಥಳೀಯ ಸಂಸ್ಥೆಯ ಬಡ್ಡಿ ರಹಿತ ಮರುಪಾವತಿ ಠೇವಣಿಯನ್ನು ಲೋನ್ which is taken, the interest on it, ವಾಣಿಜ್ಯ ಮಳಿಗೆಯಲ್ಲಿ ನಿರ್ಮಾಣ ವೆಚ್ಚದ. So ವೆಚ್ಚ will have to be calculated as to cost of construction.
Yes.
And the loan that has been taken. 1.96 into the loan minus
6.96. Oh. Well, this may not be the exact, but it's only a methodology that what they have adopted.
Correct. So they, if you're given some guidelines.
Based on this guideline, my lord, I have filed a lease agreement before this honorable court under my lord's direction. That is on 15/7/25 along with an affidavit of the commissioner.
15/7/25.
15/7/25. It's one photo ella hakidini ನೋಡಿ. This same last document. Last document is ಬಾಡಿಗೆ ಕರಾರ್ R7.
ಬಾಡಿಗೆ ಕರಾರ್.
ಅದರಲ್ಲಿ 2ನೇ ಪ್ಯಾರ 4ನೇ ಲೈನ್ ನೋಡ್ಬೋದು. ಮತ್ತೆ ಮಾನ್ಯ ಜಿಲ್ಲಾಧಿಕಾರಿಗಳು ಅಧಿಕೃತ ಜ್ಞಾಪನಾ ಪತ್ರ ರಂತೆ 12 ವರ್ಷಗಳ ಅವಧಿಗೆ ಮರುಪಾವತಿ ಇಲ್ಲದ ಮುಂಗಡ ಠೇವಣಿ ಮಹಾಯಾನ ಬಾಡಿಗೆ. ಇದು ನಮ್ಮ ಸ್ನೇಹಿತರಿಗೆ ಓದ್ದಂಗೆ 12 years was the
6,200 ಗಳಿಗೆ.
6,000.
But ಇದು whether this formula has been followed.
Not formed. This is in 1970s and 80s.
Correct.
I made a request to my lords saying that they are paying paltry 50 rupees and 75 rupees.
Exactly.
Some direction. My lords then said,
no, as per this item 5 and 6, what is the valuation that it comes to?
Bang opposite to the present building, it is 6,200 we have entered into in the year 2013. So I was requesting my lord.
We don't want to go by ad hoc on that. It's been fixed. At that time, it's been fixed. This was not there. Now this circular is there, which is saying at item number 6, this is the formula which is to be used. So you have these details with you.
Same formula we have entered into.
So ಅದರ ಪ್ರಕಾರ ಇವ್ರದ್ದು ಎಷ್ಟು ಬರುತ್ತೆ?
ಇವರು 6,200 ಇಂತಲೂ ಜಾಸ್ತಿ. Extent is more.
ಇದ್ರದ್ದು exact ಹೇಳಿ. 1.96 into C minus 0.96 into D, which is given in CL number 5 divided by 110.26. ಇದು ಎಷ್ಟಾಗತ್ತೆ?
ಕ್ಯಾಲ್ಕುಲೇಟ್ ಮಾಡಿ
ಕ್ಯಾಲ್ಕುಲೇಟ್ ಮಾಡಿ ಹೇಳಿ. These are all going to be
permanent.
Objective criteria. There is no subjective. This one. So if you have the objective, only variable is what is the
extent of land.
What is the loan that you have sought, you got, and what is the interest? ಅದೆಲ್ಲ ಸ್ವಲ್ಪ ಚೇಂಜ್ ಆಗುತ್ತೆ. You might have got for 6%, somebody else must have got for 7%. That difference may happen, giving each CMC a little bit of discretion to cater to their requirement. But the basic formula has been laid down. And when they have laid down this, it's a policy.
Based on this, I will come back with a figure as to each how much there.
Correct. ಇವ್ರಿಗೆ ಪ್ರತಿಮಾ ಅವ್ರಿಗೆ ಹೇಳ್ಬೇಡಿ, when they are doing the SOP now for KDTP Act ಪ್ರಕಾರ SOP ಮಾಡ್ತಾ ಇದ್ದಾರೆ for this auction and OFR. ಇದನ್ನು include ಮಾಡಕ್ಕೆ ಹೇಳ್ಬಿಡಿ ಅದರಲ್ಲಿ. So in the SOP it will be clear as to how it is, give proper examples and calculation ಕೊಟ್ಬಿಟ್ರೆ, each of them will follow that.
Let there be direction. Let there be a record.
No, we've already directed in another matter. This particular thing was not covered.
Yes.
SOP in terms of 2009 and 30.
Yes.
This also should be there.
Yes.
And AG has filed a memo dated 12/2/2026. His submission is that in terms of the circular dated that the circular dated 26/10/2009 provides for the methodology of calculation of the lease rentals which could be charged by any of the municipal councils or corporations. He refers to subject 1, point number 6, to state that the calculation has to be done in that basis so far as it comes under subject 1. And similar instances have been given in respect of the other subjects. Shri A. Ravi Shankar, learned counsel for respond number 1 and 2, seeks for and is granted a week's time to provide the calculation insofar as the present petitioner are concerned by following the said formulae released on 25th February. Great. Interim order earlier granted is extended to last.
Serial number 62, BM Halaswamy.
Respondent 3, case specific.
For petitioner in this case, my lord.
Yes.
62, sir, I may request some more time. We'll do it.
My lord, already several time has been given.
Some more time.
They have to file the affidavit.
3, 4,
ಆಗಿದೆ.
5, 6 adjournments.
Some on week I'll comply personally.
Because you are the state doesn't mean you'll get adjournment like that.
We're not on that line, my lord. I'm not on that line, my lord.
Who is to give you the instructions?
My lord, what happened now? The burden shifts onto the pollution board, and because it's the direction was
Pollution Control Board is saying that you have to pass orders.
My lord, what happened?
If you pass orders, they'll implement it.
My lord, then the home department may not have that power to pass orders. If it is only regulation of the.
Somebody must have the power.
That's what.
Who has the power?
My lord, as of now, the direction is to the home department. I'm the consultation is going on, and I keep on getting instructions. Maybe 1 week time, my lord, I'll be able to place some records before lordship.
1 week ಅಂತ 6 ಸತಿ ಆಗಿದೆ. 6 times. So next 1 week of 7 days, 7 adjournment will be there. So next week, if you don't get the instruction, who do we ask to be present? Can't be adjourning like this.
Additional Secretary, Home Department.
Home Department.
Additional Secretary, Home
ಮತ್ತೆ
Department.
Home Department ಹೇಳ್ತಾ ಇದ್ದೀರಾ.
But that is what, my lords, the directions may not be able to comply with the Home Department because this is a policy issue.
So which is the department?
To that extent, I'll place 1 week, my lordship. As of now, my lordship, direct that an additional secretary to be present.
I want to call somebody just for the sake of calling.
1 week, my lordship.
It must be.
I'll.
And we don't want them to come also. We want compliance.
I agree, my lord.
If you report compliance, they don't need to come.
My lord, 1 week, my lord, I'll place some constructive documents or information before this, our lordship.
Pollution Control Board is saying they can't do anything without a government order. Now, if government, you are still deciding who is the authority.
No. In some extent, my lord, if there is one matter pertains to the Chinnaswamy Stadium, there is some guidelines are there. What is the parameters to be adopted? That I received it, but I'll place it those documents constructively within a week, my lord.
Parameters are all there in noise pollution.
This is pre-production case. This is what the case is, my lord. 1 week, I'll do something and I'll place all the documents.
They do only post-mortem, as we said in the morning. Only if somebody complains, they'll try and go there.
And what happens?
They say we don't have number of people, we can't go.
Have to have made some efforts to write and communicate with the departments, my lord.
They don't have the number of people that is required. Their staff is lesser than the BBMP. BBMP only can't do anything about the illegal construction. What will they do about this noise pollution? We have to take proactive stand. So we'll ask the ACS to appear then.
Weeks time, madam, there are lordship. I leave it to the
Weeks time. And AGA once again seeks for a short accommodation to make a submission. 6 adjournments have already been granted to the learned AGA in this regard. Though no further indulgence is required to be extended, one last opportunity is granted to the learned AGA to secure instruction and make a submission. If submissions are not made by 26th February, the Assistant Chief Secretary and Secretary Home shall remain present before this court through video conferencing. Needless to say, if compliance is made, his presence would not be required.
Number 63, Girish Priya.
Here for petitioner. This is a case, my lord. The petitioner is a resident of Bangalore, working in the private company. While he was going towards his.
All those you have argued, only thing now they are saying is, since you are traveling in a vehicle, the coordinate
his own
benches.
vehicle towards his office. His own vehicle towards his office.
Whichever, he is traveling in a vehicle. What they are saying is the coordinate benches have held. In such a situation, you will have to go under MACT. And not come before this court.
I'll argue on this point.
Yes.
I'll argue. Lord, the respondent has contended in the reply statement, it is an act of God. But it is not so. My lord, my argument is, Lordship, kindly take in the writ petition, annexure K. The fourth respondent has written a letter to the BBMP saying that the branch of the tree would fall down at any point of time and would cause public. Lordship, kindly take page number, annexure K, page number
51.
Annexure K, my lord.
51.
Please. Yes, 51. The fourth respondent has written a letter to the BBMP saying that the branch of the tree would fall any time, hence requested for permission to cut the dangerous. Since the respondents are very well aware about the facts of the case and the situation and condition of the tree, they did not take any action. Hence, it is the negligence on the part of both the respondent, for which the petitioner has been now, and it is not any fault or negligence of the petitioner. Now he has to suffer, and not in the admitting their fact. The BBMP and also school management has given a.
Girish, you have argued all these things.
Please. And regarding maintenance between, Lord, I am giving judgment. Since the Honorable Supreme Court and also this Honorable Court held in number of cases, the easy and safe access of the road is a fundamental right granted under the article, under the Constitution.
What do you want to rely on?
Lordship, judgment 3, page 20.
Judgment 1 you don't want to rely on?
I am also relying. Otherly compensation, judgment 1, my lord, the Supreme Court.
So you want to first rely on 3 and then come?
I'm
first 3 barbeka?
First I'll take.
Page number.
In the case of Municipal Corporation of Delhi, Sushila Devi.
Page number madbekappa. You don't even page number the set. Where do you find that decision like this?
Very first judgment, very first page. Very first judgment, first page.
Yes.
In the case of the Honorable Supreme Court, in the identical matter has awarded.
Show us the facts, please.
No, Lordship, head note B.
Head note alla facts to see from the judgment.
First page it starts from second page, Lordship, kindly take. I'm very sorry, my lord. I will take my colleague assistant to read since I left my Kannada. I will take my assistant. Sorry, my lord. I'm very sorry.
Yes.
Very sorry.
Yes.
Second page start.
ಇಲ್ಲ ಒಂದು ಕೆಲಸ ಮಾಡಿ ಫಸ್ಟ್ ಇದು ಪೇಜ್ ನಂಬರ್ ಮಾಡಿ because we won't be able to find it with so many judgments in the list. We'll have it on Saturday. You argue it on Saturday. Saturday working day idella. Please. And counsel for the petitioner has filed a memo with citations. He seeks permission to number the same. He is so permitted. Relist on 21st.
Personal inconvenience on Saturday, any other day.
We don't know what inconvenience. Saturday, we have to only hear him. You already argued it is a rejoinder.
Yes, sir.
Saturday.
Serial number 64 adjourned, 65.
Yes, where my lord, layout is approved by Mandya Urban Development Authority. The layout is released. Layout plan is approved. The sites are released. The direction with the request to the Gram Panchayat, that's the third respondent, to mutate the name of the developer.
Entire 100% has been released.
Yes, my lord. Which my lord would find at page number 101, annexure J.
101.
Volume 1, my lord.
Yes. 26/9/24.
Please, my lord. If I may persuade my lords to kindly, for a moment, page number 102. Lord, the second paragraph from the bottom, my lord, there was one OS filed by one of the private individuals of the village, claiming, my lord, that there was a halla or the kalwe which was flowing adjacent to the layout. It has been encroached on the hill. No injunction order was granted. Lord, in fact, it's my case that he was set up by the panchayat himself. Panchayat itself, which I'll substantiate, my lord. Survey has been done.
A very strong statement.
Yes, I'll also make a submission, my lord, that at every stage, panchayat is assigning different reason for not transferring the kata, which I'll take my lord's. Lord, the MODA, my lord, basically would say, subject to the outcome of this OS, the layout plan is sanctioned and the properties are released. Lord, this was placed before the panchayat. My lord, the panchayat would pass a resolution which is produced along with the statement of objections. If I may persuade my lords to kindly take the statement of objections.
Statement of objection file madidare.
The earlier council has filed it, my lord.
22nd August.
Bharti. Statement of objections. So many volumes.
Lord, it's
Sale deeds they have produced.
sale deeds, and also the endorsement is issued to all the 139 site owners now.
5 volumes.
So all those things have been produced. Otherwise,
how many
it's only one volume which would be relevant.
How many trees did you cut for this?
Lord, there was no tree. It was actually a field. It was an open field which they were in.
For these 5 volumes.
5 volumes are actually not required.
Yes.
If I may persuade my lord to kindly take the
Statement of objections by whom?
My lord, by the third respondent.
Third respondent.
Respondent number 2 and 3, please.
2 and 3.
Please.
MS Devraj at 5.
Yes, my lord.
Now you are appearing, Mr. Anand.
Please.
Yes.
In this case.
Lords may kindly take annexure R1, which is the resolution, my lord.
R1. Yes.
R1, which is dated 24/10/2024. Lords may kindly come to page number 13, my lords. My lord, item number 11. It's handwritten. I'll take my lords through the handwritten portion because it would be relevant. My lords, my lord gets it. Item number 11. Kindly come to it. Start from there, my lords. My lord, basically they would say in this resolution.
No, basically, I'll read it.
Please, my lords. Kindly come to page number 14, my lords. I'll not read the entire this one. Kindly come to the last portion, my lords. My lords, ಎಂದು ತಿಳಿಸಿ ಈ ವಿಚಾರದ ಬಗ್ಗೆ ಸಭೆಯಲ್ಲಿ ಸುದೀರ್ಘವಾಗಿ ಚರ್ಚಿಸಲಾಯಿತು. About 12-13 lines.
From the top.
From the top. ಈ ವಿಚಾರದ ಬಗ್ಗೆ ಸಭೆಯಲ್ಲಿ ಸುದೀರ್ಘವಾಗಿ ಚರ್ಚಿಸಲಾಯಿತು.
ಒಂದು ನಿಮಿಷ. ಹ್ಯಾಂಡ್ ರಿಟನ್ ಗೊತ್ತಾಗಲ್ಲ.
ಹ್ಯಾಂಡ್ ರಿಟನ್, ಹೌದು.
ಇಲ್ಲಿ
12 or 13 lines, if I may. 1, 2, 3, 4.
ಸುದೀರ್ಘವಾಗಿ
ಚರ್ಚಿಸಲಾಯಿತು. ನೋಡಿ, ಸದರಿ ಸಾರ್ವಜನಿಕ ಅರೆ ಸಾರ್ವಜನಿಕ ಉಪಯುಕ್ತಕ್ಕಾಗಿ ಮೀಸಲು ಪ್ರದೇಶವನ್ನು ಮುಂದೆ ಸಾರ್ವಜನಿಕರ ಅನುಕೂಲಕ್ಕಾಗಿ ಸರ್ಕಾರಿ ಶಾಲೆ, ಅಂಗನವಾಡಿ ಕೇಂದ್ರ, ಪ್ರಾಥಮಿಕ ಆರೋಗ್ಯ ಕೇಂದ್ರ, ಕುಡಿಯುವ ನೀರಿನ ಓವರ್ ಟ್ಯಾಂಕ್, ಶುದ್ಧ ಕುಡಿಯುವ ನೀರಿನ ಘಟಕ ಇನ್ನಿತರ ಸಾರ್ವಜನಿಕ ಉಪಯುಕ್ತ ಕಟ್ಟಡಗಳನ್ನು ನಿರ್ಮಿಸಲು ಹಿತದೃಷ್ಟಿಯಿಂದ ಸದರಿ ಮೀಸಲು ಪ್ರದೇಶವನ್ನು ಗ್ರಾಮ ಪಂಚಾಯತ್ಗೆ ಉಚಿತವಾಗಿ ಹಸ್ತಾಂತರಿಸಿಕೊಡಬೇಕೆಂದು ಮತ್ತೊಮ್ಮೆ ನಗರಾಭಿವೃದ್ಧಿ ಪ್ರಾಧಿಕಾರಕ್ಕೆ ಪ್ರಸ್ತಾವನೆಯನ್ನು ಸಲ್ಲಿಸುವಂತೆ ಸಭೆಯಲ್ಲಿ ತೀರ್ಮಾನಿಸಿ ಗ್ರಾಮ ಪಂಚಾಯತಿ ಅಧ್ಯಕ್ಷರು, ಉಪಾಧ್ಯಕ್ಷರು ಹಾಗೂ ಸದಸ್ಯರು ಎಲ್ಲರೂ ಶ್ರೀ ವಜ್ರ ಇನ್ಫ್ರಾಸ್ಟ್ರಕ್ ಪ್ರೈವೇಟ್ ಲಿಮಿಟೆಡ್ ಸಂಸ್ಥೆಯವರು ಅಭಿವೃದ್ಧಿಪಡಿಸಿರುವ ಬಹು ನಿವೇಶನದ ವಸತಿ ಬಡಾವಣೆಯನ್ನು 139 ನಿವೇಶನಗಳನ್ನು ಸ್ಥಳ ಪರಿಶೀಲನೆ ಮಾಡಿ ಈ ಸ್ವತ್ತು ಸೂಚಿಯಂತೆ ನಿಯಮಾನುಸಾರ ಕ್ರಮ ವಹಿಸುವಂತೆ ಸರ್ವಾನುಮತದಿಂದ ತೀರ್ಮಾನಿಸಿದೆ. Basically, my lord, inspect and transfer the kata is the resolution passed and a request to be placed to Muda that all the lands that were in relinquishment deed was executed by me should be handed over. Relinquishment deed is also part of the record. Lord, thereafter, kindly come to page number 18.
18. Yes.
In the middle of the page, my lord, there is a scratch portion. Wherein, my lord, it is written, ಸಭೆಯಲ್ಲಿ ಚರ್ಚಿಸಲು ಬೇರೆ ಯಾವುದೇ ವಿಷಯಗಳಿಲ್ಲವ ಕಾರಣ ಸಭೆಯನ್ನು ಮುಕ್ತಾಯಗೊಳಿಸಲಾಯಿತು. Page number 18, my lord.
Yes.
Yes. Thereafter, my lord, after ending the meeting, my lord, that is scratched off and one more thing is added pertaining to this very same layout. Lord, here in the layout, if I may read that portion, my lord, item number 5. ಸದರಿ ವಿಚಾರದ ಬಗ್ಗೆ ಸಭೆಯಲ್ಲಿ ಪುನಃ ಚರ್ಚಿಸಲಾಯಿತು. ಶ್ರೀ ವಜ್ರ ಇನ್ಫ್ರಾಸ್ಟ್ರಕ್ಚರ್
in the same meeting.
In the same meeting. After concluding the meeting.
So concluding that subject.
Yes, my lord.
And then concluding all the other subjects.
Yes.
It was again taken
It
up.
was again taken up. Lord, this is what they write. ಸದರಿ ವಿಚಾರದ ಬಗ್ಗೆ ಸಭೆಯಲ್ಲಿ ಪುನಃ ಚರ್ಚಿಸಲಾಯಿತು. ಶ್ರೀ ವಜ್ರ ಇನ್ಫ್ರಾಸ್ಟ್ರಕ್ಚರ್ ಪ್ರೈವೇಟ್ ಲಿಮಿಟೆಡ್ ಅವರು ಅಭಿವೃದ್ಧಿಪಡಿಸಿರುವ ಬಹುನಿವೇಶನ ಬಡಾವಣೆಯಲ್ಲಿ ಕುಡಿಯುವ ನೀರಿನ ಓವರ್ ಟ್ಯಾಂಕ್ ನಿರ್ಮಾಣವಾಗಿರುವ ಬಗ್ಗೆ ಕುಡಿಯುವ ನೀರು ಸರಬರಾಜು ಮತ್ತು ನೈರ್ಮಲ್ಯ ಇಲಾಖೆಯಿಂದ ನೀಡಿರುವ NOC ಪಡೆದು ಸಭೆಯಲ್ಲಿ ಮಂಡಿಸುವಂತೆ ಸಭೆಯು ತೀರ್ಮಾನಿಸಲಾಯಿತು. ಅಲ್ಲಿಯವರೆಗೆ ಸದರಿ ಅರ್ಜಿಯನ್ನು ವಿಲೆ ಇಡುವಂತೆ ಅಧ್ಯಕ್ಷರು HS ಸವಿತಾರವರು, ಉಪಾಧ್ಯಕ್ಷರು ನಾಗರಾಜ್ ಅವರವರು, ಕವಿತಾರವರು ಸಭೆಯಲ್ಲಿ ಬಹುಮತದಿಂದ ತಿಳಿಸಿದರು. Basically, they would say, now my lords, that how to construct a overhead tank, water tank, and also get an NOC from the water department, and so also from the sewerage department, which my lord would find at page number 84. This was considered by Muda before, of course, my lord, before granting the sanction. Kindly come to volume 1, page number 84.
Yes.
Lord, this is a NOC issued by Karnataka Nagara Neeru Sarabaraju ಮತ್ತು ಒಳಚರಂಡಿ ಮಂಡಳಿ, which was considered, my lord, and NOC was issued to me. But in the first place, my lord, all this aspect comes before the town planning authority.
So this is Gopalpura Gram Panchayati Karyalaya.
Yes, ma'am.
So it's the same Gram Panchayati.
Please.
ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಪ್ರಕರಣ ದಾಖಲಾಗಿದ್ದು ಏನದು ನ್ಯಾಯಾಲಯದ ಪ್ರಕರಣ?
Not in page number 84, my lord.
84.
84.
ಪ್ರಕರಣ ಮುಕ್ತಾಯ ನಂತರ.
My lord is reading
84 you are referring to. Why you are referring to 84 of volume 1?
Volume 1, my lord. It is the NOC issued by Karnataka Nagara.
This is endorsement, Imbara.
Sorry.
Sorry, this is not yours. Yes, a memo for that. One nimsha. Yours is here. 84.
But in the first place, if I may submit this, but all this aspect of overhead water tank, NOC from all this department is the purview of the town planning department, which is Muda. It has considered all these aspects and it has already sanctioned the layout plan. In spite of that, my lord, the Panchayat would pass such a resolution. But Annexure D, but it was approved, NOC was given to me on 6/3/2024 itself.
Yes.
This was considered and the layout plan was sanctioned to me, my lord, on 26/9/2024. Now the Panchayat would pass such a resolution saying that it cannot be done because I have not constructed a overhead water tank and also NOC has not been obtained, which is not the fact. Now statement of objections is filed. My lord, may kindly take the statement of objections. Initially, my lord, as I said, it pertains to the NOC from the department. Now kindly come to page number 4 of the statement of objections, my lord.
Yes.
Paragraph number D. Kindly see what do they say before this. on 8/20/25, the Grama Panchayat resolved to cancel the kata issued by the earlier Panchayat Development Officer at agenda number 5, taking note that the tar road has not been laid. And the tar road has not been carried out by the developer, and that 139 katas have been issued by the earlier PDO, along with the President, Vice President Committee without site verification within 10 days, without following the laid down rules of Karnataka Panchayat Raj Act 1993 and in violation of Rule 14. Not totally contrary to the resolution.
Rules. What is Rule 14? Is Rule 14 of which rules? Mr. Anil? Anil Kumar? Please. Rule 14 of which rules? Which rule? Para DL ಹೇಳಿರೋದು. Rules of the Karnataka Panchayat and in violation of Rule 14. Rule 14 of which rules?
Panchayat Raj rules.
Your statement of objections.
Please.
Page 4, para D, last line.
Last line, madam. Panchayat Raj Act and in violation of Rule 14 of the Panchayat Raj rules.
ಯಾವ rule? Which rules are you speaking? Yes, you continue until we get it.
Lord,
Find out which rule it is and let us.
No, even I could not trace that rule.
My lord, my submission is this, my lord. There is an alternative remedy, my lord. This is an endorsement challenge before this honorable court. My lord, earlier, my lord, they have filed
authority to issue that endorsement.
My lord,
that is why we are asking the rule. If the rule provides you the power to issue the endorsement, we'll relegate him to the alternate remedy. But his contention is you don't have power and you are acting mala fide. So if you have the power, show us the power.
My lord, there was a collision.
In respect of these aspects.
Please. My lord, there was a resolution passed by the Gram Panchayat to inspect and to issue the e-katas, my lord. My lord, there was a collusion between the earlier PDO and the developer. The entire kata, entire layout was affected in the name of the developer. Therefore, my lord, an action was initiated against the PDO and she was suspended. Now, my lord, immediately, my lord, after getting the kata transferred in his name, my lord, developer has sold entire sites in the name of the petitioners, my lord. My lord, they have sought for a writ of mandamus, seeking for directions to the panchayats to affect the e-katas, my lord. My lord, thereafter, my lord, we have issued an endorsement. Therefore, my lord, they have filed amended writ petition, my lord, and now they are seeking for quashing of the endorsement issued by the panchayat, my lord. My submission is this, my lord. Under Rule 296, Section 269, my lord, alternative remedy is provided.
Tell us on what basis did you cancel a kata which has already been issued? Under what powers did you excise?
Please, my lord.
And kindly see the
there were some irregularities, my lord.
Why we are saying this is we are coming up with all these kind of things where the panchayats are using their office as extortion for anything.
True, my lord. But in this case, my lord,
we'll cancel this. You don't agree to what we say. It's the extortion racket which is become. If you show us the power to cancel it, then we'll relegate it.
My lord, undisputedly, my lord, there was an encroachment of Allah, that is.
No. And that 269 is again the executive officer. Again, that's another extortion. Sorry, we won't agree to that. You show us your power to do this. If that is so, then overriding the actions of the other authorities.
Please, my lord, but they have not complied with the conditions, my lord. They have not constructed the water tank. for
Where is
supply-
that condition? Please show us.
Please.
And where do you get the power in respect of that?
I will verify and accept.
If you don't have the power, that is why 43 proceedings are being initiated against all the panchayat members. And after they get disqualified, they come before us. They go demolish thing, they go do this, they go do all kinds of things. They auction the properties by themselves, private auctions.
True, my lord, but in this case, my lord, there are complaints.
You are holding it, you are a elected representative holding it in trust. You cannot be, especially these panchayats, we are having this issue.
I can understand, my lord, but in this case, my lord, there are serious.
Show us, Mr. Anil Kumar.
There are serious complaints against the
Show us.
encroachments and
Complaints
suits are
different.
pending.
Show us your authority.
Please, I'll verify and
Show us your authority. If you have the authority for the water connection, then we'll accept it.
that's what, my lord. Water tank itself is not constructed.
Who has to take action in respect of that? If at all, firstly, there is no condition to construct a water tank.
I'll ascertain, my lord, wonder what.
You can't impose that kind of a condition.
What is the authority, my lord?
You are no authority under that. Even under the model bylaws, your authority is very restricted. You're finding there's another matter at 4 o'clock in Takiri, where katas have been registered uploading fake documents.
So same thing is happened in this case also.
That's what
There
you
was
are
a collusion between
you're doing.
the officer who was there at that point of time. And without bringing it to the notice of the panchayat, my lord, PDO has transferred the katas in the name of the developer. Because of that, my lord, action has
They've
been
been
issued.
released here, at least it's been released.
Please,
In whose favor will you transfer the kata?
earlier it was transferred in the name of the developer.
Huh.
All 125 sites were
Yes.
transferred in the name of developer by the PDO without bringing it to the notice of the panchayat. my lord.
In whose name was it to be transferred?
We have taken action against.
ಯಾರು ಹೆಸರಲ್ಲಿ ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡಬೇಕಾಗಿತ್ತು? If not the developer who is owning the property.
In fact, my lord, in the resolution,
Not able to understand your
Really,
submission.
without verifying and inspecting the sites, my lord,
Plan sanction has been granted. Inspection has been done by MUDA. MUDA is MUDA andre Mysore alla idu
ಅಲ್ಲ,
Mandya.
ಇದು ಮಂಡ್ಯ.
Mandya Urban Development Authority has released the sites, verifying that everything has been done. That is the report which Mr. Gowda took us through. Who are you now again to inspect?
Now they have given the report, my lord, that survey officer, there is an encroachment of Allah.
Then take action for that.
Please, my lord, that's why, my lord, we are holding this to initiate action, my lord. In the meanwhile, there is an.
You can't be doing this. Now there's third party purchasers who have come. If there's Allah
Developer has
which is,
created third party interest and.
if there's Allah which has been encroached, only that area you can take action, not the entire layout.
Please, my lord, that observation.
Not for all the purchasers.
But for violation of other conditions, my lord,
Show us your, what is the violation? Show us your power.
I'll verify.
Allah,
and I
you
will
have
make-
the power.
Please, my lord, I will verify, my lord, I will ascertain this and I will make my
complete.
submissions by next.
just to complete whatever I was making submissions in. So far as the submission of my learned friend, that the PDO illegally transferred the kata, my lord, in the very same resolution, PDO would write that MUDA has released, approved the layout. It has released all the sites. And there is a rule that has been direction issued by the government that Krayadante kata, that's the endorsement that she, in the resolution, she notes. And she mutates the name of the developer in the kata. Lord, now in the state, in view of the fact that, my lord, they now before this honorable court statement of objection is filed that I have not laid the road. Lord, I have produced the photograph to show that the roads also have been laid. And in fact, my lord, the MUDA has inspected the property and it has approved it. Thereafter, my lord, during the pendency of this writ petition, now an endorsement is sought to be issued, saying that there is a suit which is pending, OS number 190, which I took my lords through, which was also referred by MUDA. In view of that, I am not mutating the kata. So at every stage, my lord, they are giving different reasons for not mutating the kata. It shows that that's exactly the reason, my lord, for the extraneous reasons. And I would not like to go any further to make any submissions on this. For extraneous reasons, they do not want to mutate the kata.
We are not mincing words. This is extortion racket. We are not mincing words.
I'll ascertain, my lord, what is the position.
The power which is bestowed on you is not for doing this.
I can
By
understand.
the citizens.
And
People
my
who
lord,
have purchased those plots, you are putting them into trouble. After release by, if the Urban Development Authority, who is a competent authority, is not
They have
released,
They have
they
released.
will take action. You can inform them.
There are some irregularities, my lord, but only because of that, my lord, this order of holding the
What are
transfer.
the irregularities? So far, only irregularities that Mr. Gowda has pointed out is these four.
They are not talking
Water
about
tank,
the encroachment
not your
of
purview.
Halla.
point that out.
Not your purview. Be that as may, they have been examined and releases. That is the purpose of release. Suit, permanent injunction, what does it matter to you? Allah
Yes,
is the one that you can take action.
please, my lord.
Only for that
Only
limited
because of
area.
that. And construction of overhead tank for supply.
Where is it construction of over tank? How can you impose that construction? You have to construct
Certain,
it
my
from
lord.
your funds.
That was the undertaking, that's what my lord.
but if I may persuade,
You are on notice.
Lord,
We'll direct initiation under 43.
I will verify and I'll
Lord,
certain.
last submission, Lord. Page number 139 of my amendment application. So far as the allegation that I have encroached upon the Allah, the land surveyor, Taluk surveyor was appointed to inspect the spot, the layout. He has submitted a report saying that there is no such endorsement, encroachment. Annexure R. I produced it along with my.
No. In this report, my lord, they say that there is an encroachment of ಖಾಲಿ ಸ್ಥಳದಲ್ಲಿ ರಸ್ತೆ. This is the report. my
ಯಾರ್ದು
lord.
ರಿಪೋರ್ಟ್ ಅದು? ನಿಮ್ದ ADLR.
ಅದು ಮೆಮೊ ಜೊತೆ ಕೊಟ್ಟಿದೆ. That yellow color that is already filed along with me.
ಯಾರ್ದು ಇದು?
Town survey.
Who marked through? ADLR is given a report. Your layout is in which survey number?
Yes.
No, it is in 87, 88 and 89. Sorry, I'll give the exact.
87, 88.
Lord, sorry, 87, 88 and 89 sub numbers.
89 sub. Is Allah which is shown.
And
in this
also
survey.
9-1.
But it flows.
18 of 2. 918 bar 2.
This you can take action. Your authority.
That's why, my lord.
The others you don't have. And this you can take action only on that encroached area.
My lord, if that route is deviated, my lord, if it is kept open, then they have to form a road in the layout itself, where they have already formed the sites and sold it to the private parties.
There's a road formed on this Allah.
Yes.
Where is
That
the
is
layout
having
plan
multiple.
sanction?
Lord would kindly see the layout plan at page number 106. My lord. So,
106.
06. But I don't have the benefit of that.
No, it's already.
It is the same thing that you had been produced earlier, along with memo on 11/11/25.
I don't have a copy of it. I'm sorry.
You know, 106.
106, please. No.
.15 meter road is located there.
Yes. My lord, adjacent to that, my lord, adjacent to that, this halla, this small kalwe which flows through. My lord, now they contend that that has been encroached.
Your boundary is a dotted line of the survey numbers.
Yes.
Boundary is a dotted line. And after that is where
the road is. The road
part of
ಆದ್ಮೇಲೆ
it
ಹಳ್ಳ
is
ಬರುತ್ತೆ.
within the dotted lines, part of it is outside.
Correct.
What they are saying is within your
layout.
Where is the RTC for this survey numbers?
RTC.
RTC produce ಮಾಡಿದ್ದೀರಾ?
ಇಲ್ಲ, I have not produced.
Have you produced?
We have not produced.
What does it show? Is there a kharab idea?
I will verify because.
Place the
first
RTCs on record.
Please.
For the halla, you can take action.
Please.
For the rest of what he has told now, no.
Only because of halla and.
But now from the basis of the road being there, the access will not be there.
If I may persuade my lord to kindly take page number 139 in the same volume, wherein I took my lords through the layout plan.
139.
139.
139 is the Mahazar. It's the report of the Taluk surveyor.
139 is.
39 is.
Kata.
Not in
Form
I'm
11A.
sorry, in the amendment application. I'm sorry.
Amendment
application.
ಅಲ್ಲಿದೆಯಾ?
Which was filed on my lord the 22nd November 2025.
Yes, 22nd November.
Kindly come to
39.
page number 139, Annexure R.
Yes.
Now, this is a report. My lord, kindly come to page number 141, my lords. My lord, ಈ ಬಣ್ಣದಿಂದ ಗುರುತಿಸಿರುವ 141, please.
1.
My lord, may kindly see at the top, ಗೋಪಾಲ್ಪುರ ಮತ್ತು ಮಂಡ್ಯ ಹೋಬಳಿ ಕಸ್ಬಾ so and so, survey number 88, 88, 87, 89 so and so. ಒತ್ತುವರಿ ರಸ್ತೆ ಹಳ್ಳಿಯ so and so ನಕ್ಷೆ. Kindly come to the bottom portion, my lords. ಈ ಬಣ್ಣದಿಂದ ತೋರಿಸಿರುವ ಗೋಪಾಲ್ಪುರ ಕೆರೆಯಿಂದ ಸಾತನೂರು ಗ್ರಾಮದ ಮಂಡೆಯಿಂದ ಕೆರಗೋಡು ಹೋಗುವ ರಸ್ತೆವರೆಗಿನ ರೀಸರ್ವೆ ನಂಬರ್ so and so, and it also includes 87, 88, 89 and all those things. ಮತ್ತು ಮಂಡ್ಯ ಗ್ರಾಮದ ರೀಸರ್ವೆ ನಂಬರ್ 9/8 ಬಾಜು ಗೋಪಾಲ್ಪುರ ಮಂಡ್ಯ ಕಡೆಯಲ್ಲಿ ರಸ್ತೆ ಮತ್ತು ಹಳ್ಳದ ಒತ್ತುವರಿ ಆಗಿರುವುದಿಲ್ಲ ಹಾಗೂ ಈ ಸ್ಥಳದಂತೆ ಹಳ್ಳ ಗ್ರಾಮಸ್ಥರುಗಳು ರೈತರುಗಳು ಓಡಾಡುವ ರಸ್ತೆ ಇರುತ್ತದೆ. They say not only the halla, my lord, the road and the halla both were encroached upon. It was a complaint. So what happens, my lord? There is a layout. After the layout, there is a road. Adjacent to the road, my lord, there is a halla. The complaint was that I had encroached upon the road as well as the halla. The report says, my lord, nothing has been done. Now the report that is sought to be placed before this honorable court, I'm sure, my lords, it has been obtained during the pendency of the writ petition.
We will direct the ADLR to carry out this.
We are open for it, my lords. I have absolutely no objection for that.
Because there is no seal in this, my lord.
The issue in the present matter. The issue in the present matter is as regards the encroachment. One of the issues in the present matter is as regards the encroachment of a halla in survey number 88, 87, 89. Now this is 89/9/8 and
89. The
918 for.
No, I'll give the sub numbers.
What is it?
89/1. The layout which has been formed, my lord, is in 89/1A1.
1/8, 1A2.
1A2 and 1A3.
1A3.
Yes, my lord.
By the petitioner.
No, not by. Now the site owners are before this honorable.
The vendors of the petitioner.
By the vendors of the petitioner. Learned counsel for the petitioner contending that there is no such encroachment, while learned counsel for respond number 2 and 3 contending that there is an encroachment of a halla, resulting in an obstruction to the free flow of water from Yav Lake to Gopalpura Lake.
To Mandya.
Gopalpura Lake, Mandya.
It is not per se a lake, my lord. It's a kalwe which flows.
It's a primary nala coming
Primary
from the
nala.
lake. The submission of Shri J. M. Anil Kumar, Learned Counsel for respond number 2 and 3 is that by encroaching on this halla, a road has been formed thereon, and if the road were to be eschewed from the plan, there would be no access to the sites in the layout. In that view of the matter, I am of the considered opinion that the jurisdictional ADLR could be directed to cause a independent survey of the aforesaid lands and the adjacent lands
Please.
to ascertain the location of the Alla stroke Kalwe stroke Nala or the like, and submit a report. By superimposing the same in the revenue map.
Earlier.
The ADLR, since the order is passed in the presence of both the counsel for the petitioner and respond number 2 and 3, the survey is directed to be carried out commencing from 10:30 a.m. on 26th February 2026. Report to be submitted by 4th March, released on 11th March.
Please.
There will be no requirement for issuance of any further notice to the petitioner and respond number 2 and 3. The petitioners and or the representatives of respond number 2 and 3 could participate, are free to participate
Please.
in the said survey. In the event of their choosing not to do so, they would not be entitled for any equities. Relist on so on. Learned AGA is directed to inform the jurisdictional ADLR about the above order. Idira, you party idira?
No,
State is a party.
State is a party.
State is a party.
State is a party. State is a party, then your name is there. AGA is directed to inform the jurisdictional ADLR about the above order and instruct the ADLR accordingly and file the report as and when received after furnishing copy thereof to the counsel for the petitioner and respond number 2 and 3. We list on so and so date.
It is before further hearing, my lords, has
For
heard
further,
substantially.
we don't know what roster we will go. Okay, there we'll take it out. Further hearing is all.
No, only because my lord heard it substantially, with only dependence on that.
Here, all the matters like this, it will become a.
I'll leave it to the grateful.
Macho.
Serial number 66.
In the meanwhile, RTCs of the subject property to be also placed on record.
I'll place it.
66.
Regarding that overstay of illegal.
Ah.
And 7, void order, earlier order. As directed to draw in SOP to the state. Have to seek a 4 weeks time to draw the SOPs. Based on the FRO letter submitted to the DSGI.
Yes, but 4 weeks is 4 weeks.
4 weeks. I'll do it.
And AGA seeks for and is granted 4 weeks time to report compliance with the direction issued on 21/7/25.
Not 21/7.
Released on
Thereafter, there is
26th
one more.
and further directions issued thereafter.
That 21/7 order we have complied.
Order sheet
13/1.
13/1/2026. 13/1/26.
Yes. Earlier order is complied.
Released on 6th April.
Grateful. Serial number
Much.
67.
Lords, I appear for the petitioner, my lords, in this case.
I have prepared the Ward Sabha meetings. In all,
67. Nimdala.
Yes, sir.
Lords, I appear
67
for
is
petitioner.
Joshua.
Yes, please. I have to continue, my lords, my arguments.
We can't hear you, Mr. Joshua.
Lords, I have to continue my arguments. I have
Yes.
some laryngitis.
Yeah, that's why we couldn't hear you.
Yes, Lord, I'm ready to
So-
understand the arguments.
You'll need some time. The arguing counsel for the petitioner submits that he is unable to address arguments. Relist on
Saturday, my lords.
Saturday, you'll get well by then?
I
Best is Saturday, relist on Saturday. ಏನಾಯ್ತು ಡಿಸ್ಕನೆಕ್ಟ್ ಆಗಬೇಕು. Relist on 21st.
Serial number 68. Ajay ji.
Prakash.
have prepared the Ward Sabha meeting and also its proceedings. Then I have to file it, which could not be filed it in time. Therefore, I pray for at least by Monday. So in the meanwhile, I have to Samanya Sabha and the village.
Is it ready or you have to get
Clerical work ಇದೆ ಸ್ವಾಮಿ ಅಷ್ಟೇ.
clerical work ಇದೆಯಾ? So ಮೇಲೆ ಅವ್ರಿಗೆ ಕೊಟ್ರೆ ಅವ್ರಿಗೂ
ಏನಾಗಿದೆ
ಟೈಮ್
ಅಂದ್ರೆ-
ಬೇಕಲ್ಲ ನೋಡಕ್ಕೆ. They'll also need time to see.
Yes, sir.
ಅಷ್ಟೊಂದು ಪೇಪರ್ಸ್ ಕೊಟ್ರೆ
ಕೊಡ್ತಾರೆ. Code directed me to produce, therefore I am filing.
Same things you don't need to produce. Don't waste paper. Don't waste paper like that.
Yes.
If somebody else has produced, unless there is some interpolation or something, don't produce that.
Yes.
No need to bulk the record. ಸುಮ್ನೆ paper ಬೇಡ.
ಆಗ್ಬೋದು.
ಏನ್ nothing new ಅದ್ರಲ್ಲಿ?
ಇಲ್ಲ ಇಲ್ಲ ಸಭೆ ಏನಾಗಿದೆ ಅದನ್ನು ಕೊಟ್ಟಿದ್ದಾರೆ. ಯಾಕಂದ್ರೆ ನಾನು ಮೊನ್ನೆ 5th ಗೆ ವಕಾಲತ್ ಹಾಕಿರೋದು, ಅವರೆಲ್ಲ ಕಂಟಿನ್ಯೂ ಮಾಡ್ತಾ ಇದ್ದಾರೆ.
ಆಯ್ತು ಇವಾಗ ಮಾಡಿದೀರಾ ಅಂದ್ರೆ ಕೊಡಿ ಅವ್ರಿಗೆ. ಯಾವ ಕೊಡ್ತೀರಾ ಅವ್ರಿಗೆ?
ಈಗಲೇ ಕೆಲವೊಂದು ಕೊಟ್ಬಿಡ್ತೇನೆ ಸರ್. ಇಲ್ಲ ನಾಳೆ ಕೊಡ್ತೇನೆ.
ನಾಳೆ ಕೊಡ್ತೀರಾ? The MS Prakash Land Council for respond number 4. Submit that he wishes to file certain documents. He seeks for 2 days time to do so after serving copy thereof on the council for the petitioner.
Kindly it may take to Monday.
Released on Monday, Tuesday not possible. You can try on Wednesday. 24th.
2:30.
25th, my lords. My request for 25th.
Last 2 days before this roster, if you vote it like that, then it won't happen. Okay, 25th.
25th, my lord.
25th. Okay.
69, Vinod Kumar.
Responded, my lords. Filing a memo of compliance, my lords. Lords, I would want to bring it to my lordship's knowledge that due to inadvertence, my lords, there was a 40-feet road and the commercial usage was lesser than 50 square meters, my lords. But yet the notice came to be issued.
So now you have taken action.
Please, you have taken action.
Land Council for respond number 1 and 2 has filed a memo enclosing the show cause notice, reply to the show cause notice, and the photographs of the property. His categorical submission is that the road width is
more than 40 feet.
More than 40
feet. And the ancillary use is less than 50 square meters.
And the ancillary use being less than 50 square meters, the trade license could not have been issued.
No, my lords, the trade license could be issued.
Could be issued.
Please.
To the extent of 50 square meters.
Yes.
Not for the entire property.
Not for the entire.
Even for the entire property.
Yes.
Could be issued only to the extent of 50 square meters. Illi Satyanand, he was to take the inspection of the software and then get back. The compliance being complete, no further orders are required to be passed.
Great.
Passed over matters. List number 2, serial number 8. Pawan Sham.
Lords have to receive the documents. Date may be given in the next week.
The request to council for the petitioner released on 24th.
Grateful.
Sigata ಅಷ್ಟೊಳಗೆ ಇಲ್ಲ March
1 week's time maybe.
24th.
Grateful, my lord.
Serial number 35. Samat S. Lokre.
Yes, I'll submit the records. My lord. The AE has come, just preparing the memo, the documents.
Also.
230 mood matters. Ravan Madhav.
As I appear for the petitioner, the instant petition is filed challenging the sale and proclamation notice, my lords. It's at Annexure C, my lords.
All of these are that one. Yes.
Yes. My lords, in this impugned notice, my lords, They say that I have an arrears of tax to be paid at around 15,000 rupees, 14,997 ಅಂತ ಹೇಳ್ತಾರೆ. And if I can draw your attention, my lords, to page number 27. The first paragraph, they say that the kata has been clubbed with property number 11/11. So my lords, if you can turn to page number 26, my lords.
You have paid for 11/1.
I've paid for 11/1 and they have issued the notice for 11/5.
Where is the amalgamation order?
My lords, I could not get hold of the amalgamation order because of the impending urgency, my lords. But if I can take your attention to, my lords, page number 19, my lords. It's a tax paid receipt.
You got the amalgamation order at Annexure. Yeah, okay, Annexure A lady that. Yes.
Annexure A is an endorsement, my lords.
Pawan, Shri Pawan Kumar accepts notice for respond number 1 and 2. There is yet another case of amalgamation being carried out and subsequently notice having been issued as regards non-payment of property tax in respect of a property number which has been deleted post the amalgamation. Inasmuch as the property bearing number 11/1 and 11/5 having been amalgamated, the property bearing number 11/5 had been deleted and now notice has been issued for 11/5. Hence, the operation of the auction notice dated 3/2/2026 at Annexure C is stayed till the next date of hearing. The Chief Commissioner and the Special Commissioner IT are directly look into the above issue. Connect with so and so, relist on 23rd.
Grateful, my lords.
Aditya Bhatt.
This is also similar matter, my lord. That is amalgamation in Annexure G, page 40, my lord.
Nimdu amalgamation,
Amalgamation.
Page?
Page 40, 40.
40. The deed of amalgamation order towards. What are the property numbers which got amalgamated?
There are 680. There are two units, 680 and 680/1. That is husband and wife.
680, 680/1.
So, in view of that amalgamation, they have clubbed it at 680.
ತೆಗೆಲಾಕಿದೆ ಇದು ರದ್ದುಪಡಿಸಿದಲ್ಲ ತೆಗೆಲಾಕಿದೆ.
Even annexure, there are page.
Pawan Kumar accepts notice for respond number 1 to 3. This is yet another case of amalgamation, same order. Property number being 680, 680/1. 680/1 had been deleted, now notice has been issued for 680/1. The demand notice at Annexure A, B, and the proclamation at Annexure C are stayed till the next date of hearing. Chief Commissioner also released on 23rd.
Yes, sir. Shri Prasad.
The first one, IA 1 of 26 is dismissed as not pressed. Either too early, IA 1 of 26 is allowed.
Yes. Proclamation notice, annexure. A, page 11.
Yes.
Page 11, proclamation notice. Lord, notice, Lord, demand is 7,92,000. Property worth is 2.6 crores even according to that. Lord, then, Lord, I paid tax, page number 51. Subsequently also I paid tax.
51.
Please, 51,000 rupees I have paid. In fact, I
51
requested
is for which year? 17 to 26.
What has happened is, Lord, the petitioner's father, Lord.
51,590 you
Please, out of 7,92,000. In fact, I requested them to give some time, Lord, that they are not giving any time. And they want to put the property into action on day after tomorrow.
When will you pay this money?
Sometime, Lord.
Sometime andre.
Lord,
Sometime
tax is 3 lakh.
Sometime is tomorrow, day after.
4
What is
weeks.
the balance
4
amount?
weeks.
What is the balance amount?
Balance amount is 7.5, 7.4.
The demand is 7.92 out of
50,
which you paid
Lord, 50 I paid.
51.
Please.
So 7.5 is
Please.
the balance. Yes, now you tell us when will you?
8 weeks, Lord.
8 weeks, the entire amount will be paid?
In 3 installments, Lord.
In 8 weeks.
Please.
So first installment you'll pay in 3 weeks.
Please.
Next in 3 weeks and next 33% each. Single default.
Within 8 weeks, it will be completed in 3.
Installment wise ಕೊಡಿ so that it will be monitored and it will be paid.
12 weeks, not each, every 4 weeks, 2.5 lakhs.
Shri Pawan Kumar accepts notice for respond number 1 and 2. The submission of the counsel for the petitioner is that due to financial stringency.
Upon
the-
instructions, Lord. Upon instructions.
And upon instruction, government advocate, it makes sense. For a private practitioner, you are always under instructions. Learned counsel for the petitioner on instructions submits that due to financial stringency, the entire property tax could not be paid in respect of SAS property tax ID number 1500101681, ward number 186, Jaraganalli, belonging to the petitioner, having a unique property ID number 218/715/15. His submission is that the balanced property tax would be paid in 3 equal installments of 4 weeks each within a total period of 12 weeks. His further submission is that the dues as on today is 7,50,000, and as such 2,50,000 would be paid per installment. The first of the installments by 20th March 2026. In that view of the matter, the operation of the proclamation notice dated 31/2026 at Annexure A is stayed till the next date of hearing. Relist on is suspended till the next date of hearing. If the above payments are not made by 20th March, Annexure A will automatically come back into force. Relist on 23rd March to ascertain if the first installment has been paid.
Great.
Ramu V.
My Lordship, petitioner has challenged the proclamation order, my Lordship. My Lordship, before passing the annexure A, my Lordship, the respondent has not issued any notice, my Lordship. My Lordship, annexure B and C and D, my Lordship, more than 10 lakhs, my Lordship. The petitioner has paid the tax, my Lordship. Annexure B, my Lordship.
Now, what is the demand is?
My Lordship,
14
14 lakhs, my Lordship.
5,93,000 penalty, 4,94,000 interest also. 908. 908 property number 75 ಎಲ್ಲ correct ಆಗಿದೆ ಅಲ್ಲ?
Annexure C is the 3,50,000. Passing the annexure A, my Lordship, there is no notice was issued, my Lordship.
Is paid 3,26,000 and 3,50,000. 7 lakhs plus 2,64,000. Nearly 10 lakhs is paid. All paid in 25.
Yes,
They were dues, but all paid in 25.
8/12/25 and 5/12/25, my Lordship.
Shri Pawan Kumar accepts notice for respond number 1 to 3. The proclamation notice has been issued on 31/2026 indicating that the petitioner is due to property tax of rupees 5,93,007.96, cess of rupees 1,50,228.68, penalty of 494,273.30, apart from interest and SWM cess, totally amounting to rupees 14,95,891. Submission of learned counsel for the petitioner is that an amount of rupees 326,719 was paid on 8/12/2025, 350,439 was paid on 5/12/25, and 264,761 had been paid on 13/2/2025 as per annexure B, C, and D, which has not been taken into consideration by the respondents. His further submission is that no demand or show cause notice had been issued to the petitioner before the proclamation order had been issued. Taking into consideration that nearly 10 lakh of rupees has been paid in the year 2025, and the demand made is for a sum of rupees 14,95,891. The operation of the proclamation dated 31/26 is stayed till the next date of hearing. Land Council for respondent is directed to secure instruction as to whether while raising the said demand, the aforesaid payments have been taken into consideration, and whether a show cause notice had been issued to the petitioner or not. Released on 23rd February.
Kindly, my lordship, one submission, my lord. ಪ್ರಾಪರ್ಟಿನ ಸೀಸ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ ಸ್ವಾಮಿ ಅಲ್ಲಿ ಹಾಸ್ಪಿಟಲ್ ಅಂಡ್
ಸೀಸ್ ಮಾಡಿದ್ದಾರೆ.
ಹೌದು ಸ್ವಾಮಿ.
Seizing, I was not aware, my lord.
Kindly direct to my
Relist
lordship.
tomorrow. Find out
Yes.
why the seizure has happened. If they have paid that much, then release
Yes,
this.
that is to be open. I will just
Tomorrow at 2:30 p.m.
Serial number 5. Tapasri Peter.
Again, Lord, proclamation, my Lord, notice.
Proclamation.
Up-to-date taxes have been paid.
BMP ಅಂತ ಬರುತ್ತೆ, ಇನ್ನೂ ಒಂದು ಟ್ಯಾಕ್ಸ್ ಅಂತ ಬರುತ್ತೆ. ಆಲ್ ಟ್ಯಾಕ್ಸ್ ಎಲ್ಲ ಕ್ಲಾಸಿಫೈ ಆಗಬೇಕಾಗಿರೋದು. Yes, Mr. Peter.
Lord, question the proclamation notice. Up-to-date taxes have been paid till 2026. Ever since the time I purchased the property in 2020. Previous to that, my vendor had, my Lord, paid the taxes.
You are the owner of 7634/27/1.
Yes, that was amalgamated, my Lord, by way of Annexure C.
Annexure C.
Yes. Page 46, ma'am.
46.
27/1/1/2. Yes, it was, my Lord. Amalgamated and one common number 27/1 was given.
And these two were deleted.
Yes.
Now, notice is issued as regards?
My Lord, that tax of 15 lakhs is due.
No, which property? No, 1/1 has been issued.
At page, my Lord, 57, 56, my Lord.
You received only one notice?
In
Only
fact, my
1/1
Lord,
you have-
these notices were stuck on the wall.
You have not received notice for 1/2?
No, no notices were received by me.
That
They were, I
also-
only found them stuck on the wall.
That also you would have issued.
Online, it must have been issued now.
Because
You
I
might
might
not
have-
have got it, but they would have issued.
And
because
moreover, my Lord,
most of them they have deleted.
Yes.
My Lord, they are issuing these notices to my vendor when the kata has been changed in 2020.
We have requested the Chief Commissioner and Special Commissioner IT to look into it. There seem to be a lot of problems with this software.
The software.
No, Lord.
And mainly it is this amalgamation, ownership details, SAS.
SAS. Because there is a difference of SAS number also, which is coming.
All those things have to be. Shri Pawan Kumar accepts notice for respond number 1 and 2. There is yet another case of amalgamation. 27/1, 27/1-1 and 27/1-2 were amalgamated, retaining property number 27/1 and deleting 27/1-1 and 27/1-2. Now a notice has been issued in respect of, notice was stuck on the property of the petitioner. In respect of 1-2 is also there, Mr. Peter.
One is there.
Both are there.
Only I found only one.
27/1-2 and 1-1. There is an order of 1-2, proclamation also must be there.
That's regarding attachment.
An attachment order has been issued in respect of 27/1-2 and a proclamation of sale has been issued in respect of 27/1-1. In view of the amalgamation made supra, there cannot be any notice, there cannot be any requirement to make payment of property tax in respect of 27/1-1 or 27/1-2. In that view of the matter, the operation of the proclamation order dated 3/2/26 at annexure H in respect of property number 27/1-1, he state, in the event of any proclamation order having been issued in respect of 27/1-2, that is also state, though the note same has not been received by the petitioner. Special Commissioner so and so to look into relist on 23rd.
May I request? And ನಾಳೆಗೆ
ಎಲ್ಲ ಯಾವುದು ಆಗಲ್ಲ, they postpone.
Grateful, ma'am.
List number 2, serial number 40, Sachin BS.
Bill number
40. 40, Sachin BS.
none appears. Relist on 10th March.
Serial number 41, adjourned, 42.
Not see, I'm sorry, not seal number 40.
40. Yes. 40.
One more red petition, my lords. It has to be connected with, my lords.
But subsequently, we have passed an order, not the demolition of the entire, not the temporary shed. I think that might have not challenged before this honorable court. So therefore, my lord, this does not serve for consideration.
Let's let it be tagged and even I am.
Either what have you challenged here?
Lord, here I have challenged the NOC, the cancellation of the NOC, my lords.
Well, that is connect, my lord. Here they challenge, my lord. Here, what of 2023, my lord, they filed an application for, my lord, erection of shed, temporary shed. Not after that, my lord, there is, my lord.
It won't get, because you ordered demolition, does not mean that this will get infructuous.
My lord, here, thereafter, my lord, we have passed an order, my lord. I just pass it on, my lord.
We'll club both of them and take
Let
it.
it be heard together, my lords. There's a date given by my
Meetings
lords.
are, what is the date in that?
Let's say first week of March.
What is the date?
I'll just inquire, my lords.
Connect with so and so and relist on birth body.
I'll write it
Number
down.
and date birth body. Readings are complete. In the meanwhile, objections to be filed by the respondent. Please.
42, MS Narayan.
Lord, I may be permitted to take. Lord, I'll submit on the side.
42, MS Narayan.
Mr. Narayan? Still where? None appears for the petitioner. Shri P.S. Karthikeyan has appeared for 1 to 3. Delete Pawan Kumar. IA 1 of 25 is allowed. Relist on 16th March.
43,
Yes, Mr. Agnihotri?
Blood, the tax demand made by the corporation.
For the respondent.
In
But I'll
fact,
secure 2 weeks time to
property
secure
taxes
instructions.
are
my lord.
paid in advance. 20 up to 25, 26 taxes are paid. Annexures are filed. He is the owner of the property by way of gift deed, and he has paid advance tax. So now in fact, suit was filed, it was withdrawn. Now the writ petition is filed seeking to cancel the order because the order is illegal. And it has been demonstrated by the petitioners by way of annexures filed along with the petition.
Your Mysore City Corporation is not on CCMS?
I have to verify, my lord.
Because we have given you 2 weeks time on 2/2/26 and you're still asking.
But we have sent the copy, my lord, but we have not received wakalat.
Not received wakalat also.
Please, my lord.
Counsel for respondent number 1 and 2 had been directed to take notice.
Yes.
Who is a panel counsel was directed to take notice on 2/2/26. Today, he submits that neither wakalatnama has been received nor the instructions have been received.
2 weeks time.
Despite the copy of the writ petition having been sent to respondent number 1.
Please, my lord, we have sent.
2 set ಅವ್ರು ಒಂದ್ ಇಟ್ಕೊಂಡಿದ್ದಾರೆ ಅವ್ರು ಒಂದ್ ಕಳಿಸ್ತಾರೆ.
ಇಬ್ರು ಎರಡು ಸೆಟ್ ಕೊಟ್ಟಿದ್ರು.
ಒಂದ್ ಇವ್ರಿಗಿರತ್ತೆ ಒಂದ್ ಅಲ್ಲಿ.
Gita Devi was directed.
The counsel for respondent is directed to secure instruction as to whether the respondents have been onboarded onto the court case monitoring system and make his submission. The principal secretary e-governance is also requested to look into the same and onboard, if respondent is not onboarded, to onboard the respondents onto the CCMS, as also to onboard any other city corporation or municipal authority who has not already been onboarded to enable speedier communication uh, between the respondent and its counsel, so that time of the court is not wasted. Registry is direct print the name of learned AGA to enable reporting compliance with the above. At the request of counsel for respondent 1 and 2, relist on 10th March, it is made clear that no further adjournment would be granted. If instructions are not received by then, respondent number 2 shall appear through video conferencing before this court.
The stay interim order.
Interim order earlier granted is extended till next day.
Sorry, my lord, serial number 42, I left the other code.
42.
42, my lord.
Yes. ಅಜ್ಜನ್ ಆದ್ಮೇಲೆ ಎಲ್ಲರೂ ವಾಪಸ್ ಬರ್ತಾ ಇದೆ 42 ಕೋಡ್. Yes, sir.
My lord, one Mr. Krishna Swami has purchased the flat, my lord. And in 2018, he makes a will and he dies in 2020.
Petitioners have purchased, all of them have purchased this.
No, my lord. Husband and first petitioner's husband and father of second and third petitioners. And he makes a will. It is
He had purchased it, now they are survivors.
Yes. They are the survivors. Filed at annexure N, page number 36 is the will. Life interest was given to wife and then it has to pass on to first son.
Yes.
That's the second petitioner. To that effect, will has been produced and the family tree has also been produced. And they have given NOC from the other son. And all the petition number 1 is the wife of the testator and the second petitioner and the third petitioner the sons. Third petitioner has given NOC to effect the kata.
Yes.
But corporation has not been effected the kata and
They're asking for kata in the name of mother and the son, one of the son.
Yes.
One of the son has given the NOC. And will is an unregistered will and the life interest is created in the name of the mother. So the kata has to be done all in the name of all 3 members of the family is what I've been.
ಇಲ್ಲಿ ನಮ್ಮ judgment ಎಲ್ಲಪ್ಪ. They dealt with the, they give a holder's kata for the life interest.
Life interest.
And the main kata for the person who will survive. We have dealt with that judgment.
And my lords, the NOC from one of the son is issued by the letter. They may ask for an
Affidavit and indemnity.
ಅಲ್ಲ affidavit ಕೊಟ್ಟಿದ್ದಾರೆ affidavit ಹಾಕಿದ್ದೀವಿ. It is at page number 58, my lord. 58 annexure N. Affidavit ಕೊಟ್ಟಿದ್ದೀವಿ. All the 3 have filed the affidavit, my lord. Mother
Sheshadri, Sandeep and Nagratna, all 3
have filed the affidavit, my lord.
All 3. But a judgment copy ಕೊಟ್ರೆ then ನಮಗೂ ಹೇಳಕ್ಕೆ ಈಸಿ ಆಗುತ್ತೆ. ಯಾವ ಕೊಡ್ತಾರೆ ಸ್ಯಾಟರ್ಡೆ?
ಇಲ್ಲ ಮಂಡೇ.
ಸ್ಯಾಟರ್ಡೆ ವರ್ಕಿಂಗ್
ಗೊತ್ತಾಯ್ತು.
ಬರೀ ನಾವೇನ? Counsel for the petitioner seeks for and is granted a week's time to place on record the judgment that he wishes to rely upon. Relist on 25th. Oldest kata for life estate.
Life.
And for the successor, it will be the regular kata.
Number 44 pass over. 45 serial number 45 to 47 adjourn. Serial number 48 Suyogere.
Matter may kindly be passed over, my lords. I apologize.
Passover won't reach now.
I understand, my lords. I apologize. He's held up, my lords.
Matter was there yesterday.
Please, my lords.
Passover won't reach now.
Please, my lords.
Have it on. Pleadings are complete.
Illa. Yesterday,
my lords,
first
you are
time
directed to
matter
secure
appeared
instructions.
yesterday.
First time.
Yes.
My lord, we undertake to file wakalat on behalf of R2, my lord.
O Shivram Bhatt has filed. Who is going to appear for R2?
Oh, he is going to appear.
Is there in the cause? Please. At the request of counsel for the petitioner, relist on 25th.
Please, my lords.
Not on 25th, my lord. Either on 24th or 26th.
26th to 26th.
Please.
My lords, 24th, my lords. Shorter date.
At 24th.
Please, my lords. Grateful.
49 Lata Shetty.
My lord, I pick up here, my lord.
Yes, Mr.
Lord, page 33 is the order passed by the BBMP, page 33. They say that, my lord, in the revised master plan 2015, they proposed to have a road of 30 meters. My lord, in the 2031 proposed master plan, which has now been withdrawn, my lord, they have removed the road also. Now, my lord, they also given an endorsement saying that we are not proposing to build a road here because 100 meters thereafter there is already a road
Who
being
has
built.
given the endorsement?
My lord, annexure Q, my lord, the BBMP town planning
Page?
annexure Q, page, my lord, 137, my lord.
137. Where do they say that?
My lord, 137. My lord, 130, if you I'm sorry, my lord, 139. 139. Last paragraph, my lord, page 140. After my lord discussing, they say, ಇಮೇಲಿನ ಅಂಶಗಳು ಆಧಾರದಲ್ಲಿ my lord, they say
ಕುಂಡಳಿ ಸರ್ವೆ ನಂಬರ್ 2 ಪ್ರದೇಶ 1 ನಕ್ಷೆಯವರಿಗೆ ಇರುವ 2 ರಸ್ತೆಗಳನ್ನು ಗಮನಿಸಿದಾಗ ಮ್ಯೂಟೇಶನ್ ಕಾರಿಡಾರ್ ಒಂದು ಗುರುತಿಸಿದ.
Hence, my lord, there is already a mutation corridor, my lord, which has come into existence.
Yes. You don't want to form the road.
As per my instruction also, my lords, because there is an alternate road available which is 100 feet. So in that sense, this notice is issued.
PD has no, my lord.
Now the BBMP themselves have no take action because my GBA is the form around 10/10/2025 onwards. This area is entire transferred to the GBA, my lord. And the my lord annexure.
GBN or GBDN?
There is a lot.
GBA, Greater Bangalore Authority.
Development Authority.
Yes.
Development we are not. Greater
GBA
Bangalore
will only
Authority.
sanction the plan now.
Sanction plan for this will be given by GBA. This concerned corporation, my lord. It's a site, 60/40 site.
Site?
Alla site alla. It is a, my lord, 3,623 square feet of property. Site. And even the BDM, my lord, page 157 might be kindly be seen, my lord. Even they have given 157, last paragraph.
Oh, you have not given, we have handed over, sent to the GBA, my lord, the.
We have handed over, it is for them to do it.
And the
They
application
don't want to form a road.
The endorsement is given to that effect.
If we don't want to form a road, then yesterday what we told them 2031 is gone, that doesn't take away.
2031, my lord, master plan is not 2030 master plan is not to come into effect, my lord. So
It's been recalled.
recalled and 2015 RMP is the continue as on today also.
Yes, yes.
So now do you want to form this road or you don't want to form it?
The concerned officer said that in view of the endorsement, they have also said the same.
You don't want, then sanction.
But because it is in RMP 2015, that is a hurdle that they are facing.
That is something that you can make use of to form a road. If you don't want to form a road, you can't make use of it to say, I won't form the road and I won't allow them to develop. Both you can't do.
And your lordship may kindly see.
You want to form the road, acquire the land.
Page 130. Entire area is built up.
Give them compensation.
If future road is to be formed, then they have to do.
Even now, if you want to do it, you have to acquire and
As
give
if
them
now,
compensation.
my lords have seen.
Lord, that will not be possible also. Page 130, if your lordship sees the photographs.
130?
Page 130, annexure P, my lord. Entire area, my lord, has been built up with the 30 feet road. This is where, my lord, they want with 30 meters road. That is almost 100 feet. That is why, my lord, they had done a road. ಅವ್ರು ತೋರ್ಸಿದ್ರೆ ನಾವು ಬರ್ಬೇಕಾಗುತ್ತೆ. ಅವರೆಲ್ಲ ತೋರ್ಸಿದ್ರೆ ನಮ್ಗೇನು ಇರಲ್ಲ ಕೆಲಸ.
ನಿಮ್ಮನ್ನೇನ ಕರ್ಕೊಂಡು ಬರ್ಬೇಕು.
Please ಬರ್ತಿರ್ಲಿ. Please ಬರ್ತಿರ್ಲಿ.
Petition is before this, seeking for the following leaves.
I should bring to your lordship's notice, my lord, there were 2 earlier writ petitions also. My lord, construction had already taken place without the plan. Then, my lord, this honorable court directed us, my lord, to file an application under section 240. We have filed application under section 240. That on that, my lord, now order has been passed. That also.
Petitioner is before this court seeking for the following leaves. The petitioner claims to be,
Two petitioners.
petitioners claim to be the owner of site number, property in survey number 110 of Kundalli, on which the petitioner had put up a construction without obtaining a plan sanction. A writ petition having been filed before this court, this court had permitted the petitioner to avail the benefit of section 240 of the BBMP Act, submit a plan for sanction in accordance with the building bylaws to ascertain, to try and save the property so long as it complied with the applicable building bylaws. The petitioner having made an application for plan sanction, the same came to be rejected by the endorsement at Annexure A.
Page 33.
Annexure A and A1.
Annexure C, my lord, page 33.
No, Annexure C.
Page 30.
Dated.
Dated.
No, where is the rejection of?
Page 33, rejection remarks, page 33.
Page 33.
Petition and see on the application verified as per RMP 2015, there is a road widening proposal.
How annexure? Annexure?
My lord,
B.
annexure B.
Annexure B.
Petition or annexure C ಅಂತ ಹೇಳಿದ್ದೀರಾ?
On the ground that there is a proposed road.
Since it is in the master plan, it's a proposed road. Unless master plan, there is a modification.
When the BBMP says, now you have handed over,
That is correct. But
BBMP doesn't want to form a road.
Because they've already formed next.
So why should this property be stuck for that?
it is in the master plan, whether it is shown as a proposed road.
Mr. Krishna, it's a proposed road. Proposed road would require acquisition by the BBMP, now the GBA.
There is two types. One is if the BBMP itself farm the road, then they have to acquire it. If the property owner wants to develop the land, that particular land, then there is a zone, as per the zonal regulation, the master plan road has to be shown as a road in the development plan. That area they have to hand it over to the BBMP or planning authority at free of cost, and FAR will be given to that area, to the builders.
No, even then you have to acquire. Even then,
No, if that property, the petitioner will want to develop that property, then when he make application for development plan, this master plan road will be shown as the road in the proposed road in the, there is a, in the zonal regulation, there is a specific condition, they have to incorporate that road as the proposed master plan road. Then that road, they have to hand it over to the planning authority as free of cost. And for
that we have already stuck down in so many matters. That cannot be done. 72A cannot be done if there's a.
Here comes under the zonal regulation, chapter 7, 7.1.5. Because this is the apartment, they want to construct an apartment. Therefore, the zonal regulation 7.1.5. Where it says whether the master plan-
What is zonal regulations? What is 7.1? 7.1.5.
Chapter 7, 7.1.5.
Just a minute, let's see what Mr. Krishna is saying. This also has been dealt with. This also we have said no, it can't be free of cost. There is nothing free of cost.
They have to hand over free of cost, but that area, FAR will be given. 0.3 except the CS side, other area, entire area, FAR that is given.
And this is for a larger property of 4,000 square meters and above. You do 3,600 square feet. Site idu. It's not a development plan where you require 10% for park and open spaces, 5% for civic amenities. This is a site. Four thousand square meters and above, that is different. Huh. Yenama bantu? On the ground that there is a proposed 30-meter RMP road, 30-meter road shown in the revised master plan 2015 bracket RMP 2015, and as such the plan cannot be sanctioned. It is challenging the same. The petitioner is before this court seeking for the aforesaid relief. The submission of Sri Bipin Hegde, Learned Counsel for the petitioner, is that the RMP, the road, 30-meter wide road shown in RMP 2015 has been deleted in proposed RMP 2031. And on that ground, since the planning authority has also decided that in future the road is to be deleted, there cannot be an embargo imposed on the development of the property today. Secondly, he submits that the BBMP, who is now the GBA, who is now in custody of the said property, who is the administrative authority in respect to said property, also does not wish to form any road. Hence, the question of the presence of a proposed road in RMP 2015 ought not to be a reason not to grant plan sanction by the respondents. Shri Pawan Kumar, on instruction, submits that the BBMP does not wish to form any road in the said property as per the endorsement dated 16/8/2025, produced at Annexure Q2 along with the writ petition. Submission of Shri K. Krishna, Learned Counsel for respondent number 6, is that the entire area has been handed over to the GBA, and now the GBA is the planning authority. He is the planning authority, and it is for GBA to take a decision in relation thereto. Third, Shri Bipin Hegde, Learned Counsel for the petitioner, Shri Pawan Kumar for respondent number 225, and Shri K. Krishna for respondent number 6, peruse papers. The above matter raises an interesting question, inasmuch as could a landowner be restrained from making use of his properties on the basis of a proposed road in RMP in a revised master plan, which the municipal authority now does not want to implement, merely on the ground that such reservation continues in the RMP. The proposed 30-meter wide road in RMP 2015 has admittedly been deleted in the proposed RMP 2031. However, the proposed RMP 2031 has now been cancelled, and that proposal is no longer in existence. Thus, what is required to be considered is only with reference to RMP 2015. In RMP 2015, there is an existence of a road, proposed road of 30-meter width, situate on the property of the petitioner. Merely because there is a proposal to form a 30-meter road in RMP 2015 does not mean that the property would vest with the planning authority or the municipal corporation. The proposal only enables the planning authority or the municipal authority to acquire the same and then form the road as per the provision of the Karnataka Town and Country Planning Act 1961. in the present matter, though a 30-meter wide road has been shown in the property of the petitioner, the BBMP does not wish to form any road on the said property, as is clear from the endorsement at Annexure Q2 referred to supra. Once the authority does not want to form a road, the proposal by itself will not result, the proposal is virtually given up by the authority, and that cannot be a ground to reject an application filed by the petitioner for construction, for sanction of construction plan on the ground that there's a proposal in RMP 2015 which the municipal authority does not want to implement. Hence, I pass the following order. Writ petition is allowed. A certiorari is issued. The endorsement dated 1/9/2025 at Annexure B is quashed. The respond number 4 is directed to consider the application for plan sanction submitted by the petitioners as per the observation made here and above, and consider the same in accordance with law within a period of 30 days from the date of receipt of a copy of this order. The needless to say, until the application is considered, respondents are restrained from taking any coercive steps against the petitioner.
There, your lordship said, my lord, the planning authority to acquire, my lord, there is a two diversion, there, larger extent ಗೆ ಇದಾಗ್ತದೆ. ಅಲ್ಲಿ ತಾವು ಹೇಳಿದಿರ planning authority to acquire. If it is comes a development plan, my lord, it becomes a general statement.
Acquire the land if it does not form part of a development plan. You're right.
Otherwise, it will be
ನಾಳೆ
larger
confusion ಆಗುತ್ತೆ. 48 interim order.
Serial number 50 adjourned, 51.
Yes, Nachiket.
The same apartment issue of double essays, but in this case, the petitioner has continued to pay under the old essays which was given to him before the OC was issued, and has not paid under the new essays.
Shri Pawan Kumar accepts notice for respondents. The contention of the petitioner is that in respect of property, where is the SS number?
The essays number is at annexure D.
D. Page.
The old essays number that is in
Property bearing kata number 1741 stroke E-903. The petitioner had been making payment of taxes as per SA's application number 1500229165. However, there seems to be another SAS number which has been issued in respect of the very same property bearing number
it's at annexure L.
page
Page 76.
one 1700983 as regards which now a notice of proclamation of sale has been issued to the petitioner. A perusal of annexure D series and G series indicates that the petitioner had been making payment of taxes in respect of SA's application number 1500229165, which relates to the very same property. Hence, it would be remain for the respondents to explain as to how another SAS number had been issued for the very same kata number. Until then, the operation of annexure L is stayed till the next date of hearing, relist on 23rd. IA 1 of 26 is allowed.
Serial number 52. Krishna Nair.
Yes, madam. You're not filed an application.
No, my
You don't want the money.
want, my lord. The old PDO is transferred, my lord. Trying to contact present PDO.
This is coming up after 2 years. If you don't want the money, we'll use it for something else.
weeks time may be granted, my lord.
Some good purpose for a charity or something we can use. Counsel for respondent submit that the earlier PDO has been transferred. She seeks for 2 weeks time to file necessary application. Relist on 17th March.
Serial number 53, adjourn 54. TP Rajendra Kumar Singh.
Mr. Manjunath. Where is he? Idara Manjunath BR. None appears for respond number 4. Compliance with the order date 11 to compliance with the undertaking given on 11/2/26 has not been made. Relist on 25th February.
55.
Yes, they were.
They're trying, they have literally run over my property, my lord.
Run over your property.
The Panchayat Development Officer has put up excavators, they've completely dug through my property, and when now land revenue roster has now been transferred before my lord, because the Panchayat Development Officer was made a party. Here is a case, my lord, I will take my lord directly to.
And AGA is directed to accept notice for respond number 1 to 3. Tayalur Panchayat Mudabagal A. Nagarajappa is directed to accept notice for respond number 4. Counsel for the petitioner to furnish 2 sets of the petition along with annexures on the said council. Relist on 20.
My only
ಇಲ್ಲಿ ಅಲ್ಲಿ ಹೋಗ್ಬಿಟ್ಟಿದೆ ಇಲ್ಲಿ ಕೊಟ್ಬಿಡಿ
ಇಲ್ಲೇ ಕೊಟ್ಬಿಡ್ತೀನಿ. My lord, the only position is again, even yes, the other day, last week also they have come. One, they don't receive notice. Here, my lord, I'll just submit this memo. They come and they've excavated upon my land under the guise that there is some encroachment over a nala. All I want to take, my lord, is one document. I will not bother, my lord, more than that. My lord, page number 27. They contend that I have, this is again my assumption because nobody is responding to me at all there. Page 27. Neither is a nala running through my property, nor is there is a lake. I am not encroaching upon neither.
Number survey number?
My lord, 64/2. Page number 27.
RTC?
My lord, RTC is at page number 20.
20.
I am the petitioner there, my lord, is one of the co-owners of 26 guntas of land.
7 you said.
My lord,
this is RTC of 64/2.
64/2. I'm sorry, my lord, 64/2.
There's 2 guntas of A kharab, not B.
There's 2 guntas of A kharab, precisely my point. And page number 27 is the kharab utar or the hissa.
27 kharab utar you got?
Yes, my lord. Hissa survey tippani pustaka, which details the kharab. My lord, may kindly see at the right at the bottom, my lord, in the 2 hissas, hissa one, there is a bavi, 2 guntas. Same, there is bavi mattu vagaire, 2 gunte. Total 4
Bavi
guntas.
is the A kharab.
That is the A kharab. Now they are contending that there is and this is again my assumption, because when they come with an excavator, I am not aware what they are coming under. But for a moment, even assuming, my lord, that I have encroached, let us say, no notice has been issued, no proceedings under section 67 have been initiated against me.
Perusal of the RTC in respect told. A perusal of the RTC in respect of survey number 64/2, Thiruvanelli village, Avani Obli, Mulbagal Taluk, Kolar district. As also the Karabutar extract relating to the very same survey number indicates that it's only 2 acres, 2 guntas of A Karab, which is stated to be situated in the property in the aforesaid survey number. In the question of the respondents contending that there is a nala which would necessarily have to be classified as B Karab being situated on the property would arise. Hence, the respondents are restrained from carrying out any excavation work in the property bearing survey number 64/2 detailed above till the next date of hearing. Relist on 25th.
25th. Grateful.
Counsel for the petitioner to furnish 2 sets of the petition along with annexures on Sri A. Nagarajappa and file the acknowledgement thereof with the registry by end of day 21st, failing which the interim order will stand automatically vacated.
Grateful.
Serial number 56.
Who is R4? R4 is Mr. One ನಿಮಿಷ ಕೊಡಿ. So 3 and 4. Here, Nagaraj. 1, 2 and 1, 2, 3, 4. Nagaraj. Yes.
56.
56.
Appearing for respond BBMP.
Who are 6. What is the affidavit you have to file?
My lord, there was a direction for the respond BBMP to file an affidavit, my lords, which I filed yesterday, my lords. My lords, on 31/1/2023, there was a direction for the respond to seek instruction as to what action has been taken after 17/10/2025, my lords.
31.
My lords, 31/1/2026. The Honorable Court was pleased to direct the respond to file an affidavit.
1710, you are directed to stop construction.
Yes, my lords.
Yes.
That your
Then
lordship was pleased
construction
to.
continued, so you are called upon.
No, they have not continued, my lords. My submission, even before the petitioner could give representation, my lords, there was one more complaint given by the one Mr. Ramaswamy in the month of February 2025. Immediately after that, my lords, we have given a provisional order confirmation, provisional order and confirmation order is also issued.
2 submissions. I appear for respond number 10, the owner of the property. But the petitioner hearing is my vendor who sold the property to me. He is not my neighbor, he is staying some other place. 2020, my lord, he sells the property. I refuse it. He files a civil suit against me through his daughter. He does not disclose any of these things. Out of personal vendetta, he calls me and blackmails me for a sum of ₹1 crore, stating that he will withdraw the petition provided I pay him 1 crore. And yes, I am filing an affidavit to this effect.
Where's your senior?
Senior is in out of station.
When is going to come back?
Next week.
Next week.
See the conduct, well. He blackmails me.
Commission of Learned Counsel for respond number 10 is that the petitioner is the vendor
Please,
of respond number 10, and the present petition has been filed only to blackmail and extort monies from respond number 10. The junior of the counsel for the petitioner submit that the arguing counsel is traveling and not in station. Relist on 24th. It is made clear that 25th, it's made clear that no further adjournment would be granted. If the allegation is not controverted, serious orders would have to be passed.
Great, great.
Kaushik,
Kaushika. Non-compliance with ಏನಿದು? ನೋಟಿಸ್ ಆಗಿಲ್ವಾ? And AGA is directed to accept notice for respond number 1, Election Commission.
Vaishali Hegde.
For 2, PDO Ballare Gram Panchayat.
Charanjit Shetty.
Charanjit Shetty for respond number 3. None appears for the petitioner. Petitioner is directed to furnish 2 sets of the petition along with annexures on the said councils, who are granted 3 weeks time to obtain instruction, make their submission. Released on 17th March.
58. Nagabhushanar.
Yes, same matter.
Yes.
Don't try to create problem for others.
Sorry, my lords.
ನಿಮ್ದು ಮನೆ ಹೊಡೆದೋಗ್ತಾ ಪಕ್ಕದವ್ರನ್ನು ಹೊಡಿಬೇಕು ಅಂತ ನೀವು ಹೇಳಿದ್ರೆ we won't accept it.
I'm sorry.
Petitioner is before this court seeking for the following reliefs. Illi a judgments illi.
What's
Yesterday what you
list of citations produced yesterday? First judgment, my lords, para number 2.
The provisional order which has been passed indicates that the deviation is less than 50%. Coordinate bench of this court, by its order in 19th February 25, in WP number 21041 of 2021, as held that, when was your plan sanctioned?
1991, my lords.
That if a plan had been sanctioned prior to the amendment to section, ಯಾವ section is it? BBMP Act 248. Which is the amendment? Section ಯಾವುದು? KMC Act, but BBMP Act.
Three.
225%. ಯಾವುದಪ್ಪ
My
section?
lords, 321 clause 1, KMC Act.
321 K.
321 clause 1, my lord.
ಅದು first notice about this regularization. (321) capital A, not one, capital A. Unauthorized construction could be regularized if the setback violation is less than 25% in case of non-residential and 50% in case of residential buildings. And the coordinate bench has held that since this issue is now pending before the Honorable Apex Court, if the Apex Court upholds the provision and permits regularization, then the petitioner would be entitled to seek regularization since the percentage violation is less than 50%. The same would, in my consideration, the said observation, in my considered opinion, would also apply to the present matter. Consequently, the writ petition is disposed of, holding that the petitioner would be entitled to seek regularization of his unauthorized construction in the event of the Apex Court upholding the amendment made to the KMC Act introducing section 321 capital A, and until then the impugned order shall not be given effect to. Needless to say, if the Honorable Apex Court were to quash the amendment, then the respondent would be free to take such action as is permissible in accordance with law.
59,
Great.
P.R. Mohan.
Paper petitioner.
2 and 3.
12th, this honorable court passed an order.
Yes, Pawan. Hello, Pawan.
And today, I have taken the photograph. Because of the order, and they have covered it now. I have given a copy to Mr. Pawan also. Now they covered it and left it as it is, these street vendors, in front of my shop. Vehicles are still there. Page 127 in the photograph earlier, in the petition.
So for today, your problem is solved. Tomorrow, the problem will come back. Then Mr. Pawan will also come back at that time. ಬೇರೆ court ಹೋಗಿರ್ಬೇಕು. Affidavit of respondent 2 and 3 is yet to be filed. Released on Saturday, 21st.
Please.
Yes, sir.
List number 1, Serial number 1, Shruti C.
This is also connected with serial number 10 and list 2. That's a fresh matter in which notice is not even issued.
10 and
Serial number 10.
44.
Serial number 44.
Yes. Which one do you want us to take?
My lord, on the last occasion, my lord had passed an order directing BBMP and BDA to answer specific queries posed by this honorable court.
Yaudರಲ್ಲಿ, in which matter?
818.
818, my lord, that is.
Serial number?
This serial number 1.
1.
Serial number 1. Date first is the order. This BDA BBMP issue.
Yes, my lord. BBMP.
They have issued endorsement dated annexure Gmail.
Now you have also received money, they have also received money. We're asking them to pay once again.
BDA only collected the taxes.
BBMP is also collected.
No. They have issued the
ಖಾತೆ
notice.
ನಂಬರ್ ಸಿಕ್ತಿಲ್ವಂತೆ ಲಾರ್ಡ್ಶಿಪ್ ಅವ್ರು BBMP ಅವ್ರಿಗೆ ಖಾತೆ ನಂಬರ್ ಅದು ಸಿಕ್ತಿಲ್ಲ.
ಮೈಕ್ ಸ್ವಲ್ಪ ಪಕ್ಕದಲ್ಲಿ ಇಟ್ಕೊಳ್ಳಿ.
ಖಾತೆ ನಂಬರ್ ಸಿಕ್ತಿಲ್ವಂತೆ ಅವ್ರಿಗೆ ಇವರು ಎಂಟರ್ ಮಾಡಿ.
ರೆಸಿಟ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದಾರಲ್ಲ. Where is that receipt, madam?
ಓರಲಿ ನಮಗೆ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ, ಮೆಮೊ ಫೈಲ್ ಮಾಡ್ತೀವಿ ಲಾರ್ಡ್ಶಿಪ್ 2 days time ಕೊಡಿ.
My lord, the notices that they, if my lord would see.
No, where is your payment to BBMP?
My lord?
Where is your payment to BBMP?
My payment to BBMP, I've produced all the BDA tax paid receipts, my lord, but all the notices from BBMP I've produced. If my lord would please see the latest SMS that is at page 69.
69.
That is, my lord has writ petition number.
No, we have
sorry.
818.
56, my lord has 818, my lord,
Yes.
page 56.
56.
It has an SAS ID in that SMS notice, my lord. For them to say that they're not able to get the kata number makes no sense.
2 days time ಕೊಟ್ರೆ ಮೆಮೊ ಫೈಲ್ ಮಾಡ್ತೀವಿ ಲಾರ್ಡ್ಶಿಪ್.
Their SMSs, everything, very, very highly specific notices that are being sent,
Correct.
sale notices are being
Instructions.
sent.
Make ನೀವು ಹಿಂಗೆಲ್ಲ ಸಬ್ಮಿಷನ್ ಮಾಡಿದ್ರೆ ಕಷ್ಟ ಆಗತ್ತೆ ಆಮೇಲೆ. Connect sale number 10 and 44. Learned counsel for respond number 1, 3 and 5 seeks for 2 days time to make a submission as to how demands have been made by the BBMP on the petitioner to make payment of property tax when property tax has been already paid to the BDA, who is the jurisdictional authority. And BDA has not handed over the property to the BBMP.
My lord, sorry, my apologies. Page 32 and 33 are the BBMP tax receipts. I've produced those also.
That is what we asked you.
The BBMP tax paid receipts are
And
at page
how
32 and 33.
taxes have been collected
32, 33, 34, my lord.
by the BBMP in respect of those properties for the year 2016,
15, 16
15, 16 and 16, 17
and 17, 18.
and 17, 18. 15, 16 to 17, 18.
This is 818. my lord.
Relist on 21st.
May I just make one, in 1793, my lord, which is at serial number 10, notice and interim order, if my lord would be pleased. Was that fresh matter? Sorry?
17.
1793 of 2026.
Serial number 10. Notice has been ordered. Wakalat is filed before notice, sorry.
And an interim order also.
Ms. Sumana Baliga accepts notice for respond number
Every alternate respondent.
1, 3, 5, 7. See, here Vasant, you are appearing or Krishna?
I am appearing.
See, Vasant is direct to accept notice for respond number 2, 4
and
6. And AGA for respond number 8. The operation of annexure E and H is stayed till the next date of hearing. 44, there is an interim order.
There is an, it may be
Connect.
extended.
Connect 10 and 44, relist on 21st.
Serial number 2, Shanmugappa.
The respondent 1 to 3, my lords. My lords,
Inspection report.
my lords, it has been filed, my lords, on the last occasion only.
Filed.
Copies have been served, my lords. Yes, please.
Counsel for respond number 1 to 3 submits that inspection report has been filed.
My lords, they are not inspection reports, my lords. My lords, they were reports before the joint commissioner. The proceedings had to be filed, my lords. So all that has been
Non-filing of
filed.
inspection report ಅಂದ್ರೆ ಏನಿದೆ?
My lords, the inspection of the documents to be provided ಅಂತ.
ಅಷ್ಟೇ. That is what the order says.
Please. Copies have been
The
served.
officer said something else. The note put up by the registry in the cause list is incorrect in as much as there is no inspection which has been directed to be ordered. Respond number 1 to 3 were only directed to provide inspection of the documents of the records relating to the above matter.
Copies have been served, my lords. The last occasion.
Original have you?
Yes, Your Honor.
Originally you have taken inspection?
We have not taken, because we ourselves have produced a document there. It is only for it, the document is very much necessary. So that I have, because my own documents with the corporation, I have produced 1909 till date. I have produced all those documents with the.
You have taken inspection?
Please, my lord.
You want to take, you don't want to take?
I don't want to take.
You don't want.
On my
Then why did you make this submission last time?
Respondent number 4 had made a submission. On the request of respondent number 4. Documents na court ತರಿಸ್ಕೊಳ್ಳಿ ಅಂತ ಅವರು
ನಾನು ರಿಕ್ವೆಸ್ಟ್, ಯಾಕಂದ್ರೆ ಆ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ನಾನು ಅಥೆಂಟಿಸಿಟಿ ತಮಗೆ ಗೊತ್ತಾಗ್ಬೇಕಾದ್ರೆ ಅದಕ್ಕೋಸ್ಕರ ಡಾಕ್ಯುಮೆಂಟ್ ಬೇಕು ಅಂತ ಹೇಳಿದ್ದೆ ನಾನು. ಬಿಕಾಸ್ 1909
ಪ್ರಿಎಂಪ್ಟಿವ್ ಆರ್ಡರ್. ನಾಳೆ ಅಥೆಂಟಿಸಿಟಿ ಏನಾದ್ರು ಡೌಟ್ ಮಾಡಿದ್ರೆ ತರಿಸ್ಬಿಡಿ ಅಂತ. So what have you done now, Karthikeyan?
Now it has to be held on merit.
What have you done? You filed those documents?
We have filed the documents, my lords.
Inspection of the original records. Learned counsel for the petitioner today submit that he does not wish, learned counsel for respond number 1 to 3. Submit that photocopies of the said documents have been filed before this court. Counsel for the petitioner submit that he does not wish to take inspection of the original documents. So does counsel for respond number 4. In that view of the matter, registry is direct delete the note which has been put up. Pleadings being complete,
yes,
documents being placed on record. In a
date may be fixed, Your Honor.
Counsels are granted 10 days time to get ready and address their arguments.
Much.
In the meanwhile, synopsis of dates and events, list of authorities and authorities to be filed after exchanging with each other. Relist on 10th March.
Interim order my kind of
Interim order earlier granted is extra.
Serial number 3, KV Narasimhan.
Pass over the inspection report. There is no sanction plan and 100% deviation on all sides.
100%.
Page number 4 and 5, your lordships.
This is as regard the property of
My lords?
respondent.
Yeah, R6.
What about petitioner? What about petitioner's property?
Lords, the inspection was
Dilip
ordered for
Kumar,
R6's property.
petitioner, Ramya respondent. First is construction is there, but no valid building plan for the petitioner.
Yes.
Petitioner is also violated. Very nice. 100% petitioner. Respondent. Where is the respondent's?
Lords, the respondent is
This is of Dilip, who is the
the
petitioner.
R6's property. Respondent is V Ramya. She sold
Where's
the
the
property and the subsequent purchaser has been impleaded. We have conducted an inspection on R6's property.
Petitioner also,
No, but his petitioner's name is only written in the inspection report. For the sake of clarity, inspection is of the respondent's property.
so now R7 is the owner.
Yes.
Yes. You appear for whom?
1 to 5, my lords.
Respondent 6, my lord.
6 and 7 or only 6?
Only 6, my lord.
You've been shown as 6 and 7.
Because what happened was six sold the property, I believe, to respondent number 7. So a deletion application was filed and an impleadment application was filed by R7. That came to be allowed. So R7 is the current owner of the property.
Correct, but you are appearing for both 6 and 7.
Yes, my lord, only for 6, my lord, I represent.
My lord, impleading application is filed by us, my lord.
Implead application also.
They
not served, my lord.
represent both.
Has notice gone to, who has filed wakalatnama for respond number 7? 7 ಗೆ ಹಾಕಿದಾರ? You filed wakalatnama.
No, my
You're
lord.
saying you're not appearing.
6, my lord.
Kodi ತೋರ್ಸಿ ಅವ್ರ wakalatnama. Don't
represent
confuse
both,
and
ma'am.
waste time.
Yes, my lord. Sorry, my lord. 6 cents.
So no more this one, demolition.
No, my lord. Short date given, my lord.
100% violation of the setbacks.
No setback has also been left.
Less than 2,400 square feet. You applied regulation of 5th January?
Yes, my lords.
No, it's not 5th January, 2.70, 1.8, this is not 5th January. It's 0.9 alwa. Yes, what do you want to do now?
Short date given, my lord. Inspection copy also yesterday received, my lord.
Yesterday. How long does it take to see one page? You want to get the benefit of subsection 7 of 230 to apply for a plan sanction and get it regularized, we'll give you that. Inspection report has been filed. The same is taken on record. A period of the inspection report indicates that the construction which has been put up by respond number 6/7 is without a plan sanction. Apart therefrom, there is a violation as regard the setbacks on all 4 sites. As also, this can't be regularized. Impossible. As also, there is a violation in respect of the height and the number of floors which can be constructed. In as much as in a site measuring less than 2,400 square feet, ground plus 5 floors with terrace has been constructed. Faced with the above situation, Learned Counsel for respond number 6 and 7 seeks fund is granted a week's time to obtain instruction, make a submission. Relist on 25th February. This building has to go.
Entry model maybe.
ಏನ್ ಎಂಟ್ರಿ ಮಾಡೋ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಆಗೋಗಿದೆಯಲ್ಲ ಇನ್ನೇನಿದೆ?
Construction is
Entry model
completed in
earlier
all
granted.
respects, given for rent also.
My lord, even there was operation of entry model, my lord, during that period of time, they have put up.
This is a 25 matter. How can it be 5 floors be constructed like
My
that?
lord, they have continued with the construction in spite of the entry model. BBMP has not enforced the entry model, my lord, passed by this honorable court.
Order was against R6.
My lord,
Stop construction.
in spite, my lord,
So,
property is the
Stop
same.
construction.
Property is
So,
the same.
It was for you to implement it.
My lords, by then the construction had was completed, your lordships.
Now you demolish it.
We'll demolish.
If your officers have
We'll demolish.
colluded with him, now let them answer him.
N number of representation I have given, my lord.
24th.
Serial number 4, K. Shobha.
If Praveen Raikote has entered appearance for respond number 2, he accepts notice for respond number 3, delete Pawan Kumar. Inspection report.
10 days, my lord, I request.
10 days illa kodakagalla.
Because we have informed them, my lord, I just require some time.
This is the problem, Mr. Raikote, that we are seeing.
First time I am appearing.
Not all assistant executive engineers, they don't submit the report. They delay it. In the meanwhile, they'll allow the construction to go on.
My lordship may pass an order to stop construction. I'll instruct them accordingly.
We have already passed the order. At the inspection stage only, we have passed the order. We don't do it twice.
That I don't know.
We also said sealing also if it doesn't stop. Everything is covered. But if your report doesn't come, we'll have to take action against you AWE and ADTP.
1 week, my lordship.
Not 1 week, tomorrow or day after. Which one do you want?
Yes, day after tomorrow.
At the
Monday,
request
Monday,
of-
your lordship.
Not Monday. At the request of counsel for respond number 2 and 3, relist on 21st for filing of the inspection report. If inspection report is not filed by then, respond number 2 and 3 shall be personally present before this court. Please.
B group matters, serial number 5. Kumar MN.
My lord, regarding
Who appears for respond number 1?
someone has wanted to appear in this matter. Someone has taken a copy, my lordship. They wanted to appear on behalf of respondent one.
Respond number 1. Where is that someone?
Someone, they've taken the copy, my lordship.
They have taken copy from.
From you also,
From them.
not from you.
The regarding the
If they are
disqualification.
not here, what to do?
Another one date, my lordship. Another one date.
Because we already observed that if nobody appears for respond number 1, we'll take it up.
The whip, the president, whether whip has been issued by the.
We have 5 o'clock. Here also, there is no appearance on part of respond number 1. If none were to appear for respond number 1, on the next, one more opportunity is granted for appearance on part of respond number 1. If none were to appear for respond number 1 on next date of hearing, matter would be considered on the basis of submission of the petitioner. Relist on 10th March.
Serial number 6, Arjan, 7. Janardhan Aji.
6 Arjan.
6 Arjan.
7, Mr. Janardhana. None appears. Relist on 16th March.
Serial number 8, Chandrasekhar.
Yes. Bega barbeku. You are appearing. That is not where to appear. You have to appear here. Heli mat. Chandrasekhar. Ashwin.
Application, I said that not there is an exemption up to
50 square meters.
in obtaining the sanction plan in the Bovi colony, that is not abutting to Basveshwar Nagar. Therein, my lord, at the relevant point of time, my lord, we made an application for seeking information from the BBMP. Whether the plan for sanction for construction of the dwelling house is required or not. Then, my lord, they issued an endorsement stating that throughout the Bovi colony, my lord, they did not issued any sanction plan, since it is an exempted area. Your lordship, kindly take, my lord.
Where is Ashwin?
Ashwin idru.
Ellodu.
Lordship, kindly take, my lord, page 45, annexure G.
When you had made this submission, we had asked him to obtain instruction.
Last ಹೇಳಿದೆ.
So he has
But
to make
ಇಲ್ಲಿ
his
ಏನು
submission.
ಬಿಲ್ಡಿಂಗ್ ಬೈಲಾಸ್ ಕೂಡ 50 ಸ್ಕ್ವೇರ್ ಮೀಟರ್ಸ್ ತನಕ ಎಕ್ಸಂಪ್ಷನ್ ಇದೆ. But as is various basis, my lord, at the relevant point of time, they sanctioned the sites. Nandu 55.08 ಬರುತ್ತೆ.
Square meters.
ಹೌದು.
ಸ್ವಲ್ಪ ಜಾಸ್ತಿ ಆಗಬೇಕು.
ಸಣ್ಣ ಸಣ್ಣದು ಅವಾಗ ಎಷ್ಟೆಷ್ಟಲ್ಲಿ ಅವ್ರು ಗುಡಿಸ್ಲು ಹಾಕೊಂಡಿದಾರೋ ಆ ಟೈಮಲ್ಲಿ ಕೊಟ್ಟಿರೋದು.
Anyway, you have an interim order. None appears for the respondent. Compliance with the order date 3/2/26 is yet to be made. Relist on 16th March, interim order earlier granted is extended till next date.
Serial number 9, HP Leeladhar, connected matter.
Wait. The representation is we. Would be to the authorities concerned, respond 1, 2 and 4 for the last.
For the same petitioner, there are 2 different counsels.
For clubbing of sites.
First petition is infructuous. Leeladhar or petition infructuous ಅಂತ ಇದೆ. ನಿಮ್ಮ petition infructuous ಅಂತ ಇದ್ದಾರೆ.
ಅಲ್ಲ ಅವ್ರು ಹೇಳ್ತಾರೆ ಅಷ್ಟೇ. ನಮ್ಗೆ ಕ್ಲಿಬ್ಬಿಂಗ್ ಮಾಡಿಕೊಡೋದಕ್ಕೆ
ಅವ್ರು ಒಪ್ಪೋ ಚಾನ್ಸ್
ಕ್ಲಿಬ್ಬಿಂಗ್ ಮಾಡ್ಕೊಡೋದಕ್ಕೆ ಒಂದು ಪರ್ಮಿಷನ್ ಕೊಟ್ಟು ಖಾತಾ ಮಾಡಿಕೊಟ್ರೆ ಆಗುತ್ತೆ. ನಾವು ಅವ್ರಿಗೆ ಲ್ಯಾಂಡ್ ಬಿಟ್ಟು ಕೊಟ್ಟಿದ್ದೀನಿ, ರೋಡ್ ಮಾಡಿಕೊಟ್ಟಿದ್ದೀನಿ, ಸೇತುವೆ ಕಟ್ಟಿಕೊಟ್ಟಿದ್ದೀನಿ ಕಾರ್ಪೊರೇಷನ್, ಪಬ್ಲಿಕ್ ರೋಡ್ ಇಲ್ಲ ಅಂದಿದ್ದೀನಿ. ಅಂಡ್ ದೇ themselves have passed a resolution.
ಏನಿದೆ, ವಾಟ್ ಇಸ್ ದಿಸ್ annexure Z18?
Yes, sir. It is representation made.
Z18 certiorari ಕೇಳಿದ್ದೀರಾ?
Yes, sir. ಇಪ್ಪತ್ನಾಲ್ಕು ಇಪ್ಪತ್ತೈದರಲ್ಲಿ
ತಿಳುವಳಿಕೆ ಪತ್ರ.
I produce all those documents to the authorities concerned. What they have sought for under annexure X18, in page number
You
135.
have produced it.
Yes, I produce your also, ಅದಕ್ಕೆ 24 page number 25 ತಗೊಳ್ಳಿ. Page number 25 sir.
Page number 86.
86. Yes.
Sketch ಅಲ್ಲಿ.
Para number 6 ಮೇಲ. ಲಿಖಿತವಾದ ಮತ್ತು ದಾಖಲಾತಿಗಳನ್ನು ಪರಿಶೀಲಿಸಲಾಗಿದೆ. ಅರ್ಜಿಯಲ್ಲಿ ನಮೂದಿಸಿದ ವಿಷಯಗಳನ್ನು ಗಮನಿಸಿದಾಗ ನಿವೇಶನ ವಾಸ್ತವ ಉದ್ದೇಶಕ್ಕಾಗಿ ನಿರ್ಮಿಸಲ್ಪಟ್ಟಿದ್ದು ಅದನ್ನು ಮೇಲ್ಮನೆದಾರರು ಶೈಕ್ಷಣಿಕ ಸಂಸ್ಥೆ ಉದ್ದೇಶಕ್ಕಾಗಿ ಶಾಲಾ ಕಟ್ಟಡ ನಿರ್ಮಾಣ ಮಾಡಲು ಪ್ರಯತ್ನಿಸುತ್ತಾರೆ. ಅಲ್ಲದೆ ಖಾತಾ ನಂಬರ್ ಮಧ್ಯದಲ್ಲಿ ಬರುವ 2 ರಸ್ತೆಗಳನ್ನು ಸಹ ಶಾಲಾ ಕಟ್ಟಡ ನಿರ್ಮಾಣ ಮಾಡಲು ಬಳಸಿಕೊಂಡಿರುವುದು ಕಂಡುಬರುತ್ತದೆ. ಪುರಸಭೆ ಆನೇಕಲ್ ಅವರು ದಿನಾಂಕ 8/3/2006 ನಿರ್ಮಾಣದಲ್ಲಿ ನಿರ್ಮಿಸಿರುವಂತಹ ರಸ್ತೆಗಳು ಪುರಸಭೆ ಆಸ್ತಿಯಾಗಿದ್ದು ಅದನ್ನು ಸಮಕ್ಷಮ ಪ್ರಾಧಿಕಾರದಿಂದ ಅನುಮತಿ ಪಡೆಯದೆ ಬೇರೆಯವರಿಗೆ ಕೊಡುವಂತಿಲ್ಲ. ಇದಲ್ಲದೆ ಶಾಲಾ ಕಟ್ಟಡ ಕಟ್ಟಿರುವ ನಿವೇಶನಗಳು ವಾಸದ ಉದ್ದೇಶಕ್ಕಾಗಿ ವರ್ಗೀಕರಿಸಲ್ಪಟ್ಟಿದ್ದು ಉದ್ಯೋಗ ಬದಲಾವಣೆ, ವಲಯ ಬದಲಾವಣೆ, ಯೋಜನಾ ಪ್ರಾಧಿಕಾರದಿಂದ ಅನುಮತಿ ನೀಡಿದೆ. ಇದಲ್ಲದೆ ಕಟ್ಟಡ ನಿರ್ಮಾಣ ಪ್ರಾರಂಭಿಸುವ ಪೂರ್ವದಲ್ಲಿ ಕಟ್ಟಡ ನಕ್ಷೆ ಅನುಮತಿ ಪಡೆಯದೆ ಕಟ್ಟಡ ನಿರ್ಮಾಣ ನಿರ್ಮಾಣಕ್ಕೆ ಪುರಸಭೆಯ ಪರವಾನಗಿ ಪಡೆಯುವುದು ಅಗತ್ಯವಿದೆ. ಅದಲ್ಲದೆ ಈ ಎಲ್ಲ ಅಂಶಗಳನ್ನು ಪರಿಶೀಲಿಸದೆ ಶಾಲಾ ಕಟ್ಟಡ ನಿರ್ಮಾಣ ಮಾಡುವುದು ಕಾನೂನು ಬಾಹಿರವಾಗಿ. ಅದರಿಂದ ಪುರಸಭೆ ಆನೇಕಲ್.
So there is no plan sanction. So now what is the application that they have submitted as per Annex
Your
Z18?
Lordship, is what happened. We have made layouts. Thereafter, Your Lordship, the
In
corporation.
plan sanction ಎಲ್ಲಿದೆ Mr. Leeladhar?
Plan sanction, layout plan sanction, yes, sir. I produced it. It is.
Layout plan sanction.
Yes, Your Lordship.
ಎಲ್ಲಿದೆ? Page number?
I have produced the layout plan.
Page number 2.
Yes,
number?
sir. Your Lordship, see that. Your Lordship, see that. This is the plan, layout plan.
Page number ಹೇಳಿ.
Exhibit annexure C in page number 33.
33.
House.
This sanctioned by whom?
ಮುಖ್ಯಾಧಿಕಾರಿಗಳು ಆನೇಕಲ್ ಟೌನ್ಸ್ ಅದನ್ನ ಅಪ್ರೂವಲ್ ಮಾಡಿದ್ದಾರೆ. ಕೆಳಗಡೆ ಇದೆ ನೋಡಿ. ಇಲ್ಲಿ ಏನಾಗಿದೆ ಅಂದ್ರೆ Your Lordship, this is Nala. There was no the bridge to enter into those property. They sought bid. I have constructed the bid. Thereafter, they want to widen the road. Then Your Lordship, this portion of land I have been given to the corporation, the municipal corporation. This land also. Farmers. Then I sought for ಈ ಲೇಔಟ್ ಅಲ್ಲಿ ಏನು ನಾನು ಸ್ಕೂಲ್ ಕಟ್ತಾ ಇದ್ದೀನಲ್ಲ ಆ ಸ್ಕೂಲ್ಗೆ ಎಲ್ಲಾ ಸೇರಿಟಿಗಳನ್ನ ಕಂಬೈನ್ ಮಾಡಕ್ ಒಂದು ಪರ್ಮಿಷನ್ ಕೊಡಿ ಅಂತ ಕೇಳಿ ಅದು ಇಲ್ಲಿ ಗಂಟ ಅದನ್ನ ತೀರ್ಮಾನ ಮಾಡಿ. ಕ್ಲಬ್ಬಿಂಗ್ ಆಫ್ ಸೆಲ್ಸ್
ಬೇರೆ ಯಾರಿಗೂ ಸೇಲ್ ಆಗಿಲ್ಲ,
ಯಾರಿಗೂ ಸೇಲ್ ಮಾಡಿಲ್ಲ, ಏನ ಸ್ಕೂಲ್ ನಡೆಸ್ತಾ ಇದೀವಿ. 1,600 ಜನ ಸ್ಟೂಡೆಂಟ್ಸ್ ಇದ್ದಾರೆ. ಇದು ರೆಕಗ್ನೈಸ್ ಸ್ಕೂಲ್. ನಾನು ಅವರಿಗೆಲ್ಲ ಅಷ್ಟು ಬೆನಿಫಿಟ್ ಮಾಡ್ಕೊಟ್ಟಿದ್ದು. ನಾನು ಕೇಳ್ತಿರೋದಷ್ಟೇ, ನನ್ನ ಲೇಔಟ್ ಅದು, ನಾನು ಫಾರ್ಮೇಶನ್ ಮಾಡಿದ್ದೀನಿ. ಈಗ ಸ್ಕೂಲ್ ನಡೆಸ್ತಾ ಇದೀವಿ, ಸ್ಟೂಡೆಂಟ್ಸ್ ಇದ್ದಾರೆ, 1,600 ಜನ ಸ್ಟೂಡೆಂಟ್ಸ್. ಅವರಿಗೋಸ್ಕರ ನನಗೆ ಇದು ಕ್ಲಬ್ಬಿಂಗ್ ಮಾಡ್ಕೊಡಿ ಸೈಟ್ಗಳನ್ನ ಅಂತ ಕೇಳಿದೆ.
ಈ ಲೇಔಟ್ ಪ್ಲಾನ್ ಸ್ಯಾಂಕ್ಷನ್ ಕ್ಯಾನ್ಸಲೇಷನ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದೀರಾ?
ಕ್ಯಾನ್ಸಲ್ ಅಪ್ಲಿಕೇಶನ್ ಕೊಟ್ಬಿಟ್ಟು ಕ್ಯಾನ್ಸಲೇಷನ್ ಅಪ್ಲಿಕೇಶನ್ ಕೊಡಲಿಲ್ಲ. ಈ ಸೈಟ್ಸ್ ಗಳಿದೆಯಲ್ಲ ಆ ಸೈಟ್ಗಳ ಒಂದು ಕಂಬೈನ್ ಮಾಡ್ಬಿಟ್ಟು
ಅಮಾಲ್ಗಮೇಷನ್ ಮಾಡಿ
ನನಗೊಂದು ಪ್ಲಾನ್ ಕಾಸ ಕೊಟ್ಬಿಡಿ, ಸ್ಯಾಕ್ಷನ್ ಪ್ಲಾನ್ ಕೊಡಿ ಅಂತ ಕೇಳಿದ್ದೀನಿ. ಅಂದ್ರೆ ಇಲ್ಲಿ ಗಂಟ ಕನ್ಸಿಡರ್ ಮಾಡಿಲ್ಲ.
Now they have constructed illegally, that will come to. But this particular amalgamation ಮಾಡಕ್ಕೆ ಏನು ಪ್ರಾಬ್ಲಮ್?
Conversion is residential. conversion is residential purpose. Now it's coming for semi-commercial.
Correct. Now they'll apply for all of it.
This is completely deputy commissioner. Page number 87 is operative.
Leela, you'll have to do, we can't advise you on this. You'll.
One ನಿಮಿಷ.
What all you have to do, you will have to advise your client.
I'll submit it.
But what you have done is not sufficient.
ಅಲ್ಲ, ಇಂಕ್ ಪೇಜ್ ನಂಬರ್ 25 ತಗೊಳ್ಳಿ ಸರ್. ಯಾಕೆಂದ್ರೆ ಕನ್ವರ್ಷನ್ ಮಾಡ್ಬೇಕಾದ್ರೆ ಮಧ್ಯದ ಲಾಸ್ಟ್ ಇಂಕ್ ಪೇಜ್ ನಂಬರ್ 25. ಸೆಕೆಂಡ್ ಪ್ಯಾರ 2011ನೇ ಇಸ್ವಿಯಲ್ಲಿ ತಮ್ಮದೇ ಕಚೇರಿಯಲ್ಲಿ 21 ನಿವೇಶಗಳನ್ನು ಒಂದುಗೂಡಿಸುವ ಕಾರ್ಯವಾಗಿದ್ದು ಅದರಂತೆ ಮಿಟೇಷನ್ ಮಾಡಿ ಅಸೆಸ್ಮೆಂಟ್ ಮಾಡಿ ನಕಲನ್ನು ನೀಡಿರ್ತೀರಿ. ಆಸ್ತಿ ಹಕ್ಕನ್ನು
ಓದ್ತಾ ಇದ್ದೀರಾ ನೀವು 25 ಅಲ್ಲಿ
ಅನೆಕ್ಷರ್ ಎ ಇವಲ್ಲ. ಅನೆಕ್ಷರ್ ಸೆಕೆಂಡ್ ಪ್ಯಾರ
24
2011ನೇ ಇಸ್ವಿಯಲ್ಲಿ ತಮ್ಮದೇ ಕಚೇರಿಯಲ್ಲಿ 21 ನಿವೇಶಗಳನ್ನು ಒಂದುಗೂಡಿಸುವ ಕಾರ್ಯವಾಗಿದ್ದು ಅದರಂತೆ ಮಿಟೇಷನ್ ಮಾಡಿ ಅಸೆಸ್ಮೆಂಟ್ ನಕಲನ್ನು ಕೊಟ್ಟಿರ್ತೀರಿ. ಆಸ್ತಿ ಹಕ್ಕನ್ನು ಒಟ್ಟುಗೂಡಿಸುವ ಅಧಿಕಾರ ತಮಗೆ ಮಾತ್ರ ಇರುತ್ತೆ ಹೊರತು ನಗರಾಭಿವೃದ್ಧಿ ಪ್ರಾಧಿಕಾರಕ್ಕೆ ಆಪ್ತಿಗೆ ಬರುವುದಿಲ್ಲವೆಂದು ನಗರಾಭಿವೃದ್ಧಿ ಪ್ರಾಧಿಕಾರವು ಉಲ್ಲೇಖಿಸಿದ ಪತ್ರವನ್ನು ತಮ್ಮ ಅವಗಾಹನೆ ಕಲಿಸಿರುತ್ತೇನೆ. ಇನ್ನು ಕಟ್ಟಡ ನಿರ್ಮಾಣ ಲೈಸೆನ್ಸ್ ಮತ್ತು ನಕ್ಷೆ ಮುಂಜಾಗ್ರತೆಗೆ ತಮ್ಮ ಕಚೇರಿಗೆ 2003ರಲ್ಲಿ ಆಗಾಯ್ತು ನಾವು ಸಲ್ಲಿಸುವ ಅರ್ಜಿ ಮತ್ತು ಎಂಡಾರ್ಸ್ಮೆಂಟ್ ಪ್ರತಿಗಳನ್ನು ಸಹ ಇದೊಂದಿಗೆ ಲಗತ್ತಿಸುತ್ತೇನೆ. ದಿನಾಂಕ 29/8/2017 ನಮ್ಮ ಮನವಿ ಪತ್ರ ತಮ್ಮ ಕಚೇರಿಗೆ ಸಲ್ಲಿಕೆಯಾಗಿದೆ. ಆದಾಗ್ಯೂ ಸಹ ಕಚೇರಿಯ ಕಡೆಯಿಂದ ಯಾವುದೇ ಪ್ರತಿಕ್ರಿಯೆ ಬಂದಿರುವುದಿಲ್ಲ. ಸದರಿ ಮನವಿ ಪತ್ರದಲ್ಲಿ ತಮ್ಮ ಕಚೇರಿ ಮತ್ತು ಸಂಸ್ಥೆಯ ನಡುವೆ ನಡೆದ ಎಲ್ಲಾ ಆಡಳಿತಾತ್ಮಕ ವ್ಯವಹಾರಗಳ ಚಿತ್ರಣವನ್ನು ನೀಡಿದ್ದು ತಮ್ಮ ಎಲ್ಲಾ ಪ್ರಶ್ನೆಗಳಿಗೆ ಉತ್ತರವನ್ನು ನಾವು ಕಾಣಬಹುದಾಗಿದೆ. ಈ ಮನವಿ ಪತ್ರದ ಪ್ರತಿಯನ್ನು ಸಹ ತಮ್ಮ ಅವಗಾಹನೆಗೆ ಲಗತ್ತಿಸುತ್ತೇನೆ. ತಮ್ಮ ಅಂತಿಮ ತಿಳುವಳಿಕೆ ಪತ್ರವು ತಾವು ಉಲ್ಲೇಖಿಸಿರುವಂತೆ ಕಾನೂನು ಬಾಹಿರ ಚಟುವಟಿಕೆಗಳು ಮೂಡಿಸಿ ತನ್ಮೂಲಕ ಸತ್ಪ್ರಜೆಗಳನ್ನು ಸಮಾಜಕ್ಕೆ ಕೊಡುವ ನೀಡುತ್ತಿರುವ ಈ ವ್ಯವಸ್ಥೆಯನ್ನು ಮನಗಂಡು ಸದರಿ ತಿಳುವಳಿಕೆ ಪತ್ರವನ್ನು ವಿಲೇವಾರಿ ಮಾಡಿ ನಮ್ಮ ಮನವಿಯಲ್ಲಿ ಪತ್ರದಲ್ಲಿ ಉಲ್ಲೇಖಿಸಿರುವಂತೆ ನಮ್ಮ ಕೆಲಸ ಮಾಡಿಕೊಳ್ಬೇಕಾಗಿ ಪ್ರಾರ್ಥಿಸುತ್ತೆ. ದನ್ 27 ಬರಲ್ಲ ಅನದರ
ಮಾಡ್ಕೊಳ್ಬೇಕು ಅಂತೆಲ್ಲ ನೀವು ಯು ಹ್ಯಾವ್ ಟು ಫಾಲೋ ದ ಲಾ. ಯು ಹ್ಯಾವ್ ವೈಲೇಟೆಡ್ ಆಲ್ ದ ಲಾಸ್.
ಒಂದೇ ನಿಮಿಷ ಹೇಳ್ತೀನಿ. ನಾನು ಪ್ಲಾನು ಲೈಸೆನ್ಸ್ 2003ರಲ್ಲಿ ಅರ್ಜಿ ಕೊಟ್ಟಿದ್ದು ಇಲ್ಲಿ ಗಂಟ ತೀರ್ಮಾನ ಮಾಡಲಿಲ್ಲ, ಹಾಗೆ ಇಟ್ಟುಕೊಂಡಿದ್ದಾರೆ. ಅನಂತರ
ಪ್ಲಾನು ಲೈಸೆನ್ಸ್ ಆನ್ ಎ ಲೇಔಟ್ ವಿಚ್ ಇಸ್ ಬೀನ್ ಫಾರ್ಮ್ ಫಾರ್ ರೆಸಿಡೆನ್ಷಿಯಲ್ ಪರ್ಪಸ್ ವಿತ್ ವೇರಿಯಸ್ ಸೈಟ್ಸ್. ನೀವು ಯಾವ ಪ್ಲಾನ್ ಕೊಟ್ಟರು ಯಾರು ಅಪ್ರೂವ್ ಮಾಡಕ್ ಆಗಲ್ಲ.
ಅಲ್ಲ ಕರೆಕ್ಟ್, ಅದಕ್ಕೋಸ್ಕರ ನಮ್ ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಪೆಂಡಿಂಗ್ ಇದೆ 2003ರಿಂದ.
ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಮೇಲೆ ಕ್ಯಾನ್ ಎನಿಥಿಂಗ್ ಹ್ಯಾಪನ್?
ಅದು ಮಾಡಕ್ಕಾಗಲ್ಲ. ಮತ್ತೆ ಐ ಅಗ್ರಿ, ಬಟ್ ಒನ್ ಥಿಂಗ್ ಇವಲ್ಲ, ಇದ್ರ ಮೇಲೆ ಅವ್ರು ಏನಾದ್ರು ಆರ್ಡರ್ ಮಾಡಿದ್ರೆ ನನಗೆ ನಾನು ಅದನ್ನ ಬೇರೆ ಯಾವ್ದು ಪರಿಸ್ಥಿತಿ ನೋಡ್ಕೊಳ್ತಾ ಇದ್ದೆ.
No vested right for us to issue.
ಅಲ್ಲ, ಇವನ್ municipality is also made a resolution to amalgamation of all these sites. They have passed a resolution. ಅದಾದ್ಮೇಲೆ ನಮ್ಮನ್ನು ಕೇಳ್ಕೊಂಡ್ರು ನೀವು ಮೋರಿ ಕಟ್ಸ್ಕೊಡಿ ಮತ್ತೆ ಒಂದು ಸೈಟ್ ಬಿಟ್ಟು ಕೊಟ್ಬಿಡಿ ರೋಡಿಗೋಸ್ಕರ.
ರೆಸಲ್ಯೂಷನ್ ಎಲ್ಲಿ ಪಾಸ್ ಮಾಡಿದ್ದಾರೆ ಅದು?
ತೋರಿಸ್ತೀನಿ
ಟು ಅಮಾಲ್ಗಮೇಟ್.
ವಿಲ್ ಶೋ ಇಟ್. ಇಂಟರ್ನಲ್ ಪೇಜ್ 67 ಇವರು
67.
ಇಂಟರ್ನಲ್ ಪೇಜ್ 60 ಅನೆಕ್ಷರ್ ಎಫ್ ಇವರ ಪೇಜ್ 60. ಆನೇಕಲ್ ಪುರಸಭೆಯ ವ್ಯಾಪ್ತಿಯಲ್ಲಿರುವ ಹೊಸ ಪ್ರವಾಸಿ ಮಂದಿರದ ಮೂಲಕ ಬನ್ನೇರುಘಟ್ಟ ರಸ್ತೆಗೆ ಹೂವಾಡಿಗಾರ್ ಬೀದಿ ಮುಖಾಂತರ ಮಾಡಿರುವ ಸಂಪರ್ಕ ರಸ್ತೆಯನ್ನು ದೊಡ್ಡ ಚರಂಡಿಯವರಿಗೆ ಬಂದು ನಿಂತಿರುವುದನ್ನು ಸಭೆಯು ಕೂಲಂಕಷವಾಗಿ ಚರ್ಚಿಸಿತು. ಇದಕ್ಕೆ ಹೊಂದಿಕೊಂಡಿರುವಂತಹ ಇರುವ ಮಾರುತಿ ಬಡಾವಣೆಯ ಮುಖ್ಯ ರಸ್ತೆಗೆ ಸಂಪರ್ಕ ಕಲ್ಪಿಸಲು ಸಿ ವಿಭಾಗದ ಲೇಔಟ್ನಲ್ಲಿ ಸಾರ್ವಜನಿಕರ ಹಿತದೃಷ್ಟಿಯಿಂದ ರಸ್ತೆಗಾಗಿ ನೇರ ಸಂಪರ್ಕ ಕಲ್ಪಿಸಲು ಅನುಕೂಲವಾಗುವಂತೆ ರಸ್ತೆ ಜಾಗ ಪಡೆಯಲು ಹಾಗೂ ರಸ್ತೆಗಾಗಿ ಪಡೆದ ಜಾಗಕ್ಕೆ ಪರ್ಯಾಯವಾಗಿ ಲೇಔಟ್ ಅಲ್ಲಿ ಇನ್ನೊಂದು ಭಾಗದಲ್ಲಿ ನಿವೇಶಕಗಳಿಗೆ ಅವಕಾಶ ಕಲ್ಪಿಸಿಕೊಟ್ಟು ಲೇಔಟ್ ವಿನ್ಯಾಸವನ್ನು ಮಾರ್ಪಾಡು ಮಾಡಿಕೊಂಡು ಹೋಗಲು ಸಭೆಯು ಸರ್ವಾನುಮತದಿಂದ ತೀರ್ಮಾನ ಮಾಡಿದ್ದಾರೆ. ಇದು ತೀರ್ಮಾನ ಆದ್ಮೇಲೆ
ಲೇಔಟ್ ಮಾಡಕ್ಕೆ ನಿಮ್ಗೆ ಏನ್ ಸರೆಂಡರ್ ಮಾಡ್ತಿರೋ ಅಲ್ಲಿ ಬೇರೆ ಜಾಗದಲ್ಲಿ ಮಾಡ್ಕೊಡಕ್ಕೆ
ಅದೊಂದು
ಅನುಮತಿ ಕೊಡ್ತಾರೆ. ಅಮಾಲ್ಗಮೇಷನ್ ಇಲ್ಲಿ
ಇನ್ನೊಂದು ನಿಮಿಷ, ಇನ್ನೊಂದು ಭಾಗದಲ್ಲಿ ನಿವೇಶನಗಳಿಗೆ ಅವಕಾಶ ಕೊಟ್ಟು ಲೇಔಟ್ ವಿನ್ಯಾಸವನ್ನು ಮಾರ್ಪಾಟು ಮಾಡಲು
ಮಾರ್ಪಾಟು ಎಕ್ಸ್ಚೇಂಜ್
ಕೆಲವು ಸೈಟ್ಸ್ ಗಳು ನಾನು ಸ್ಕೂಲ್ ಬಿಲ್ಡಿಂಗ್ ಗೋಸ್ಕರ.
ಅಮಾಲ್ಗಮೇಷನ್ ಎಲ್ಲಿದೆ ಮಿಸ್ಟರ್ ಡೀಲರ್?
ಅದೇ ಹೇಳ್ತಿದ್ರು, ಲೇಔಟ್ ವಿನ್ಯಾಸವನ್ನು ಮಾರ್ಪಾಟು ಮಾಡಲು. ಅಮಾಲ್ಗಮೇಷನ್ಗೆ ನಾವು ಅರ್ಜಿ ಕೊಟ್ಟಿದ್ದದ್ದು.
ಮಾರ್ಪಾಟು ಮಾಡೋದು ಅಮಾಲ್ಗಮೇಷನ್ ಅಲ್ಲ.
ಯಾಕೆ ಅಂತಂದ್ರೆ
ವಿಲ್ ಡಿಸ್ಮಿಸ್ ಯುವರ್ ಪೆಟಿಷನ್ permitting you to make suitable application to the deputy commissioner and
ಡೆಪ್ಟಿ ಕಮಿಷನರ್ ನನಗೆ ಬರಲ್ಲ ಅಂತ ಕೊಟ್ಬಿಟ್ಟಿದೆ. ನಾನು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದೀನಿ ಅನೆಕ್ಷರ್. ಅವರು ಬರಲ್ಲ ಅಂತ ಹೇಳಿದ್ರು. ಆನೇಕಲ್ ಟೌನ್ ಪ್ಲಾನಿಂಗ್ ಅಥಾರಿಟಿ ನಮ್ಮ
ಅಪ್ಲಿಕೇಶನ್ ರಾಂಗ್. ನಾವು ವಿ ಕಾಂಟ್ ಅಡ್ವೈಸ್ ಯು ಏನ್ ಮಾಡ್ಬೇಕು ಅಂತ ಹೇಳ್ಕೊಡ್ಬೇಕಾ? ನಿಮ್ಗೂ ಗೊತ್ತಿರೋದೆ.
ಅಲ್ಲ ಎಲ್ಲಿ
ನಿಮ್ಗೆ ಗೊತ್ತಿಲ್ಲದೆ ಇರೋದಲ್ಲ ಇದು.
ಅಲ್ಲ ವೈ ಆಮ್
ನೀವು ಹಿಂಗೆ ವೈ ಅಂತ ಗೊತ್ತು. Follow the applicable law, get those 3-4 things done before you go for
do
amalgamation.
it. There is no impediment for us to once again approach the competent authority also.
This you are kept pending from 2018.
Okay.
Petitioner is before this court seeking for the following leaves. Idu 9. The petitioner had made an application for amalgamation of kata in respect of various sites. ಅದೇ ಅದು ನೆಕ್ಸ್ಟ್ ಬರ್ತೀವಿ ಅದಕ್ಕೆ. In survey number 75/1, 75/2, 75/3 and 75/4 of ಯಾವ village ಇದು? Which village is this?
Pardon? That is Anekal.
Anekal village, Anekal
House.
Taluk.
Anekal municipal town limit.
The respondent had called upon the petitioner to furnish certain documents via Annexure Z18. It is challenging the same, the petitioner is before this court. The submission of the learned counsel for the petitioner is that though a residential layout had been formed in terms of Annexure C, subsequently the said lands have been put to use for construction of a school building and playground. And in that background, for the benefit of the school, the amalgamation application had been filed, which not having been considered. The further application which had been submitted for sanction of plan has not been considered. It being without doubt that it being admitted that there was a plan sanction for a residential layout which had been granted. There are sites which have been formed as regards which kata has been issued. An amalgamation application having been filed would not help the petitioner to obtain a plan sanction for a school building in the said property, inasmuch as the property is converted for residential purposes. For a school building to be constructed, the same would have to be converted for commercial purposes or educational purposes if provided in that particular area. That apart, the change of land use. CDP ಬಂದಿದೆ ಯಾವಾಗ ಇಲ್ಲಿಗೆ? ಆನೇಕಲ್ ಪ್ಲಾನಿಂಗ್ ಅಥಾರಿಟಿ ಅಲ್ಲಿ ಬರಲ್ವಾ ಇದು?
ಅಲ್ಲ ಅವರು ನಮಗ್ ಬರಲ್ಲ, ಪಂಚಾಯತ್ ಮುನ್ಸಿಪಾಲಿಟಿನ ಅಪ್ರೋಚ್ ಮಾಡಿದ್ರು.
ಆನೇಕಲ್ ಪ್ಲಾನಿಂಗ್ ಅಥಾರಿಟಿ ಬರಲ್ಲ. That apart, now that Anekal Planning Authority, now that the land comes within the Urban Planning Authority, necessary change of land use.
Ink page number ಸ್ವಲ್ಪ 90 ಒಂಚೂರು ನೋಡ್ಬಿಡಿ ಸರ್. ನಾವೇನ ಸಪ್ರೆಸ್ ಮಾಡಿದ್ವಿ ಅಂತ ಹೇಳಿ. Ink page number 90
ಅಲ್ಲ, ನೀವು ಅಪ್ಲಿಕೇಶನ್ ಸರಿಯಾಗಿ ಮಾಡಿಲ್ಲ.
Ink page number 91. ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಮೇಲ್ಗಾಂವ್ ಮನವಿ ದಾಖಲೆಗಳನ್ನು ಪರಿಶೀಲಿಸಿ ನೀವು ಕೋರಿದ ಜಾಗವು ಆನೇಕಲ್ ತಾಲೂಕು ಕಸಬಾ ಹೋಬಳಿ ಆನೇಕಲ್ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ ಸೋನ್ಸೋಲಿ ತಹಸೀಲ್ದಾರ್ ವಸತಿ ಉದ್ದೇಶಕ್ಕೆ ಭೂಪೂರ್ತನೆಯಾಗಿ ಈ ಸಾಲಿನ ಆನೇಕಲ್ ಪುರಸಭೆಯಿಂದ ವಿನ್ಯಾಸ ನಕ್ಷೆ ಅನುಮೋದನೆ ಹಾಗೂ ಖಾತೆಗಳನ್ನು ಸಹ ಪಡೆಯಲಾಗಿದೆ. ಈ ಪೈಕಿ ನಿವೇಶಗಳು ನಿಮ್ಮ ಟ್ರಸ್ಟಿಗೆ ವರ್ಗಾಯಿಸಲು ನಿವೇಶಗಳು ಈಗಾಗಲೇ ಶಾಲಾ ಕಟ್ಟಡವನ್ನು ಕಟ್ಟಿ ಶಾಲೆ ನಡೆಸುತ್ತಿರುವುದಕ್ಕೆ ಪ್ರಾಧಿಕಾರದಿಂದ ಆನೇಕಲ್ ಪುರಸಭೆಗೆ ಖಾತೆ ಮಾಡಲು ಮತ್ತು ಕಂದಾಯ ವಿಧಿಸಲು ಅನುವು ಮಾಡಿಕೊಂಡು ಕೋರಿರ್ತೀರಿ. ಈ ರೀತಿ ಖಾತೆ ಮಾಡಲು ಕಂದಾಯ ವಿಧಿಸುವ ಬಗ್ಗೆ ಈ ಮನವಿಯಲ್ಲಿ ಈ ಪ್ರಾಧಿಕಾರ ವ್ಯಾಪ್ತಿಗೆ ಬರುವುದಿಲ್ಲ. ಅವ್ರನ್ನ ಕೇಳಿದ್ರು, ಮತ್ತೆ ಆದ್ಮೇಲೆ ಮತ್ತೆ ಇವ್ರಿಗೆ ರೆಪ್ರೆಸೆಂಟೇಷನ್
ಹೇಳ್ತಾರೆ, ರಾಂಗ್ ಇದಕ್ಕೆ ಕೇಳ್ತಾರೆ, ಅದಕ್ಕೆ ಬರಲ್ಲ ಅಂತಾರೆ. Change of land use from the said planning authority. The residential layout plan which had been sanctioned is also required to be cancelled before any further action could be taken. None of these having been done, the question of the petitioner seeking for a building plan sanction for as regards the building already constructed cannot be considered. There is no vested right created in favor of the petitioner without compliance of all the above. Reserving liberty to the petitioner to comply with the above and then approach the appropriate authority. The petition stands dismissed. 9.1, you are not appearing in that.
Pardon?
9.1 ನೀವು appear ಆಗ್ತಾ ಇಲ್ವಾ?
ಅದ್ರಲ್ಲಿ ನಾವಿಲ್ಲ, ಬೇರೆ
ಅರೆ ದೇವಾನಂದ್.
ಇದು ದೇವಾನಂದ್.
None appears for the petitioner. If none were to appear for the petitioner on the next date appearing, dismissal. Released on 16th March.
Serial number 10. Abhinav.
You know?
My lord, I am appearing for petitioner, my lord.
Yes, Vivek.
My lord, this matter, my lord, pertains to, my lord, the widening of Bannerghatta Road, my lord. The respondents, my lord, the widening of Bannerghatta Main Road.
Still not widened from 2019.
My lord, they have widened the road. But insofar as, my lord, the scheduled property of the petitioners are concerned, my lord, in that stretch, my lord, they have not widened because there is a interim order granted by this honorable court, my lord.
How is
On
this
23,
repetition maintainable?
my lord, without acquiring the properties, my lord, in accordance with law, my lord, without issuing any notification, my lord,
No
they have.
objection for acquiring.
Melodic.
Acquire the land.
If it is acquired, it will be in accordance with law. That is what they have stated.
Petitioner is before this court seeking for the following reliefs. These kind of matters you please mention. It's coming in the way of public development. Please mention and get it listed.
Please, ma'am.
Petitioner is before this court seeking for the following reliefs. The grievance of the petitioner when he approached this court on 11 January 2019 by filing the above petition was that without acquiring the land of the petitioner, the respondents are proposing to widen the Bannerghatta Road. Learned AGA today has filed a memo stating that the respondent would acquire the land.
Counsel for BBM.
Counsel for the BBM, new dual role madada kashta. Counsel for the respondent number 1 and 2 BBMP. Respondent number 1 and 2 BBMP submits that the said road would be widened by following due procedure of law by acquiring the land and making payment of compensation to the petitioner. Learned counsel for the petitioner today submits that if an acquisition is resorted to, the petitioner will have no objection for the said acquisition, so long as the compensation is paid in terms of the right to fair compensation, So Act 2013. In that view of the matter, I pass the following order. Writ petition is disposed, reserving liberty to the respondents to acquire the land of the petitioner to the extent required for the purpose of widening of the Bannerghatta Road under the Right to Fair Compensation Act and making payment of compensation to the petitioner until the acquisition is made and compensation is paid. Respondents are restrained from dispossessing the petitioner from the subject property.
Please, my lord. I'm grateful, my lord.
Serial number 11. Nitin Prasad.
Yes, Nitin.
My lord, the challenge is, my lord, to order at annexure R, page 67. Appellate authority, my lord, allows the appeal of respondent number 1, directs, my lord, that kata be restored in her name, despite the fact that she has sold the property to the petitioner. Nothing is disclosed. No notice to me.
By respondent number, who has sold it?
1, my lord, 1.
Respondent number 1, Kamalamma. Who appears for respondent number 1? K. Srinivasa.
But he has not been appearing, my lord, perhaps because, my lord, I have also filed a memo, my lord, dated 16/6/2025. Respondent number 1 had filed a suit against me for an injunction. The ex parte order was granted. I filed an.
You'll have to put them on note.
Yes. What is it?
They are so many or idra. None appears for respondent number 1. Counsel for the who is respondent number 3?
My lord, is
why is it
this was dispensed with?
Who is respondent number 3?
He is, my lord, made a party in the appeal.
Why?
He is no more, my lord.
Why is he made a party and why is it dispensed with? 18/1/19.
He's not a party in any of the litigations.
You have filed, so you won't be bound by. None appears for respondent number 1. Counsel for the petitioner is direct furnished 2 sets of the petition along with annexures on Shri MS Devraj, who
No,
appears
it is done.
Prakash, you will be appearing.
Yes.
Mr. Devraj, you already ಕೊಟ್ಟಿದ್ದೀವಿ. ಇಲ್ಲ ಕೊಟ್ಟ ಆಗಿದೆ
ನಿಮ್ಗೆ
ಮೆಮೊನ
ಕೊಟ್ಟಿದ್ರೆ ಕಾಪಿ
ಹಾಕಿದೆ.
ಅಲ್ಲಿ ಕೊಡಿ, ಮತ್ತೆ ಪೇಪರ್ ವೇಸ್ಟ್ ಮಾಡಬೇಡಿ.
Sir, and we have filed with acknowledgement already. Anyway, I'll serve it again. I've already filed.
You will serve it. We don't want the paper to be wasted like that. ಕೊಟ್ಟಿಲ್ವಾ? Prakash submits that he would be appearing for respond number 2 and 4. Registries direct print his name as such and delete the name of Shri MS Devraj as that appearing for respond 2 and 4. Counsel for the petitioner furnished 2 sets of the petition along with annexures on Shri Prakash, who seeks for and is granted 2 weeks time to obtain instruction, make his submission. None appears for respond number 1. If none were to appear for respond number 1 on the next date of hearing, matter would be taken up for consideration on the basis of the submissions made by the councils present. Released on 16th March.
Serial number 12.
Great.
DIG Sadashivaya.
I appear for respondent number 3, my lord. Kindly a week's accommodation may be given, my lord.
Why do you want a week's accommodation?
My senior is not available today, my lord.
The request of counsel for respond number 3, released on 16th March. It's made clear that no further adjournment would be granted.
Interim order.
Interim order earlier granted is extended till next day.
13. Ravi Kumar JS.
Petition. 1, 2, 3. ZP Mangalore yaru?
Sharanjit Shetty.
Sharanjit Shetty is directed to accept notice for respond number 4. Counsel for the petitioner to serve 2 sets of the petition along with annexures on the said counsel. You filed your objections?
No, your lordship, I'm appearing for respond number 2.
No relief against you. You want to file your objection, you don't want to file it.
Your lordship, it's about the report that has to be submitted. Spot inspection.
Direction is against respond number 2 to 4.
It's already there, report is there.
Yes. You have received the copy. We have received the copy.
Yes, your lordship, we have received the copy, your lordship.
Report is there.
Yes.
What is your submission?
We will file the statement of objection in the next stage.
You want to, it's in your favor, report.
Yes, ma'am.
Counsel for respond number 2 seeks for and is granted 10 days time to file or objections to the inspection report. Objections, if any, by 6th March, released on 11th March.
Yes, your lordship.
14.
Sorry, 10th March. Raju, what about you? You want to file objections? Illa.
No relief has started
No
against me.
relief. Then counsel for respond number 4 submit that he does not wish to file any objections on behalf of respond number 4. 14 only. And AGA accepts notice for respond number 5 also, registries direct printer name as such. And AGA seeks for and is granted 10 days time to file a statement of objection. Objections, if any, by 6th February, failing which will be taken as not filed and matter proceeded with. Released on 17th March.
Yes.
Whatever reaches, reaches. Serial number 28, Junal code, how reach?
My lord. One submission will be serial number 46 is first list. In spite of the interim order of stay granted by lordships, the four corresponding PDO today went to the spot and removed the fencing, my lord. Interfered with the portion, my lord. MS Devraj is very much here. The interim order was
PDO,
passed in his
assistant executive engineer.
Knowingly stay ಇದೆ ಅಂತ ಹೇಳಿ ಕೂಡ ತಾವು stay ಮಾಡಿ ಕೂಡ
Contempt petition.
Serial number 35.
Ah.
We have not sealed the property.
Passed over matter, 35. Kodi ಅದು. Madam, we have been sitting till 5:30. Then from tomorrow we'll get up at 4:45. Don't be making all this submissions. Sorry. Yes. Yes, Karthikeyan.
Please, Manoj.
My client is very much there in the spot. He has reported. They have not
If I may
seen.
just take my lordship's 15 seconds, my lord.
They have proceeded with the slab work is what your lordship found. Found fault with the AE who is before the court.
My lords, 11th, the interim order was passed, my lords. 13th, an intimation.
We have informed them immediately with covering letters. I have got proof. I have filed it also.
Lords, I'll complete my arguments, my lords.
Hmm,
Lords,
clearly.
11th interim order was passed, my lords. 13th a notice was issued to stop all activities, my lords. Again on 23rd, my lords, there was an inspection, and even before that on 30th, my lords, we have stuck on the stuck the notice of no further construction on the property, my lords. On 23rd, we have again done an
Place
inspection, my lords.
everything before the chief commissioner in the inquiry that we have directed to be conducted. If your officers are going to be doing like this, we have to take action.
Lords, they have
There are no other
actively,
option.
Allah, my lords, they have actively, they've gone ahead to ensure that
They have actively constructed.
Yes.
ಅವ್ರು ಏನ್ ಮಾಡಿದಾರೆ ಮೆಲಾಡ್ಸ್ ಆನ್ 7th of January ಮೆಲಾಡ್ಸ್ ನಮಗ್ ಗೊತ್ತಿಲ್ಲದೆ ಅವರು ಫಸ್ಟ್ ಫ್ಲೋರ್ ಸ್ಲಾಬ್ ಹಾಕಿದ್ದಾರೆ. ಅದಾದ್ಮೇಲೆ ಮೆಲಾಡ್ಸ್
ಪೊಲೀಸ್ ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ರ
ಕೊಟ್ಟಿಲ್ಲ.
ಏನ್ ಮಾಡೋದು ಈಗ?
ಮೆಲಾಡ್ಸ್ ವಿ
ಹೋಗ್ಬಿಟ್ಟು ಬರೀ ಹಚ್ಬಿಟ್ಟು ಬಂದ್ರಿ.
ಆಮೇಲೆ ವಿ ಹ್ಯಾವ್ ಟೋಲ್ಡ್ ದೆಮ್ ನಾಟ್ ಟು ಟೇಕ್ ಎನಿ ಫರ್ದರ್ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಆಕ್ಟಿವಿಟೀಸ್ ಮೆಲಾಡ್ಸ್ ಮಾಡಿಲ್ಲ ಮೆಲಾಡ್ಸ್. ಅದಾದ್ಮೇಲೆ
ಒಂದ್ ಕೆಲಸ ಮಾಡ್ತಾರೆ ಲೋಕ್ರೆ ಅವ್ರ ಪಕ್ಕದ ಮನೆಯಲ್ಲಿ ಒಂದು ರೂಮ್ ಕೊಟ್ಬಿಡ್ತಾರೆ ಅವ್ರು ಇದಕ್ಕೆ. ಅಲ್ಲೇ ಇದ್ಬಿಡಿ and see that it is not constructed.
Now the CCTV is also installed, my lords, and so no further construction, my lords.
Agli dictate agide. Further memo along with documents has been filed. The same is taken on record. Submission of Shri B.S. Karthikeyan is that the orders passed by this court had been struck on the premises, despite which respond number 5 and 6. That is his submission. You can reply to it. 5 and 6 have constructed, ignoring the orders passed by this court. The details, the fact however remains that the construction has happened under the purview and under the administrative jurisdiction of respond number 4, as regards which already an inquiry has been ordered. Yes.
Lords.
My submission to Lordship is already I made a submission that the slab was put on 7th of January.
Correct.
What notice they are referring, my lord, is issued to us on 13th of January. So, my lord, we were not aware. On 7th, we had put up the slab, and after that, my lord, there is no construction except for watering, my lord. The cement portion, we have not done anything.
My lords, the page number 2, my lords, it is on 1712, my lords, and the same was
1712
stuck.
is the notice.
Yes, please. And the same was stuck
They claim that 1712.
on 1712, my lords.
13.1 is where I have received.
And that 1712 is being stuck on the wall as per page
3, my lords.
3.
Please, yes, my lords. On page 3, it has been stuck on 1712, my lords. The same notice was issued also through RPAD, my lords. And again on my lords.
Lord, I'll file my appeal because we have on record, my lord, that it was given to us on 13th. It was stuck on.
13th also again it's been given. 1712 also is been given.
My lords, again on 2012.
Now what will happen, Mr. Nandish,
Please.
is that whatever equitable consideration that we have for not demolishing, that won't apply to you. And your violation is 100%.
Lord, to that, in that, my lord, may I make this submission? Lord?
Please see the report is 100%.
Yeah, your lordship may kindly signal 2026 bylaws prakara.
So,
In order
yavattu
to
we have
object.
listed it on Saturday, alva?
Please, my lords. Page number 13, my lords. There is one, they have to approach the inquiry committee, my lords, which is slated to happen on 22 at 3 p.m., my lords. Joint Commissioner Munda, my lords. They have to appear. My lords.
Saturday, 21st.
Please.
Serial number 56, my lords, there is some urgency.
Interim order may be extended.
All interim orders will be extended.
Much obliged.
The matters which have not reached.
17th March. Madam, ಎಲ್ಲ 17th March ಬರುತ್ತೆ. Remaining month 17th March.
ಮೇಡಮ್ 17th ಮಾರ್ಚ್ ಟೂ ಲಾಂಗ್ ಡೇಟ್ ಆಗ್ಬಿಡುತ್ತೆ ಮೇಡಮ್. ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಯಾವ್ದಾದ್ರು ಕೊಡಿ.
ರೀಚ್ ಆಗಲ್ಲ
ನಂಬರ್
ಸರ್.
16 ಈಗೇನ್ ಒಂದ್ ಬ್ಯಾಟ್ರಿ ಇತ್ತು ಅಷ್ಟೇನೆ, ಒಂದ್ ಬ್ಯಾಟ್ರಿ ಇತ್ತು ಅಷ್ಟೇ ಮೇಡಮ್.
ಎಲ್ಲ ದಿನ 100 ಮ್ಯಾಟರ್ಸ್ ಇದೆ ಸರ್, ರೀಚ್ ಆಗಲ್ಲ.
ಅಲ್ಲ 16th ಮಾರ್ಚ್ 16th ಸೀರಿಯಲ್ ನಂಬರ್ ಫಸ್ಟ್ ಲಿಸ್ಟ್ ನಲ್ಲಿ ಇನ್ನೊಂದು ಒಂದ್ ಬ್ಯಾಟ್ರಿ ಇತ್ತು ಅಷ್ಟೇನೆ.
ಇಲ್ಲ
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಥವಾ ವೀಕ್ ಆಫ್ಟರ್ ನೆಕ್ಸ್ಟ್ ಯಾವ್ದೋ ಒಂದು ಡೇಟ್ ಕೊಡಿ ಮೇಡಮ್.
ಎಲ್ಲ 17th March ಬರುತ್ತೆ ಸರ್.
ಅಲ್ಲ 17th ಮಾರ್ಚ್ ಟೂ ಲೇಟ್ ಆಯ್ತು. ಫಸ್ಟ್ ವೀಕ್ ಆದ್ರೂ ಕೊಡಿ ಹೋಗ್ಲಿ.